Hello. Where's my chat? There's my chat. Hello, third teachers. Good morning. Good morning. Hello. I didn't realize this is how I look this morning. That's okay. It's okay. We're here. We're going to get through it. Hello. I'm a little late. And I will tell you why. Why is this not working? I'm having issues with Lucy Cam this morning. Something's going on with Lucy Cam. I can hear myself, and that's weird. Speaker. There we go. Camera. Can't be without Lucy Cam. USB 2. OBS virtual. Nope. Interesting. Okay, we're gonna have to work on Lucy Cam. I don't know what's going on with Lucy Cam. I get one thing fixed and 10 things go wrong, but that's okay. Because you know what? It is Friday Eve and it's going to be a good day. I'm happy y'all are here. So let me go ahead and let's just get this out of the way. The things I've failed at this morning. I did not do the first in chat because I was working on something else. So I did not do the graphic, but I do know who was first in the tailgate. So we have Jill C was first. So Jill C, what's the first one in the tailgate? There's a dun, 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 dun. I'll just act it out for you since I didn't do it. Dun, 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 dun. And then there's like, what is the first one? Is it a rocking chair? No, rocking chair is the second one. What's the first one? I don't remember what the first one is. Second one's a rocket chair. Third one's a beanbag. First one is something. So here's your imaginary throne for the first one, whatever it is. Jill C. Everybody, round of applause for Jill C. Jill C was first at the tailgate, getting the party going. Here's your throne. And our second was our official statistician, Marie Moss. Here, I'll act her out too. Dun, da, 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 da. I don't remember what the song is. Dun, da, 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 da. That's not the song, but we're going to make it up. Marie Moss, statistician, and you get the rocket chair. Here, we'll rock with you. Rocking with Marie Moss, our official statistician. Got to get her a comfortable chair because she keeps our stats. But careful with those sharpened pencils in your rocking chair, Marie Moss. We love you. Our third was Emin Twin Mom, and you get a comfy beanbag. I have a comfy beanbag. What do they call them, like a Big Bubba or something? Maybe I just made that up. Maybe that's not what they're called. I think that's what they're called. Or maybe that's just what I call it because, I don't know why. There's no explanation. So here's your song. Dun, 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 dun. And then you fall back in the beanbag. I think there's like some feet flailing about, right? And they're like feet in the thing. I think there is. I think there's feet. And they're feet. It's like little tennis shoes or something flailing about. So that one is for you. And there you go. So even though I failed miserably at creating the first in tailgate graphic, I acted it out for you. And Lucy's over there scratching at her bowl. She's like, excuse me, I want more breakfast. So what is our queen on? Our queen, it's sleep deprivation is what this is called. But that's, it's okay. So we're just gonna roll with it. Also, who's got anniversaries with us today? We had so many yesterday, and it made me think of something. Who has anniversaries with us today? Give them to me. Bring them to me. Bring me the anniversaries. Bring me the anniversaries. Somebody has to have one. Yay, Marie Moss member for 3 months. Oops. Hold on. Did y'all hear that? Or do I have to do it again now? Hold on. And there's another one. Yes, you're welcome. If y'all don't recognize the poetic sound and the soothing voices of R&B superstars, Tony, that was Tony. And every time we talk about anniversaries, oh, look. You know, people sometimes are like, my friends are like, are you as weird on your show as you are like in real life? And I'm like, I toned it down some. They would be really disappointed to see today. But that's okay. Let me give this child some more food. You are so needy. I'm in the middle of something over here. You know, you gotta learn to wait your turn. I've already fed you once. Like, this, I'm trying to talk to our friends. Gosh, needy little thing. Okay. So, Kathy B, yours was. See? It's so much fun. And then I've still got the.
What? Did we just become best friends? Yep.
Yes. I've still got that one for all of our new members because that is, you know, you can't get rid of that one. That's like one of my favorites. Oh, and okay. This is a safe zone, right? We don't judge each other. Like this is a safe zone. I used to love the show Jersey Shore. It was a train wreck. I have always been on two very like the shows that I watch are on two very different spectrums. I'm either like hardcore, you know, like true crime documentaries and you know, history documentaries and stuff like that, like, or mindless dribble, like reality like Jersey Shore and Love Island and those things that just can help my mind just not have to process information anymore. And so no judgment here. GTL, see, I knew y'all are my people. GTL. And so there's so many times when people say things and I'm like, oh yes, my mom, oh my God, my mom is a 90 Day Fiance fanatic. Vanderpump, that's another one. Love me some Vanderpump. Like Team Ariana all the way. I have to have the mindless like that, just the other people's ridiculous drama, so that because otherwise, like if I keep like I can't watch that stuff at night because my mind will keep working. So like yes, Buffy Bot, yes, same girl, same true crime and trash TV. Those are my jams, and I'm like, I don't watch a whole lot of in between. There's like every once in a while there's a show like Suits and stuff like that. You know, like every once in a while there's a show kind of in the middle of that spectrum that I really enjoy. But for the most part, like, and my son always makes fun of me for that. He's like, you're either watching like, you know, like PBS documentaries or like trashy reality TV that anybody would be embarrassed to, you know, for you if they walked in on you. But those are my two spectrums and I love it. And oh my God, I can binge watch me some Love Island. I feel like, okay, for all of our people across the pond here, I feel like I am pretty much one of y'all because I have binge watched enough seasons of Love Island UK that I feel like I know what it means to crack on. Okay. I know what a toasty is. There are other things that they say that I probably shouldn't say on mine. But there are like, I'm pretty much one of y'all now too. So don't let this Southern twang fool you. I could pass for a Brit, Anna A. I could pass for a Brit. Give me a toasty and let's crack on. I could pass for a Brit. Yes, ma'am. So having said that, I do like have that love for trashy reality TV. And there's so many times when things are said in court or whatever, I'm like, well, that's awkward. So listen what I got. Awkward. Do y'all remember that? Jersey Shore, DJ Pauly D. I could do hold on. Let me get in character. I gotta get in my Brit character. Normally I don't do this before 9 a.m., but all right, are we ready? Give me something to say. I'm now British. Give me something to say. But do you eat beans and toast? According to Shireen, it's wonderful. Bam! Nailed it. I could pass as one of y'all. Prank war champion. See? I should take my medicine, shouldn't I? This has gone off the rails already. It's all right. This is, it's fine. Everything's fine. So I've got my exciting new sound effects, and there are a couple more that I wanted to put on there that I haven't had a chance to do yet, but we're going to get there. I'm really excited. Hold on. Good morning, Jen. Right? Just call me Lisa Vanderpump. Oh, totally nailed it. I got this. So here's our plan for today. This is going off the rails. I do need we are family. Yes. Brandy without medicine is fine. Oh my God. Oh yeah. We're fine. Everything's fine. I am I'll just do a different accent every day. And then we'll see how it goes. We'll see how long I make it. If I can make it to lunch every day with my fancy new accent every day. We were trying that during that one stream. We were trying to get some people were trying to help me with my accents, and I won't say that people thought I didn't do a good job, but I will say that people were not super impressed with my accents. So, you get what you get and you don't pitch fit. We try. All right. So we have a lot going on today. I want to do the, we have the, there's a status hearing that's starting in just a couple minutes that I want to watch. And I didn't put it on the thing because it's not supposed to be very long, and we're going to go straight into the, let me see if I can pull it up. We're going to go straight into the 2 hours from yesterday that we missed of, oh, this is the wrong one. We'll have to come, we'll come back to that. The 2 hours that they released from yesterday of the, here it is. Sex therapist murder trial, but also there's this hearing this morning for Murdaugh. So we're going to watch this first, and then, cause it shouldn't be long. Oops. Let me hit play. That would probably help. There's our favorites. Hit play. Gotta love them. Let me pop out this chat. Get our stuff going. All right. So we're going to watch this first. It shouldn't be too long. Hopefully. And then as soon as this is over, we will go straight into nope. Oops. It's just a moving me. All right. Update that. Let me turn that down. Okay. All right. So we're going to watch this for just a few minutes first and hope that they don't just annoy the crap out of us today. Oops. I'm having all kinds of problems. There we go. And then we're going to go straight from this into the 2 hours yesterday from the sex therapist trial. And then we will go into day 2 of our trial that we started yesterday. So that way we can fit all of it in. Because we're going to be skipping breaks and stuff like that, so we can fit all of it in, so we can get all the most information without having to add extra hours to our watch time. That's our plan. Yeah, this is where we need Dr. G, but he did say lawyers are hard to read because they are such good actors. If y'all missed Dr. G, the interview yesterday, it was so good. It was so, he is just, I just think he's the best thing in the whole entire world. Good afternoon from Wales. All right, are you ready? Because I've got my Wales accent ready. We were practicing. Hello, Poppet. Did I nail it? Lisa, did I nail it? I think I nailed it. Let me do... I love that song. And it makes me such a happy camper. Let me turn them down for a minute. It makes me such a happy camper that that I get to use that. I love it. I love it. Happy anniversary, Kelly. I love that. We'll do it one more time just for fun. Listen to Tony. Is he just is they just the best? Oh, gracious alive. Let's see. Still dark here in California, waiting for daylight to walk. Yeah. What time is it there? It's like, what, 6 there? Dr. G did, hey, Brooklyn. Dr. G did a great job on his last few videos. Very informative info about Jody and Ruby. Oh, yes, the new one about Ruby. The one that he told us on the interview last night that he was going to put out when he was done. He released it. It's really good. It's really good. It's so good. Oh, gracious alive. Let's see. Ladies Music Man is here. Look at Creighton. Creighton's like, I'm ready. Let's get this. I don't see her. Good morning. Good morning. Well, here comes Share with the Cherry. He's like, Ready. Yes, this is a live feed. This shouldn't take too long, so rather than doing a separate stream for this, we're just doing it here. We got a lot of ground to cover today. Do you know what? Now that song's gonna be in my head all day, every day, all day, every day. Good morning. Good morning. The awkward is from Jersey Shore. So Pauly D used to say it, and I used to love that show. We're on a field trip. We're court hopping today. We're going from South Carolina to Hollywood, and then to, what's your other one? Why can't I think? Do you know? Someone, let me tell y'all why I shut down my DMs. Someone sent me things saying that I have a responsibility to. Oh yes, it's I think Eastern Massachusetts. That's right. For some reason, details escape me. I couldn't remember. Somebody told me that that I have a responsibility when I'm reporting on Murdaugh to not put my personal opinions on it. Which, if y'all know anything about like how I got my start during Murdaugh, and I am very opinionated. So it would be fake of me to all of a sudden, now that I have this platform, to pretend like I didn't have those opinions and that I don't have those opinions. So I'm not going to hold back, and I'm not going to water myself down. Look what we have. Her baby's mom, happy anniversary. We are so glad you're here. We're so glad you're here. So glad to have you. Morning, Ricky Watson. Yeah, it's not bias when you have come to a conclusion based on evidence. That's not what bias means. So I agree with you, Amber C. But like I've said all along, look, if Becky's guilty of doing what they're saying she did, 100% he deserves a new trial. He also deserves a whole lot of other things, but we won't get into that. Do you? The sound effects are very low. Oh, we can fix that. Let's see. Let's see here. Are all of them low or just the... See, it's our anniversary. Profile my soundboard. Awkward. Okay, is this better? Is that better? Okay. What about this one? Is this better? Or does that one still need to come up? You know, it also makes it hard because the audio from different courts are like some courts audio are great and some courts audio are awful. So then I'm having to like do all this stuff over here to try to like boost their audio. And then it makes my stuff sound okay. So that one still needs to come up a little bit. We can do that. We can do that. Do you know profile? My soundboard. My soundboard. Anniversary too. Okay. Isn't that ironic, Brooklyn? Yes. No, he is a terrible, terrible. Let me say this about that. He ain't got no business telling anybody how to act. And I'm sorry, but being a lawyer doesn't make you any more capable of looking at evidence and coming to a decision than anybody else, because it ain't 12 lawyers up there making the decision, y'all. Just throwing that out there. Oh, he needs to somebody needs to take his internet password away. MJ Lynn. It's our special day, MJ Lynn. Member for 3 months. Happy anniversary. We are so glad you are here. So glad you are here. Oh, there's old Jimmy boy. It's old Jimmy boy. Old Jim. I'm going to see them at CrimeCon too. Good morning, y'all. Do y'all know that it was his birthday yesterday and he didn't tell us? He tried to sneak by, trying to be sneaky like 80s Music Man. I love the anniversaries. I could have totally been in a Tony video. Happy anniversary, Julie McBride. Oh, and Amanda Brown. Happy anniversary. Happy anniversary. Yeah, Brooklyn, he's gross is what he is. He's disgusting. He's gross. People who are that rude to people I've never even interacted with him. I have never had an interaction with him. Didn't even know who he was. Never heard of the guy. That's not true. Actually, once I looked him up, then I remembered I had heard of him because I'd heard people saying how nasty he is, and they were right. Like, imagine how miserable you have to be in your own heart to go around saying hateful things to people who don't even know who you are. Sit down, sir. I will not be quiet. Everybody needs to know it's your birthday. You can't sneak by with that again. Can't sneak by with that. I'll say it again. It's his birthday yesterday. See? Now everybody knows. Now everybody knows. Good morning. Good morning. We're talking about one of my Twitter trolls who goes around hating on women. I don't know how he has followers. Happy anniversary, P. Cooper. 2 whole months. Time flies. Time flies. And you live here now. This is where you live. This is your life now. This is where you belong. Yeah, it's funny because I didn't respond to him because, I mean, who is he? He's not important. And like, I don't go back and forth, you know, a lot with people who, like, if I don't have any respect for them, there's no point in me. Like, if I respect somebody and their opinion, then I'll debate back and forth because that's how you learn. Like, you learn other people's perspectives. But I don't respect him. He has no significance in the world. So I didn't respond to him. I just saw him. I was like, oh, bless his heart, you know, and I just kept it moving. So he kept on and kept on and kept on. And I guess he got mad that I wasn't responding. He called me a hoe. He said I was 55 and childless and husbandless. And what else did he say? Something. I can't remember. It was bless his heart. Hello, Jackie. The agenda for today. So we are watching the Murdaugh stuff. There's a hearing this morning. So we're watching this, and then we have a busy day today. So I hope y'all packed your little brown sack lunches because we have a lot to handle today. We have this Murdaugh hearing, and then this isn't expected to take long. Then we have the 2 hours of the sex therapist murder trial that they finally released it yesterday after forever. So we have that. And then after that, we're going to go into the day 2 of the fourth trial of the strangled wife. So we have a lot to do today. A lot to do today. Yeah, 50. Oh, maybe it was 59. I thought he said 55. I can't remember. He's so hateful. Yeah, he's so hateful to women. It's gross. Bless his heart. Yeah, when I learned how to use mute, I will mute people who I think are just annoying and argumentative. When they cross lines of being disrespectful, then I'll block them because I don't want them putting disrespectful stuff on my stuff so that my people, you know, who are interacting on my stuff start to engage with them. But if they're just annoying and not disrespectful, I'll mute them. Fur Baby's mom. Thank you for the super sticker. Thank you, thank you, thank you. Thank you, thank you, thank you. I appreciate it. I appreciate the support. It's our I think a lot of people did after some of the. He caused a lot of ruckus with some of the terrible things he was saying. So I think a lot of people were pretty angry. Oh, how many for 10K? Let's. Whoa.
Are there any additional media requests that Judge Newman has yet to sign? If so, please come forward.
490 more. 491 more to get. 491 until 10K. That's crazy. So cool though, huh? Let's go. We got traveling to do. We're needed in Hollywood, then in Boston. Well, not Boston. It's Massachusetts. I got corrected yesterday. The lawyers from Boston. I kept saying Boston because the podcast I'm doing is Boston area. Oh, Jen, you adopted another dog, Golden Doodle, Great Dane, training and neutering. Been busy. Aw. Is it a boy or a girl, and what's its name? You got to welcome to the family. Welcome our new little pup to the family. Another Furger. Yay! It's a boy named Benji. Oh. Oh. Welcome to the family, Benji. Yeah, Lucy's got a new friend. How cute is that? I had a Great Dane named Oliver when I was in college. And Oliver, I'm 5'9". Like, I'm a tall girl. And Oliver, if I would do like this, and he would jump up and put his paws right here, and he was as tall as I was. It's a big old boy. He used to like eat my shoes, and he would like swallow socks whole and stuff. It was crazy. Oh yeah, there you go. It's Northampton, Massachusetts. I said Boston, and I was corrected, so I'm trying not to. The lawyer that we recognized from Netflix and stuff was from Boston, and then the podcast I'm working on is in Canada, which is there's like a lot of Boston police officers that's in the Boston area. So I said Boston, and I was wrong. You thought I was short? Like 5'1"? I haven't been 5'1" since like 4th grade. My dad was 6'8". My dad was 6'8". My brother's like 6. My brother and my son are both like 6'4". My son is 6'4". Yeah, and my dad was 6'8". Try dating in high school when your dad is 6'8" and has a huge gun collection, and everybody in town knows him. Y'all all thought I was really short? That's so funny. All of y'all thought I was. Why do I look like it's the camera angle, isn't it? Does this camera make me look short? Look like I'm 5'6". That's closer. That's so funny. I had no idea. Everybody just assumed I'm short. I need a standing desk. I had one at my old office that would like lift up so I could stand. I am 5'9". Gnomes made you think that. Did y'all see my Halloween gnomes that JT sent me? How cute are they? The one that's in this one, I got this one as a Halloween gnome last year, but then I just thought, like, okay, he's got, a skull hat, but people wear skulls year round, so I kept him up because I thought he was cute. But these are like actual Halloween ones. Like there's for anybody who hadn't seen them, look how cute that is. And the witch, and then the Dracula one with his little cape. Like that. Super cute. All my little gnomies. Brandy is 6'8". Yeah. My dad was 6'8". Hello to those of y'all still joining us. Lisa Lamont is 6'3".
The lie detector determined that was a lie.
I have some Christmas gnomes, and I will bust those out once Thanksgiving is over. Good morning. Oh, I have fall gnomes that are holding a turkey and a pumpkin. I love them. Gnomies, not thommies. Yes. Okay, 5'3". I was going to say, you got the lie detector.
The lie detector determined that was a lie.
You got the lie detector sound effect because I was like, there's no way she's 6'3". But okay, typo will accept. That says, honestly, I think being tall is a burden. You can't be sneaky. You stand out like a sore thumb and can't fit in most places. Yeah, you know what's hard for me? Because I have really long legs. So it was always hard because like we had in high school, we had, nowadays they let these little girls just wear whatever they want to. In my day, that was not allowed. We had dress codes, and you had to have like your shorts had to be like I think to like your middle finger or whatever. So my legs are really long, or I think it was like an inch past your middle finger or something like that. So my legs are really long. So it would always look like shorts were shorter on me than they really were because there's like a lot of real estate, like when you got long legs. So I used to get in trouble all the time. And then finding like prom dresses and jeans, especially jeans, finding stuff that's like that you can have long enough, because you can always have stuff hemmed, but you can't just add extra length to everything. And it's always been really hard for me to find anything that's long enough. And then it's like when I do find stuff that's long enough, I buy it in like every color. It's our anniversary. That song's in my head now. What's the date today? 9/14. Let's do this. Oh, and I've had a few people asking me. Oh, are the sound effects still low? I guess maybe I have to change them all. Maybe, let's see. Let's see here.
The lie detector determined that was a lie.
Is profile my soundboard. That was okay. Is this
The
better?
lie detector determined that was a lie.
I had them turned down really low because they were too high at one point. But also, depending on what people listen on. Still low. Okay, let's see.
The lie detector determined that was a lie.
My soundboard. Okay, we got
The
this.
lie detector determined that was a lie.
I don't want to like blow out your eardrums. But see, it's hard for me to hear what y'all hear, and everybody hears it different. Like, no matter how much I have stuff on, like, no matter how much I work on stuff, some people will be like, oh, yes, that's perfect. And then there will be some people who still say it's too loud, or some people that say it's too soft. So we do what we can. It's still low. Let's see.
The lie detector determined that was a lie.
Is that better? Without blowing out eardrums? You can please some people some of the time. Universal approval is not a possibility. Yeah, I think a big part of it is the headphones too. See, even yesterday, let's see. That was a lie. There we go. Yesterday, the audio for that one trial was so bad. It was so bad. So I had it all the way up and it boosted. I had my microphone pushed like this on my boom. I had it all the way pushed like all the way away from me. And some people said it was still good, but some people said that my stuff was still so loud, and I had it turned down and I had theirs turned up. It's just, that's the thing that is the hard part about streaming live court stuff. You are just really at their mercy on their audio. All right, let me see. Oh, Lucy. Let's see if we can get Lucy Cam up. I don't know why it wasn't working earlier. Good morning, Virginia. We are waiting on court to start. Mute. Oh, I did not turn on beach cam. I can go do that though. Did y'all see my video? For any of you who follow me on Twitter, I posted a video this morning of the dolphins jumping. I was watching them out the window while I was drinking my coffee. Not jumping. They were just, but you know how they come up. Let's see. Oh, no. Not that one. Enter. Do you know what today is? Oh, I just started messing with her stuff and then she moved. But she'll come back. How much of this trial have we missed? It seems like days ago. So we haven't actually missed anything. They didn't go back to, well, yesterday, but yesterday's, like, the stream is only a 2-hour stream. So the defense attorney had COVID. So they postponed court for a week because of COVID. So, and then when they came back, the witness who was on the stand is now also sick. So, they've had all kinds of problems. But so they released the video from yesterday, which I have like up and ready for us to watch as soon as this is over. And then when that's done, we're going to jump into day 2 of the other. With them not releasing this stuff yesterday and then it delaying so much, I didn't want to, and the streams are so short when they do release them, because I don't know what's going on with this stream, but we're not, like, it's very short stuff. So and that worked out great for me while I was, getting a lot of research done and stuff like that for the podcast. But at the same time, I really wanted to get back on a regular schedule with our streaming stuff too. So we started that 4th trial looked so interesting. So we started that way we can work around the Hollywood trial. Well, I thought it was supposed to start like 45 minutes ago, but yet here we are. Here we are, just a-waiting. Just a-waiting. Yeah, I'm loving the 4th trial too. I like, y'all know there's a Dateline episode on the fourth trial thing, from 2017, I think. And somebody had asked me if I'm going to do the podcast recaps on that one. I am not planning on it as of right this moment, because I'm already getting very little sleep as it is. And I've started the podcast like the recaps on the sex therapist murder trial. So, I'll keep those going. And of course, the new podcast, that one takes so much time and work and research and all that. So that on top of this is, so as of right now, I'm not planning on doing the podcast recaps on the 4th trial, but maybe when the sex therapist murder trial ends, I'll do that. We'll see. Yeah, that might be why it sounds familiar, because it was on a Dateline episode from a few years ago. I mean, this is probably maybe 2018-ish. maybe when it came out, sometime in that general vicinity. It was before I got sick. So, and I know Dateline, they have those episodes on like Peacock and stuff. I don't know if it's still on there. I know some of them they don't show though, which is weird. You'll have a ton of the episodes. There's like 36 in a season, and then there will be missing like 3 or 4. And it's always the 3 or 4 that you want to actually watch. Blah. Blah. Do you know what today is? See, now I got the anniversary song stuck in my head. But what a great song. If you're going to have a song stuck in your head, that's a good one to have. There we go. This is, if you want, I mean, this is the, this is the financial stuff. If y'all want to go straight into the sex therapist stuff, we can. I don't know how much longer they're going to be. I thought they would have started. This is financial stuff. Here, we'll do a poll. Choose your own adventure. All right, we're going to do a poll. I'll give y'all a minute to answer because this is y'all's show. I just happen to be here. Yeah. Murdaugh Financial Crimes Group, South Carolina versus Alex Murdaugh, Russel Lafayette, and Cory Fleming. It's our anniversary. Do picture in picture for a minute, and then I'm going to get. It's our anniversary. Next, library. It's our anniversary. Okay, so all right, so everybody says let's go ahead and start sex therapist, and then we'll pause when this one. What happened? Pause when this one starts. So I'll keep this kind of in the bottom over here. All right, I'm going to mute them momentarily. And we'll just, y'all voted, the people have spoken. So we are going to, all right, I'm going to skip through the first few minutes of this because basically all that happens is they have a sick juror and who's replaced by an alternate. So that's what we've missed so far on this one. All right, so we'll watch this until Murdaugh starts.
What's your first and last name?
My name is Sarah Rollins, spelled SARAHROLLINS.
All right. If any of you have a problem hearing her, raise your hand. I just asked if you do have a problem. Can you just lean into the microphone when you speak? Okay, do you have a soft voice?
Is that better?
Yes, that's better. Thank you, ma'am. Appreciate it.
May I inquire?
Yes, please.
Hi, Ms. Rollins.
Good morning.
Do you know Amie Harwick?
I do.
And how long have you known her?
If she were alive now, it would be 13 years.
Aw.
And how did you two meet?
We met working at an event.
And as a doing what?
We were serving ice cream sandwiches.
Now, were you two close in your almost 10-year relationship, I would say?
Yes.
Did you celebrate special occasions together?
Yes.
Birthdays, things like that?
She's
Yes.
really pretty.
Did you ever travel together?
Yes.
How often would you say you saw each other over the course of your friendship?
Mostly monthly,
Okay.
if I had to guess.
What about in the year leading up to her passing? How often
love
would
you,
you say you
Tosh.
saw each other that year?
Mostly monthly until that month, definitely.
Despite seeing each other monthly, would you say you communicated pretty regularly?
Yes.
Was that through phone calls or text messages?
Yes.
In the time that you've known Amie, did you ever see her smoke any tobacco products,
No.
ingest any sort of nicotine products like vaping?
No.
Now, I want to turn your attention to February
Oh,
10th
she's struggling.
of 2020. Did you see Amie that day?
Yes.
And where did you guys see each other?
We went to her home and we went on a walk or hike around her home, and then we went to dinner nearby.
Now, did you go to dinner or do a walk first?
We first did the walk.
Now, what did you do on this walk?
We caught up, just like friends would, talked about things that were going on in our lives.
How long would you say that walk lasted prior to going to dinner together?
Probably 2 hours at least.
And how long was dinner?
It seemed to be long.
Now, during your time together on February 10th, did you and Amie speak about something called the Ex-Biz Awards?
Yes.
Had you not talked about the Ex-Biz Awards prior to your meeting on February 10th?
She had mentioned that she had ran in to her ex at that award show, but it had occurred, right before.
Now, did she talk to you about the X-Biz Awards during your walk?
That's the one.
I don't recall it so much during the walk as I do during dinner.
So during dinner, you guys talked about the X-Biz Awards?
Yes.
What did she talk about took place at the X-Biz Awards?
She told me how she had ran into her ex, a very old ex of hers, and that he kind of went a little crazy and was triggered when he saw her and got into fetal position on the ground and was crying and reciting texts that they had had from a long time before.
When she was talking to you about this interaction with an ex-boyfriend, she indicated to you that he was crying?
Yes.
You used the word he'd gone crazy. Did she say those words to you?
I don't recall her exact wording of it at this moment.
But it was something to that effect?
That's what was expressed to me.
She talked to you about him getting into, did you say a fetal position?
Yes.
Did she at any point talk to you about the tone of his voice when she had her interaction with him?
I don't know about the tone of his voice, except for that when she was expressing it to me, it seemed just kind of chaotic. That's just how I imagined it.
What was her demeanor like when she was talking to you about this interaction with her ex at the X-Biz Awards?
I'm sorry, could you repeat the question?
Sure. What was Amy's demeanor when she was talking to you about her interaction with her ex-boyfriend at the X-Biz Awards?
She's very articulate, very well-spoken, very intelligent, and obviously she has a lot of knowledge in the mental health world.
But did she appear upset?
She seemed very stressed by it to me.
Did she express to you how that interaction with her ex-boyfriend at that award show made her feel?
She was scared. I know she was scared.
And how do you know that she was scared?
She'd spoken about things that he had previously done to her.
And without going into specifics, Mr. Alco, I'm sorry, Your Honor.
Sorry. Go ahead.
Now, without going into specifics about the past, did she express to you why she was, or how she was scared?
She was scared of what he might do to her, to harm her, or even her clients.
Well, clear that up first of all before I rule on it.
I'm sorry?
Clear that up first of all before I rule on it. I mean,
Sure.
is that something she told you or? But
Sure. Did Amie tell you that she was scared?
Yes.
You said something to the effect of she was afraid that he would harm her or her clients. Did she express that to you specifically?
Yes.
Now, when she told you that she feared harm to herself, did she indicate that she was scared of her personal safety? In light of the 402 ruling, Your Honor, I was
trying to pinpoint.
correct.
All right. Why don't you try to re-ask it?
Sure. Did she indicate any sort of concern about her personal safety?
Yes.
You see,
And did she talk about any sort of measures she may take as a result of her fear for her personal safety?
I don't recall any measures that she said she would take at that point, but she did tell me about previous measures that she had tried to take.
Now, did you see each other again after having dinner and going on that walk on February 10th?
Yes.
And when did you see each other again?
Shortly after, on Valentine's Day.
Did you have plans with Amie?
Yes, she arranged plans for us to celebrate a Galentine's that evening.
And what did you guys decide to do?
We went to a burlesque show hosted and produced by one of her friends.
Where was that burlesque show?
That was at the Globe Theater in Los Angeles.
And do you know about what time you arrived at the Globe Theater?
I can't recall off of the top of my head right now.
Would 8 p.m. sound about right?
Yes.
And who else did you meet with at the Globe Theater?
It was Amie and her friend Rebecca.
Had you met Rebecca prior to that day?
That was my first time meeting her.
Were they already there when you arrived?
Yes,
Did you take any pictures while you were at the Globe Theater?
we did.
going to show you a photograph that was previously marked.
He doesn't move from that position.
As People's 12A. Do you recognize this photograph, Charles?
Yes.
Could you please identify who's in the photograph?
Amy's on the left in the light pink dress and the leather jacket. I'm sorry.
It's okay, take your time.
I feel bad for her.
I know her as Miss Posh, to the right of Amie, who is a producer for the event. And that's me with dark hair. And then to the right of me is Rebecca, who I had met that night.
And so the record reflects you were identifying individuals from the photograph as I was pointing to them with my finger, is that correct?
Yes.
And this is a photograph that you had taken at the Globe Theater when you met with Amie and company.
Yes, that's a photo that we took together.
Now, did you guys have any plans about your outfits for the evening?
We didn't discuss anything, but it was Valentine's Day. So
Now, do you recall any accessories that Amie was wearing that evening?
it looks like she has maybe 2 rosaries on.
I'm zooming into the photograph of 12A and it's pointing to some necklaces that Amie is wearing. Are those necklaces that you recall her wearing on that day, those 2 rosaries?
I didn't notice them that evening, but I can see that she's wearing them.
Now, do you recall about what time you left the Globe Theater after the burlesque show?
I don't recall at this exact moment.
9:15-ish sound about right?
Yes,
Did you go anywhere else after the burlesque show?
we did.
And where did you guys go?
We went to Rebecca's place of work nearby, and then we also went to the Nomad Hotel to have dinner, or appetizers, I guess.
And while you were at the Nomad, did you take any photos there?
We did.
Now, at this time, Your Honor, the people are holding a photograph depicting Amie Harwick and the witness date Avenue Marcus Peoples 52.
Like he doesn't. Y'all see that? Like he doesn't. He like sits there and stares down the whole time.
As Peoples 52. Do you recognize that photograph?
I do.
Can you identify who's in the photograph?
Amie on the left, and myself on the right.
And this is a photograph that you took with Amie while at the Nomad that evening?
We took it together, yes.
Now, following your appetizers and hanging out at the Nomad, do you know about what time you left?
I'm sorry, I don't recall the exact time right now.
Now, do you know about, let's say, around midnight? Does that sound about right?
I think so.
Do you know where you went after the Nomad?
I went to my cousin's house in Echo Park. That's where I had left my car, and then I had Ubered to the Globe, so I went to go pick up my car from my cousin's house.
So from the Nomad Theater, you took an Uber to Echo Park,
Yes.
where your car was parked,
Yes.
and then you drove home.
Yes.
About how long would you say it took you to get from Echo Park to your house?
I don't recall right now. Probably 35 to 45 minutes.
Okay.
But once I was driving in my car.
Did you and Amie communicate in any way after you parted ways at the Nomad?
No.
Did you receive any communication from her that evening?
Yeah, I checked my phone and I had one text message from Amie. That was once I got home, so 45 minutes later when it was received or so.
This I'm holding 2 pages of text messages made out be marked collectively as people 53A and B.
Yes.
I'm showing you what's been marked as 53A. You recognize these series of text messages?
I do.
And how do you recognize these text messages?
The blue ones, or all of the ones with the timestamp, are coming from my phone. I'm texting Amie. I have 80 unread texts, and she sent me a message at 1:02 a.m. asking or telling me, send me the pics on the green couch.
So let me just break it down a little bit here.
Mhm.
You talked about a text message in blue that I'm pointing to with my pen. Is that a text message that you sent to Amie?
Yes,
Now, there are text messages that have white writing with no kind of a blackish background. Are those text messages from Amie to you?
yes,
I'm pointing to one text message where it says, send me the pics on the green couch. Marked at 1:02 a.m. Is that a text message that you received on February 15th after your Valentine's Day gathering at the Nomad from Amie?
yes,
And I'm pointing to a photograph that we looked at earlier. Is this your response to Amie?
yes.
And what time did you respond to her text message?
I started sending her photos at 2:05 a.m.
Now I'm showing you what's been marked as People's 53B, which appears to be just a zoomed in version of those text messages. Is that correct?
Yes,
So again, you receive a text message from Amie at 1:02 and you respond with a photograph at 2:05.
yes.
When was the last time you spoke to Amie?
Verbally,
Yes. Or in any way, in any form.
oh, it seems like at 1:02 a.m. was the last time she contacted me.
So is this the last communication that you received from Amie? Was at 1:02 a.m. on February 15th?
Yes,
Thank you, nothing further.
Cross-examination.
Good morning, Ms. Rollins.
good morning.
Detectives interviewed you on February 16th, 2020. Do you remember that?
Yes,
And Robert Kochland was present with you during the interview.
he was.
And during that interview, both you and Mr. Kochland asked the detectives whether they had gotten the security camera footage from Ms. Harwick's house. You remember that?
I think so.
And Mr. Kochland specifically said to do it fast.
I don't remember that part.
Okay, it looks like Judge Newman's coming in. We're going to pause it for just a minute.
I believe I'm speaking with State Grand Jury Clerk. The first case up for status is the State versus Russel Lafayette. Again, to remind Your Honor, he's been indicted in 2022 GS 4701, venue in Hampton County. This is a State Grand Jury indictment containing 4 white-collar counts. 2022 GS 4702, that's the venue in Hampton County, 3 white-collar counts. And then finally, 2022 GS 4703 venue in Allendale County, which contains 14 white-collar counts, a total of 21 charges with an alleged loss of about $1.8 million. Mr. Lafayette is here, present with his counsel, Mark Moore and Todd Rutherford. And again, I think we're here to status the case and to discuss a trial date.
Not to discuss the trial date, to set a trial date.
And the state, well, it is.
Audio is terrible.
Go forward at whatever date works for all parties. I think the defense has a different position, and so I will let them at this point raise whatever they wish to raise, unless Your Honor has any specific questions.
All right. Mr. Moore?
Morning, Your Honor. How are you?
Fine.
So things have not changed much on the federal side since the last time we spoke. Mr. Lafayette's bond motion is still pending with the Fourth Circuit. The Fourth Circuit has not yet decided. I thought we would have a decision by today.
It's what kind of motion?
It's a motion for an appeal bond. He is scheduled to report on September 21st, unless the Fourth Circuit grants him an appeal bond.
I had a briefing schedule in this case, in the federal case. They briefed it at the end of September. The government crossed appeal, and after the government crossed appeal, the circuit consolidated those cases. I don't have a new briefing schedule, but I'm going to get a briefing schedule in the federal case.
All right, so you're here to talk about the federal case. I'm here to talk about this case, the state case.
Well, Your Honor, I'm just telling you because they have some relationship to each other.
What is the relationship?
The relationship, Your Honor, is that much of the evidence is the same. Okay? Much of the evidence is the same. And as Your Honor knows, and I know that these cases are scheduled separately, but my client is charged in 3 separate cases with Mr. Murdaugh. Okay? They are co-defendants. No motion to sever has been filed. Okay? And so, as I understand it, the state wants to try a case involving Mr. Murdaugh that does not involve my client first. My client has been convicted in federal court, and
We're going to set this case aside and proceed with Mr. Murdaugh's case. Then we'll come back to this case.
so you want to set aside one?
That's what I just said, yes.
Thank you.
That audio is terrible. Oh, I love me some Judge Newman, y'all.
John, we have Mr. Murdaugh.
Yes, sir.
Here he comes. Bring the convict. Orange is not his color.
This is State versus Richard Alexander Murdaugh. Your Honor's aware he's been indicted in a slew of state grand jury charges, and I'm happy to read those numbers into the record. They are extensive. We have 2021 GS 4727 in Orangeburg County, containing a number of white-collar counts. 2021 GS 4728 in Bamberg County. These were indicted in the state grand jury in November of 2021. We have 2021 GS 4729 in Allendale County, also indicted in November 21. 2021 GS 4730 in Beaufort County, also indicted in November 2021. 2021 GS 4731 in Carlton County, also indicted in November of 2021. 2021 GS 4732 in Hampton County, indicted in December 2021. 2021 GS 4733 in Hampton County, also indicted in December 21. 2021 GS 4734 in Hampton County, also indicted in December 21. 2021 GS 4735 in Beaufort County, indicted in December 21. 2021 GS 4736 in Hampton County, also indicted in December 21. 2021 GS 4737 in Hampton County, indicted by the state grand jury in December 21. 2021 GS 4738 in Carlton County, that's indicted in December 2021. 2021 GS 4729 was a superseding in Allendale County in January 2022. 2022 GS 4701 in Hampton County in January 2022. 2022 GS 4702 in Hampton County, that's January 22 was when it was indicted. 2022 GS 4703 in Allendale County in January 22. 2021 GS 4727 superseding in March of 22 in Orangeburg County. 2021 GS 4730 superseding in Beaufort County in March of 2022. 2022 GS 4701 in Hampton County in April. 2022 GS 4702 in Hampton County in April. 2022 GS 4703 is superseding in Allendale County in April of 2022. 2022 GS 4710 in Colleton County in June of 2022. 2022 GS 4723 in Hampton County in August of 2022. 22 GS 4724 in Colleton County in August of 2022. Finally, our last two, 2022 GS 4734 in Hampton in December of 2022, and 2023 GS 4703 in Colleton County indicted in April of 23. Your Honor, the state grand jury indictments that I've just listed against Alex Murdaugh represent 101 total charges for an alleged loss of almost $8.8 million.
101
The
charges.
state is here, as we have discussed, I believe, back in April, requesting a trial date for Mr. Murdaugh. I believe that we look at some of the other co-conspirators that Cory Fleming has pled. They're supposed to get a trial this week. But Mr. Murdaugh remains the state's priority, and I believe the case that is the priority would be the case involving the Satterfield, Your Honor. That by far represents the greatest single loss among all the victims. That would be 2021 GS 4730 being here in Beaufort County. And the state is intent and requesting the court to schedule a trial date as soon as reasonably possible, sometime before the end of this year, to try Alex Murdaugh on those particular charges.
All right, Mr. Harwick. Yes, sir.
Your Honor, there are a number of different objections we have to trying any of these cases this year. We previously got the impression from Your Honor when we met at the last status conference that you would not be trying any of these cases, and you'd be leaving the bench on January 1.
Tell me about that question again.
That was my impression based on your discussion. Now, maybe I misread you. I've done that from time to time during the process. If I did, I apologize. But in the meantime, Mr. Griffin and I have scheduled other matters this fall. Both he and I have a federal trial in December. Before that, Your Honor, and I think I mentioned this the last time we talked, I have the oldest case in Lexington County, civil case, involves the death of 5 children killed by their father who sentenced to death for it. We sued the Department of Social Services 8 years ago, and finally on a trial docket. I've mentioned this is something I mentioned.
It's on a trial docket for when?
Motions on the 14th of October, trial on October, and I have a email here from Judge McCaslin who's trying a trial on motion heard on October 13th, trial roster for October 30th. And it's at least a 2-week or 3-week trial. Mr. Griffin has an additional conflict in Texas in a federal trial, what day? October 30th that week. So I guess this is September. It looks like most of October is going to be involved either getting ready for or trying that case. Wouldn't be done until early in November. And Your Honor, it's going to take some time to get ready for these cases. But more importantly, maybe this is the toughest thing I have to say, and that is this. This case was finished 6 months ago. Clearly, I don't think anyone disputes has had more publicity than any case in the history of this state, and maybe the country. On national television every day for 6 weeks, the motions motions hearings were covered, and they're here again today. It has been podcasted, blogged. We've got podcasters out there who are ripping their 15 minutes, hanging by their fingernails, wanting more of their 15 minutes.
He's such an asshole.
Talk about this. I understand one of the solutions to massive pretrial publicity is a change of venue. There are two cases I want to cite to the court, both of the United States Supreme Court cases. Murdaugh versus Florida, and the cited, I'm sorry, in Shepard versus Maxwell. There are two kinds of pretrial publicity that would indicate a continuance and or a change of venue required. Prejudice is presumed for pretrial publicity when pretrial publicity is sufficiently prejudicial and inflammatory, and the prejudicial pretrial publicity saturates the community where the trials are held. They found presumed pretrial publicity in a case much less renowned, much less publicized than this one. And Your Honor, to try this case in less than a year after the verdict came in the other case, don't we need to let it calm down a little bit? Where are you going to get a jury? Mars? I mean, there's nowhere in this state.
Allendale, Orangeburg, Beaufort, Colleton,
Your Honor, and I
Hampton.
appreciate your sense of humor.
It's not a sense of humor. We have many counties where these indictments were issued. I am not presuming that a jury cannot be impaneled. Just as the trial that took place in Colleton County, there was no motion to change venue. And I'm not presuming any prejudice, and the test is not based on speculation. The test is whether or not a jury can be impaneled. We first have to attempt to get a jury according to the law.
What I'm saying is, I think it'd be an exercise of utility. I know this. We've been interviewing jurors, as you know, in the murder trial. There was a juror who on that jury who had been excused, been on the jury panel within the previous year, and told other jurors, I want on this trial. I want on this trial. And that, I'm afraid, is what happened on that jury. We got a motion for a new trial after discovered evidence. The court, the Attorney General is going to file their response tomorrow. We believe the Court of Appeals will order a hearing before a circuit court judge to determine whether or not the corporate court tampered with that jury. And that is and so we would go forward with another trial while that matter is pending, while that matter is being litigated.
Probably not in Colleton County.
Well, Your Honor, the idea that somehow something happens in Colleton County doesn't affect what happens in Beaufort County. I mean, this is a national case. I mean, do they not have television in Allendale County?
I don't
Do they
know.
not have the internet?
I don't know.
What's the hurry? That's the other point. What is the hurry? He's pleading in federal court next Thursday. Every allegation the state has made, the victims will have their day in court. We plead, Mr. Murdaugh indicated he pleads guilty to the state charge, but the state insists on doing them in serial so they get 3 convictions so they get life without parole. By a guy who's already serving 2 life sentences without parole. This is just another attempt to get more publicity, to make this another national case. And, Your Honor, I'm offended that the Attorney General is waiting. He's got many other cases that are much older than this, but get granted, court TV won't be there for them. This is another effort in creating a national spectacle. Now, Your Honor has some things to say about Mr. Murdaugh at his sentencing. You obviously believe he was guilty of that. You obviously think the jury found him guilty of that. But I would ask you to put those feelings aside and give us a chance to litigate this jury tampering issue. To allow Mr. Griffin and I to have time, if there is going to be a trial on these, to prepare for those trials, which we won't with our calendar for the fall. And third thing is, why doesn't the Attorney General put some distance between the conviction in the murder case and the trial, if there has to be a trial, on the financial cases? I'm, as you know, as a prosecutor, I'm bewildered by this. Certainly they can do it, but why? Why? What is the hurry? Thank you, Court. No. Thank you, Your Honor.
Your Honor, this isn't about a spectacle. These white-collar indictments have been investigated by the state grand jury, which is a partnership with the AG and SLED. And these particular, the Satterfield indictments were indicted in November of 2021, just about 2 months after the side of the road happened. This is about allegations that represent an assault on the state judiciary. And because of that, they need to be answered. Your Honor is exactly correct that the law does not presume prejudice. If he wants to file a motion where he cites law, then we can respond, but the law is very clear. It's that you don't presume prejudice, you try to seat a jury. And only through that process can the court then assess whether or not a jury can be seated. We are in 2023. The reality of the media environment is what it is. And unless we're going to say the judicial system just can't function because of publicity, that just leaves nothing left to happen. This is just the reality that we live in. And so we depend on the ability of the system, we depend on the ability of the jury selection process to seat jurors. And that is what should happen. And only if there's an inability to do so can this court then consider whether or not there needs to be some change of venue or some relief or something like that. That is exactly what the process should be. And this is a big county, this is Beaufort County, and fundamentally, just as we rely on lawyers, just as we rely on judges to be objective about what they do, and that includes the defense motion here. Okay, we have an objective duty. We also depend, the system depends on jurors to be objective as well. And to just say, because there's publicity, nothing can be done, just throws the system out and leaves no recourse whatsoever. And what the defense can't do is try to essentially run down the street to the federal authorities and bypass the accountability that needs to happen in state court for a direct assault through use of a state law license on this courtroom, Your Honor, on the other courtrooms from the other counties that I named. The state judiciary needs, the state judicial system needs to answer for the allegations of this assault. And that's why this is important. That's why this case has priority, and that's why the state seeks to move it forward.
Briefly, Your Honor.
Yes, sir.
Well, this wasn't his argument a year ago when he called the murder case first. The murder case was indicted after the financial crimes, and it wasn't that important then. Now, all of a sudden, it's, the most important thing in the world. I would suggest, Your Honor, that he made a decision to try the murder case first, not the financial crimes. And as a result, we've been put in the position, of where we're at today. In addition to that, I would state for the record, I want this clear, based on that is Mr. Griffin and my trial schedules in other cases between now and the end of the year, we would be ineffective in preparing for this trial, any trial.
Your Honor, that is absolutely not what happened. I even said I was happy to trial the white-collar cases first. It was the defense's motion for a speedy trial and Mr. Harpootlian's waiver of his legislative immunity was what led to the murder cases being done before. It was the defense that wanted to trial the murder case. They filed a motion for speedy trial, and the state said, okay, let's do it.
He had a decision to agree with that, Your Honor. It was up to him. He's calling the case today. The solicitor calls the case, the prosecutor. We don't call the case. It was his decision. He decided to go with the murder case first.
Your Honor, the state is happy to show up in court and seek justice for these very important matters whenever a date can be scheduled. And the only reason the murder went first was because of Mr. Harpootlian.
Spicy.
Well, the court's not going to defer to Texas and setting a trial date.
I love his
And
face.
a trial date will be set prior to the end of this year. You all have a choice of either the week of November 13th, November 27th, And there's an Allendale term scheduled.
Just not October. We're
On
busy.
December 11th. You will have a choice of either of those 3 weeks to try whatever case is pending in those individual venues.
Your Honor, could we confer and email you today on what our preferences are?
No, we can confer and resolve it this morning while we maybe move on to the next matters. We have other matters.
I love me some Judge Newman. He does not let poop push him around.
Your Honor, without waiving my previously made objections, November 27th would allow us to deal with the other trials, although not really give us time to prepare for this, because you've already heard my position on that.
Well, November 27th, let's see.
The Monday after Thanksgiving.
All right, let's see. And we've attempted to coordinate with other existing terms of courts in the various places. All right.
Your Honor, where's the venue on November 27th?
I'm open to whatever venue the predominant number of cases are pending in Hampton County.
And the state's preference would be to do the Satterfields in Beaufort because that is the greatest single loss. But if there are scheduling issues, we will do Hampton. I do believe that it makes the most sense to do that one first just because of the way this case is developed. And so the state would seek to call that one in Beaufort County.
Let's see. November 27th, there is a general sessions terms scheduled here in Beaufort County.
For the 27th?
Yes.
That works for the state, yes, sir. We need to coordinate with the solicitor's office as well. Absolutely.
No, we'll take care of whatever coordination is necessary, unless there's a death penalty case scheduled that week.
Thank you, Your Honor.
All right, so the case is set for trial on November 27th.
That's Saturday, okay, right?
Is that the matter you're seeking, the Satterfield trial?
Yes, sir. Yeah, that would be course developments. 2021 GS 4730.
Maybe more development. You got nothing else, I'm sorry. We're trying to.
Do y'all want to set a deadline for any motions that might be filed?
Yes, sir, I think that's advisable. If I can look at my phone real quick, Your Honor. I would say because of the week prior, obviously, is Thanksgiving, that perhaps the Friday the 10th might be the best day for motions and then responses to the following week. Maybe by Friday the 17th. I think if we have significant pretrial issues, it might even make sense to have a hearing prior to the trial date so that those, if there's resolution of those, we can get the ground running that trial week.
Your Honor, none of this is a big concern. I don't know why we just can't deal with it that morning. I mean, our schedules really are complicated. Can't we have a hearing that morning?
The morning of the trial?
Yes, ma'am. Yes, sir.
Well, a deadline for filing the motions.
I don't have a problem with that. 10 days prior to trial and responses 5 days before trial.
I think, in effect, that's what you proposed.
Yeah, Your Honor, and I apologize, the 10th is Veterans Day. We could have the motions filed on the 17th.
My God knows I don't want to have to work on Veterans Day. Oh, my God.
I just pointed that out, Your Honor.
I know the state government people enjoy these holidays, but we're going to have to rearrange a major personal items to deal with this. I plan to take Thanksgiving and visit my wife overseas. That ain't happening now. I've got to call her when I leave here to tell her. So, perhaps we'll have to work Veterans Day. I'm sorry.
All right.
I would say these people next to me work just as hard as they do, and Your Honor saw that.
We'll be working Veterans Day, so why don't you have this?
That's a deadline. Maybe you'll have it prepared the day before. Veterans Day is on the Friday the 10th, is that it? Well, the deadline will be Thursday the 9th. How about that?
And then responses in 5 days.
And responses in 5 days will determine when and if a hearing is needed prior to the 27th. If you put all of that in order and circulate it to council for any comment, and I'll sign a written order addressing all of what we've just discussed.
Well prepared, Your Honor.
Now, anything else we need to talk about in this case?
Your Honor, I hate to rise.
I said in this case. No, you're not in this case, are you?
Yes, Your Honor, but
Well, we're coming to you next.
I know I'm just charged with him in the other cases.
You're charged with what?
My client is charged jointly with Mr. Murdaugh for 3 other cases that have not been scanned.
Well, he's indicated he's calling the State v. Murdaugh, State v. not Murdaugh, yeah, State v. Murdaugh in the Satterfield case. Unless you want to voluntarily join in.
Your Honor, I do not, you got voluntarily to join anything.
Well,
Your Honor, I apologize for Mr. Moore. He just had to say it.
all right, well, I thank you all very much.
Thank you, Your Honor.
Thank you, Judge.
Mm. 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 All right, so real quick, I'm going to do a poll. If you want to keep watching this, or if you want to go back to the other, and then I can look up to see what other trial dates are set for the other cases involved in this. And then we can just do an update on. I think they're taking a break right now anyway, or they might not even be showing the rest of them. They're all in a, we'll do, we'll keep picture in picture for now so we can kind of keep an eye on it. But if they come back, we'll do it. But I got to show y'all. Y'all know I got a big mouth on me. So I made a graphic while we were waiting. Because why not? So when he said something about the podcasters and their 15 minutes of fame, I had to make a little thing. So Jim Griffin saying, "You mean them, not me, right?" I had to tweet it out. Alrighty, so November 27th, mark your calendars, y'all. This one's the Gloria Satterfield one. This is the one that is you know, his, I hate to call her just the housekeeper, because she was a lot more than just a housekeeper to them. And if you've heard any of the, you know, conversations about anybody talking about her and, you know, her connection to the family and how close she was to them, she's more than just a housekeeper, even though when all of this happened, they tried to distance themselves from her. But this is a big one. Also, can we just point out that, and let me go ahead and prerequisite this with, this part might be my bias. And I'm going to go ahead and tell you that, because everything that Poot does already annoys me. So, and if I wasn't already disgusted by him, then I might not have even been bothered by this. So I'm just going to, full disclosure, I might be bothered by this because I don't like the man. But him saying how inconvenient the trial for him is because he has to, you know, he was going to go see his wife. Okay, that's fine. But nobody's really worried about your inconvenience when these are people who have been waiting for this trial for so long and, you know, have had, like, you know, your client didn't give a flying rat's butt about anybody's, you know, what's convenient for anybody else when he was stealing all their money, did he? No. So sit down. You can see your wife later. But again, like I said, full disclosure, I could just be annoyed because anything he does is probably going to annoy me. All right. So I'm going to do a poll and we're going to start watching this again while they're on break. Do you want to watch the other parts of the hearings for other clients, or have me recap later? Stop this and watch. All right, ready? Here we go.
You testified on direct that you and Ms. Harwick went on a at least 2-hour walk on February 10th, 2020.
Yes.
Was that like just a walk around the neighborhood near her house or on Beechwood Canyon?
It was around a lake that was by her house. I don't remember what it's called, but I have photos from that as well.
The Hollywood Reservoir, right?
I believe so.
It has like a dam on one side, and you can see the Hollywood sign in the hills.
I believe so.
So Ms. Harwick was an athletic person, right?
She was physically fit.
She went on runs.
I don't know what her routine was.
She had a background in dance.
Yes.
And, you know, like you said, she was physically fit. She worked out and stayed in good shape.
She appeared to be in good shape.
How many times had you been to her house at 2086 Mount Street, do you think?
Was
Have
that
you
her
ever
last
shared the
address where she was living?
Yes.
Probably only a handful of times.
Had you been out to the balcony that was next to her bedroom?
When she gave me a tour, yes.
I have in my hand what I'd like to be marked as defense next in order.
Double M.
Sorry, M?
Double M, yes. Is that photo?
Yes. It's what appears to be a photo of Ms. Harwick.
Yes.
Ms. Rollins, is this a picture of Ms. Harwick on the railing on her balcony?
Is that a picture of, you're objecting to what foundation in terms of the railing?
It's the date of the photograph and whether she has personal knowledge of that photo.
Wow, did you assign a date to it?
No.
No, I didn't think you did.
You may answer.
I don't know what the railing looked like exactly.
Does this look like a picture of Ms. Harwick on her balcony?
Sorry, I see a lot of y'all asking. The poll means like I still have this picture down here. The judge is going to come back after a break, and they're going to basically what they did with Murdaugh, like where they're talking about the financial crime stuff. They're going to do the same thing with Russel Lafayette and Cory Fleming. So it's just, did y'all want to watch them do the hearing, or do you want me to just recap later so that we can watch this? That's what the poll means.
It's definitely a photo of Amie on some sort of fence.
Okay. And you'd been out to the balcony, you said, when she gave you a tour?
Yes.
But you're not sure whether this is a photo of her on the balcony.
I don't know.
Okay, I'm going to redo the poll.
Now, at the time of the interview with detectives on the 16th of February, you indicated that Mr. Koshland was there the whole time, right?
Right.
And while you were doing this interview with the detectives, there were people gathering at Mr. Koshland's house.
Is that a question?
Yes.
What was the question?
Isn't it true that there were people gathering at Mr. Koshland's house while you were having the interview with detectives?
I believe he does say that in our interview. Yes.
Do you have a recollection that people were gathering at Mr. Koshland's house at the time that you were having this interview with detectives?
Did you, no, maybe ask, do you have any recollection of people, independent recollection, while you were being interviewed, that people were gathering at the house?
I understand your question. I don't completely remember.
Okay. Would it refresh your recollection to look at the transcript of the interview?
Yes.
Okay. If I may just have one brief moment.
Oh, Chrome.
Actually, I'll move on. One of the reasons, so at the time of the interview, you and Mr. Koshland were receiving lots of messages about Ms. Harwick's passing, right?
I believe that he mentions that there were he was receiving messages.
Were you receiving messages about Ms. Harwick's death?
Not that I recall.
Were you and Mr. Koshland concerned about how her story would be told in the media?
I'm not sure.
Do you recall telling the detectives that you hoped that her story would be able to be controlled?
I don't recall saying that.
Would it refresh your recollection to look at a transcript of the interview?
Yes.
All right, this is page 12 of the second transcript, transcript number 2. So if you could please read from line 19 to 28 of page 12 of transcript.
Read it to yourself if you would.
Yeah, read it to yourself, not aloud.
I'm sorry, I wasn't done.
Did that refresh
finished.
your recollection?
A bit.
And isn't it true that during the interview with detectives, you expressed that that you had concerns about how her story would be told by the media?
What I just read, none of that was coming from me. I think my abbreviation is the letter S.
Would it refresh your recollection to look at the key on the transcript?
Yes.
May I approach? Yes. Showing the cover page of the transcript, 2 of 2.
Oh, thank you.
So if you could just look right there at the legend and then look up when you're done.
Okay.
And do you want to look back at page 12 again?
Yes.
Okay. So if you could please reread lines 19 to 28.
Okay, yes.
And have you reread them?
I understand, yes.
Okay. So isn't it true that you expressed concern to the detectives about how the media would tell her story?
Yes.
And that you expressed a desire that you hoped it would be able to be controlled?
I hope that she's portrayed as the woman that she is. And not a victim who was naive. And, you know, that's what I meant by that.
Okay. Objection as to the narrative at this point. Sorry, one moment.
He objects to his own people on the stand. Like that's
Prior to your testimony today, did you speak with Mr. Avila or Ms. Mariano about your testimony today? Recent to today.
Catherine, is that your last name?
Yes.
Yes.
And did you speak about the facts of the case?
I went over my interview with the detectives via audio and transcript, and then also the preliminary trial transcript only.
My question was whether you spoke with Ms. Mariano about the facts of this case.
I asked her what Mr. Pursehouse could be facing.
That was the only discussion about the facts of this case. Is that your testimony?
I believe so, yes.
Okay, nothing further.
No redirect, Your Honor.
Now, can I step down? Thank you. Make all your necessary.
The people at this side call Mr. Patrick Turner, Your Honor.
What's the last name?
Turner.
this is day 4. There's only a couple hours of this one. They had paused this, so they haven't had this in like a week and a half because of COVID. So this is the and they don't do it live. They only release the video after.
Page is he on your list? Is he on it?
Please state and spell both your first and last name.
Patrick Turner, Patrickturner.
Thank you, Your Honor. What do you do for a living?
I am an engineer with the LA City Fire Department.
What is an engineer?
I drive the fire engine to and from incidents, mitigate fire and emergency responses, medical responses. Yeah.
Do you have any other training?
I'm also trained as a EMT and as a paramedic.
Now, what were you assigned to as, or what was your occupation specifically back on February 15th of 2020?
I was also an engineer at Fire Station 82.
Now, on February 15th at around 1:40 in the morning, were you at the location of 2086 Mound Street in the city and county of Los Angeles?
Yes.
Why were you at that location on that date and time?
We were called out as an engine company, and we responded to that incident. I don't remember the name of the type of call it was, but we were dispatched.
And was that at around 1:32 in the morning?
Yes.
Do you recall what time you actually arrived?
I believe we arrived within 5 to 10 minutes.
Do you recall if there was any sort of delay in getting to that location?
I do remember that it was a unique street. I don't believe I'd ever driven down that street before. It was on the west side of our district, so it was fairly far away as it's we encompass the Hollywood Hills for our district. So I do remember it was on the west side, and it was down a street that I hadn't really even been on before.
Was it a narrow street?
It was a narrow street, and it was like up a hill as well.
So I know you said as an engineer you drive a fire truck. Was it hard to navigate up to that residence?
Yes, that's the same.
Now, would you say that the location of where you, or 2086 Mount Street, caused any sort of delay in arriving to the location?
Maybe it may have hindered us by a couple of minutes, perhaps, because I believe I had to park the apparatus a little bit further away than I normally would have, and then we had to walk up to the house.
Who else were you with during that time?
I was with a captain and 2 firefighters along, inside the engine with me, and then there was LAPD on scene.
Were any of the other fire department personnel an EMT?
They are all EMTs.
Were any of them paramedics?
No.
Now, can you describe what you observed once you arrived on scene?
Once we arrived on scene, I remember walking up to the house, just thinking it seemed like a unique looking house. It was large. It was dark. It was late at night, early in the morning. LAPD's there walking us through. And it took us a while to get from the front. They were escorting us to the backyard where they were explaining a little bit what we were walking into.
And when you say they were explaining, are you talking about law enforcement explaining?
Yeah, just LAPD was, they were the ones that greeted us, and they took us basically to where the victim was laying in the backyard.
When you say they were explaining something to you, is that something that customarily happens when you report to a scene?
Yeah, absolutely.
You can answer.
Yeah, we arrived on scene. It's typical if whoever's calling us out, whether it's just a public person or if, in this case it was LAPD, we kind of just give us a little rundown of what we're expecting. We have if it's a patient or if they have a person in custody, they'll just let us know, okay, this is kind of what happened. This is what we're seeing, and we're going to lead you to where we need you to do your assessment.
You said that you were led to the backyard. What did you observe once you actually got into the backyard?
We walked through down these stairs, I believe, to the backyard. And when we went outside, we were shown where the victim was laying. And then there we saw her laying on the ground.
When you say you saw the victim, what was her state at the time you observed her in the backyard?
Just upon seeing her from a distance, I initially thought she was a dead victim. The LAPD had told us that it was a fall from the balcony about 2 to 3 stories in height. So I remember looking up, seeing the balcony, that it was quite high, and that she had fallen from the balcony onto the concrete, and looking and appearing lifeless at the time upon my immediate assessment, just from seeing her.
Did you take a closer look at her once beyond just your initial glance?
Yes, of course. We proceeded to, we walked through, we all entered the backyard. We had our equipment with us, and then we went to go ahead and assess the status of the patient lying on the ground.
Now, I know you said that you're an engineer by occupation. Why is it that you were hands-on with the victim, seeing that your primary duty is to try to fire a truck?
Exactly. Well, that's just one of my duties. If there is any instance where there is critical patient care that's involved, I'm always going to jump in and also lend a hand. And in this circumstance, this is definitely a critical patient. So I felt the need to assist as much as I could.
Your Honor, at this time, the people have a DVD, a body-worn video made at the Marcus Peoples 54. And there's an accompanying transcript made at the Marcus 54B.
Yes, what's the duration?
About 20 minutes, if I'm not mistaken, Your Honor. 20 to 30.
She said B58.
Or sorry, should I reverse it?
This DVD and transcript. So much to transcript, eh? Right. No.
Permission to distribute the transcript?
You have a copy of the report?
Let's see.
For our engine company,
I'm stopping the video at 10 minutes and 53 seconds. Can you let us know all of the LA Fire Department personnel that walked in at that point?
yes, so the person in the very front was the captain for our engine company, Captain Dave Grijalva. I believe I was the second one to follow through. And then the two firefighters behind me were firefighter Majak and firefighter Brinson.
Continuing the recording at 10 minutes and 53 seconds. I'm pausing the video at 11 minutes and 10 seconds. Based on this, where I stopped the video, can you point out the personnel that you just named?
Yes, so the gentleman holding the flashlight, that's Captain Grijalva. He's also in charge of our radio comms, so he's the one talking on the radio right now to dispatch. This is firefighter Majak.
And on the bottom left corner, is that the victim as you observed her when you first walked in?
Right here, yes, this is the victim right here, how we observed her as we came in. I can't really see from this where I'm standing or where firefighter Brinson is.
Can you all see, ladies and gentlemen? Okay, you have a pointer there, you need a wooden pointer somewhere behind you.
Corner.
Oh, the screen there.
Everyone's talking.
Right there. The pointer.
Behind your seat?
Yeah.
Oh, Steve.
You're looking for a laser.
I was looking for a laser.
Resuming the video at 11 minutes and 10 seconds.
I like the hook print.
He said he heard her screaming.
I'm stopping the video at 11 minutes and 32 seconds. I think I stopped it a little late, but there was someone, fire department personnel standing over the body touching it. Could you tell us what that person is doing?
That person is checking for a pulse.
Oh, page 12. Resuming the video at 11 minutes and 32 seconds.
Hey, so what we got right now is a female. It looks like she either fell, or was thrown from a third-story balcony. The roommate that's here says he heard her screaming. He thought she was probably being attacked. But instead of going to check on her, he went out to the street and was claiming. And I called police, and then he found her with the officers. There's some blood on his shirt, though. Because he doesn't think anyone else is here. So it looks, she's breathing right now, but she looks very bad. Mal,
I'm pausing at 12 minutes and 26 seconds. In the figure to the left, it's a little harder on the TV screen. Crouched over the victim's body. Who is that?
I am crouched over the victim's body right now.
And what are you doing at that point?
I'm verifying that there actually is a pulse right now.
And was there a pulse at the time that you checked the victim?
There was a pulse.
Continuing the video at 12 minutes and 26 seconds.
Okay, really good. Yeah, yeah, she doesn't look too great. The balcony is what it would be 2 full stories, 2.5. So like 20 feet, 25 feet. All right, okay.
I'm talking to video 12 minutes and 36 seconds. Faintly to hear someone say, "Man, talk to me." What is it that you or one of the other law enforcement, fire department personnel is doing?
So right now I'm just trying to determine her level of consciousness. She was laying face down. We checked her pulse. I personally checked her pulse. She had a very, very weak and thready pulse, and very, very slow agonal respirations from my initial assessment. I'm now checking to see if I can wake her up, if she's going to respond to me either verbally, open her eyes, start talking to me. That's what I'm trying to determine right now. So by me saying, "Ma'am, can you hear me?" I'm trying to stimulate any of her senses to see if I can get any response from her.
You said that you checked for her pulse and that it was thready. Is that a bad indication?
Yes, that's very, very bad.
You talked about checking her respirations. Is that correct?
Correct.
And how was that?
So she wasn't breathing normally. She was having irregular gasps, not normal exchange of normal tidal volume of breathing in and out. And that, along with her weak and slow pulse, are just signs that she is a very, very critical patient.
Did she respond to you when you were speaking to her, saying, "Man, talk to me"?
No.
Is that also a sign of her critical state at that time?
Correct.
Continuing the video at 13 minutes and 26 seconds.
Hey, what's the number again? What was that? 2086.
Pausing at 13 minutes and 53 seconds. You're crouched next to the victim, is that correct?
That is correct.
What are you doing at this point?
So right now we have moved the patient from a prone position. She was lying on her stomach. We've turned her over, and we are now just going to start establishing some patient care. So right now we are with a fall for this height, and for a patient to be unconscious, we have to assume massive head injury. The potential for various broken bones, we have to consider all these things. So we have carefully turned her over with protection of her head and neck in mind, and we are going to just start conducting our full assessment of her, along with the treatment, including securing her neck with a C-collar, removing her clothes, and checking for further injuries, and providing first aid and vital signs, everything that we can do for her prior to the ambulance arriving.
Why did you have to flip her from her back, or sorry, from her prone position to feet?
Because a natural position to assess a patient is not while they're laying on the ground with their face down and their stomach down. We have to put her in a position to open her airway if her airway was potentially closed, put her head and neck in an upright position so we can give her every chance to move air cleanly. And that requires her to be on her back, not on her stomach.
What do you do once she's on her back?
So once we turn her over and she's on her back, we keep in mind, we try to keep her head in line with the rest of her body. We raise her chin slightly so she has a good patent airway. And then we can just start conducting a rapid physical assessment from head to toe, and then initiate any care that we deem needed.
How do you do a rapid physical assessment?
So initially, for any trauma patient, we try to just do a brief, quick head to toe, looking at what the biggest things are. The biggest, by meaning like the most critical things that we can do. For someone who's unconscious, who has fallen from a 2-3 story balcony, And in this particular case, she wasn't breathing adequately. She's not perfusing adequately, meaning her heart rate is very, very low. So we know that she's critical. She's not pushing enough blood through her organs. She's not breathing enough. She's not oxygenating her brain enough. So we're quickly going through, and we need to try to fix that as much as we can. And then while we're doing that, we need to also assess for other damage that we can report to the paramedic ambulance when they arrive on scene, such as broken bones, other injuries that we notice. We just don't want to miss anything.
Proceeding the video at 13:53. We're stopping at 15:07. There's an individual directly in the middle of the screen messing with what looks to be a device. What is he doing?
Correct. That is the captain right now, and he's opening up a oxygen cylinder, and he is turning the regulator on. That's the noise that you hear. That he's turning it, making sure that there's oxygen that's going to flow out of that. And he is out of a bag. He is obtaining an adult bag valve mask, which is a device that is used when connected to the oxygen cylinder. Will allow oxygen flow, continuous oxygen flow to a setting of our choice, and also comes with a tube that we can squeeze and actually breathe for the patient. It inflates their lungs at any given rate that we decide to depress it.
At this time, did you make a determination that the victim needed assistance breathing?
100%. She was not breathing adequately on her own.
Resuming the video at 15 minutes and 7 seconds.
If they go around the side of the house here to go to straight show.
You are late. Late. Yeah, they're not by the microphone on that stuff. You are late.
I'm stopping the video at 16:17. It appears that you.
I'm just going to shame all y'all for being late.
Your hands along the victim's entire body. What is it that you're doing?
So what we've done here is with any trauma victim, we remove their clothes. So I think she did have a nightgown or something on. So that I've cut off and removed, and I've also taken off her boots. I think she had some higher boots on as well. But for any trauma victim, it's important that we get eyes on their entire body, head to toe, with the exception of underwear, bras, that sort of thing, just so we can make sure that we don't miss anything. We want to make sure that we catch any injury that they may have sustained. So by me palpating her body, I'm just running through and I'm just assessing for broken bones, any like lacerations, punctures, any other sort of wounds that she may have received. And I'm just trying to do that very, very quickly so I can assess how bad she may be injured.
And did that sort of pat down of the victim's body reveal any sort of injuries?
Yes, it did.
And what sort of injuries were you able to glean from doing that?
So initially, you can even see that there was a pool of blood, which was coming from her nose and mouth area. That was pretty obvious just from seeing that. But once we removed the clothes and had her turned around, after assessing it, I did notice that she did have extensive deformity to her pelvic region, so her hips, waistline all the way up to her neck. She had some disfigurement to her neck and collarbone area, and she had extreme softness and tenderness to her ribs and stomach region. Ribs meaning like it was being soft around that area, just indicative of possible broken ribs. And coming from a fall onto the pavement, right, that would be in line with what to be expected from a fall like that.
After putting off the victim's clothes and doing that assessment, did you continue to believe that she was in a critical state?
100%.
Continuing the video at 16 minutes and 17 seconds.
Yeah, you guys did. Yes.
Yeah, her injuries were really bad. I think what makes this one so hard too is that this wasn't just like a, quick thing that she didn't know what was coming. You know what I mean? And that makes it harder. Especially like if you go look at her like Twitter and her Instagram and stuff like that, like you can tell what a great lady she was. She's constantly posting things that are like, helpful and uplifting. We can't really hear because they're not showing the body cam because they're not going to show her, but that's what they're doing right now.
Yeah, third store right there. Yeah, I'll give my neck. Hey. Case of any kind of statements. Yeah. Right with her. Well, we'll get you. You guys are gonna go to Cedars, I'm sure. Yeah.
I'm stopping the video at 20 minutes and 37 seconds. There's some chatter about going to Cedars Hospital. Is that where the victim is headed to?
Yes, based on the criteria of this injury, it's important that this victim goes to a trauma center. The only two trauma centers in this area would be County USC and Cedars. And based on the location of the residence, she would be qualifying to go to Cedars.
And at this point, what are you waiting for?
So right now we're just waiting for the ambulance to arrive.
And why did an ambulance need to arrive?
Because she's extremely critical. She didn't. We weren't dispatched with the paramedic ambulance to begin with. So we're pretty much just waiting for them to get there. We've taken over her breathing for her, and we're just kind of setting everything up so when the paramedics arrive, we can just load her on the gurney immediately and then they can get going to the hospital.
We're seeing the video at 20 minutes and 37 seconds.
It was like a skirt. And yeah, if they go on the side of the house here, there's no stairs or anything. That's easier for those to go. It's more like a ramp. So. Born in 81, so 39. Very, very faint.
Okay, I want to pause it again for 1 second because I want to go back to the Murdaugh trial just for this part because we're going to hear the victims.
Indicted by the South Carolina State Grand Jury in March of 2022, and that alleges
Speak on this part.
18 counts.
So we're going to pause for just a
against
minute.
Mr. Fleming for victimization of Lord Satterfield's estate and ultimately her sons as beneficiaries of that estate. And I would point out that we do have representatives of the Satterfield family here today, as well as their counsel, Eric Bland. I believe some of the victims want to address the court at the appropriate time. Your Honor, we also have State Grand Jury indictment 2022 GS 47-2. That was indicted by the South Carolina State Grand Jury in April of 2022. And that alleges 5 counts against Mr. Fleming. And that is where the victim is Ms. Pamela Pinckney. And we have here Representative Ms. Pinckney, Justin Bamberg was here. Ms. Pinckney wanted to attend, was unable to make it, but Mr. Bamberg will be speaking on her behalf here today. Your Honor, I'd like to, I know we went through a very extensive factual basis and put in a number, over 20 exhibits at the plea. And as I described it at the plea, I think that the issue here is if we were in traffic court and the speed limit was 55, and Mr. Fleming wants to say, well, I admit I did 58. And the state, if I'm the trooper, I'm like, no, Your Honor, we clock you doing 90, weaving in and out of traffic like a video game. And so what I'd like to do, Your Honor, with the court's indulgence is just kind of detail some of the facts that show the true and real extent of the conduct here, because again, it does go to the heart of the state judicial system. Your Honor, these allegations here involve the use of state law licenses in state court actions before state judges with state court approved settlements. So ultimately, Mr. Fleming has admitted to a violation and abuse of the state judicial system. And because of that, Your Honor, I would submit to the court that the state judicial system must defend itself. It must provide its own accountability for those who would abuse it. And that is what the state, and I believe the victims, will be asking Your Honor to do here today. Mr. Fleming admits that he conspired with Alec Murdaugh to steal money in both the Pinckney matter and the Satterfield matter. He admits that, Your Honor. He admits to colluding with Mr. Murdaugh in the Pinckney matter when he was recruited by Mr. Murdaugh to represent Miss Pinckney because she was a driver in the crash, but also a plaintiff, and so they needed another lawyer involved in the case. Mr. Murdaugh represented the other clients, including Hakeem Pinckney. And in the Satterfield matter, as Your Honor has heard, Mr. Murdaugh recruited, put these cases in Mr. Fleming's lap. In the Satterfield matter, where Mr. Fleming was going to represent the estate and represent the sons of Miss Gloria Satterfield, but Mr. Fleming was going to behind the scenes collude with the defendant in that action. Not the attorney, but the defendant himself. And what Mr. Fleming, I think, wants the court to believe is, even though the state grand jury, he initially reported to everyone that he was a victim of Mr. Murdaugh just like everybody else, just like Mr. Murdaugh's law partners, and just like his clients. He was tricked and fooled by Mr. Murdaugh just like anyone else. But what happened was the state grand jury, which again is a partnership of the Attorney General and SLED, and the people sitting around me and the SLED agents over there, right out of the gate, when we first got involved in September of 2021, and one of the things that we uncovered was that Mr. Fleming had been stealing checks from his clients going all the way back to 2012. All the way back to 2012. So when Mr. Fleming tries to tell this court that, okay, I stole a little bit, but I really was hoodooed by Alec Murdaugh as to the big money, I'd ask the court to consider that and consider this entire chain of conduct and whether or not that makes common sense and whether or not that fits with the evidence. Your Honor, what we see at the beginning of this case, the Pinckney wreck occurred back in 2009, and it resulted in terrible injuries to members of that family, injuries that ultimately contributed to Hakeem's death, injuries that Miss Pamela Pinckney is still dealing with to this day. And what the evidence revealed is that Mr. Fleming knew how to interact with his clients. Early on, he's interacting with Miss P. He's developing that personal relationship with Miss P that you expect a lawyer to do in a case like this. He knows how to do it. But then what we see is at the same time where he's telling Miss P he's taking care of her, he's spending time with her, he's going to her hospital bed. It doesn't take him long to steal a couple of checks so that he and Alec Murdaugh can fly in a private plane and go to the College World Series. And he bills that. No one else did this. This is in his records from his law firm. He bills that to Crosswind as if it is a medical expense. And it was a private plane ride to go party.
with Miss P's money. And so when Mr. Fleming tries to tell you that he didn't really know what was going on throughout this entire decade-long scheme of conduct, I would ask Your Honor to take that into consideration when you look at what he really did and how long it's been going on. He disbursed a large sum of money to Miss Pinckney the right way. And there is no better feeling, I am told, for a plaintiff's lawyer or their staff, that when they get to call in that person who's been hurt, who's suffered, and say, I know you've been hurt, I know you've been suffered, but I've got a check of life-changing money for you. Here it is here today. And in fact, that's how usually the scheme works, because those clients, those victims are so distracted by the big check in front of them that they're not paying attention to the sleight of hand behind them. And that's what Mr. Fleming did with his law license. Mr. Fleming stole those crosswind checks in 2012. And one of the facts I have to reiterate for Your Honor is we mentioned another civil action in which Mr. Fleming was not actually the defendant, but he pretty much was the defendant because it was a close family member who was the defendant. And what the investigation revealed was that Mr. Fleming, as essentially the defendant, was doing the legal work in the case, and they were essentially using Alec Murdaugh's name as the plaintiff's lawyer. To the point where there's an email where Mr. Fleming sends to Alec Murdaugh's staffer the petition and the order with the settlement in there and says, hey, I need you to send it to the defense lawyer so it doesn't look like it came from me. And this man wants to try to convince you that he didn't really know what was up in his dealings with Alec Murdaugh. Ultimately, in that case, Your Honor, the order that was submitted, the settlement, reflects $48,000 in legal fees that were supposed to go on the paper to Alec Murdaugh. But instead, they ended up in the pocket of essentially the defendant and his family. And that's ultimately how the state grand jury figured it out, because we saw this $48,000 reference, but no $48,000 check coming into the PMPED law firm. But does it sound familiar, Your Honor? Again, I would ask you to consider that it was essentially Satterfield in reverse. Except this time, Mr. Fleming was the beneficiary as essentially the defendant of receiving monies that were supposedly going to the plaintiff and the plaintiff's counsel. Your Honor, that was going on 2012 through 2014, around the time that Mr. Fleming first stole from Ms. Pinckney. And years go by to all the way to 2017. And Mr. Fleming still has money belonging to Ms. Pinckney in his account, money that he had retained supposedly for satisfaction of liens. But what we found, what we uncovered, was that was a perfect delta of money. Because once you settle those liens, or you just don't even settle them at all, that's money then that you can steal or steal from. And in 2017, Mr. Murdaugh cuts a check for $4,560 and delivers it to Alec Murdaugh, or causes it to be delivered for fake expenses of Ms. P's money. Again, when you consider what he's trying to convince you, think about the entire course of conduct here and how these two men operated together. But more importantly, he also cuts a check for $89,000, over $89,000 of Ms. P's money, and cuts it to PMP, and Alec Murdaugh promptly converts it to forge. This is a man, again, who knew how to interact with Ms. P, who had interacted with Ms. P, who had sat by her bedside as she suffered from the injuries of that wreck.
I love how
call
passionate
up
he
Ms.
is for the
P
victims.
in 2017 and say, great news, I got $89,000 more of your money. Does he call up that client that he had that personal interaction with? No. He just gives it to PMP&D, gives it to Alec. Makes no effort to contact him. again, when we look at this entirety of these events, and Mr. Fleming tries to tell you, okay, I got caught red-handed stealing a little bit, but I didn't know about all this other stuff. It doesn't fit with the evidence. It doesn't fit with common sense. But if we had any question, and we're going to get to the 3 checks in the Satterfield matter. There were 3 checks. There were 1 check for over $400,000 that Mr. Fleming made out from his trust account to just the single word forge, which in and itself is ridiculous. Just the word forge. A 2nd check for over $2.9 million. This is money that's supposed to go to this family right here, Your Honor. Made out to the word forge. And a 3rd check for $118,000 made out to the word forge. All of that money was supposed to go to this family, and it doesn't. Mr. Fleming, I believe, wants to convince Your Honor that when he cut those checks representing the proceeds that were supposed to go to this family and caused those to be delivered to Alec Murdaugh, made out to forge, that he didn't know that Alec might take any of that money. That he thought every penny of that money was going to go to those boys. And it doesn't make sense. It doesn't make sense with the history here, and it doesn't make sense with the specific evidence in this case. And let's talk about the first thing that we have. Aside from just, it doesn't make common sense. It doesn't make common sense to make out a check just to the word forge. It doesn't make sense because forge doesn't take money in the traditional sense. It doesn't make sense because his own staff testified that Mr. Fleming did everything differently in this case. It doesn't make sense because Mr. Fleming, unlike we know how he does to do with Mr. P, never made an effort to talk to the Satterfield family. Never made an effort to find out if they got their money. Never contacted them, never called them up and said, great news. Never told the PR that they pretty much brought in as a patsy to do that either. Never told him what to do. And I'll talk a little bit more about that in a second, Your Honor. In December of 27, though, if we had any illusion that Mr. Fleming, when he cut those checks to forge out of his trust account, when he received the settlement money in his trust account, that that's not how you do a structure, we have that email that I detailed for Your Honor, where Michael Gunn at the legitimate forge explained to Mr. Fleming and his staffer, you received the money, we can't set up a traditional structure.
What year was that again?
That was in December 20th, 2017 was that email, and that was State's Plea Exhibit number 5, Your Honor. And I have another copy of the plea exhibits, if Your Honor. I don't know if Your Honor has
Yes,
some.
sir, if you would.
I'll pass those up.
I think his band is actually, I'm going to be at CrimeCon, and his band is actually playing at the kickoff party, I think. I'll take videos and pictures. Maybe I'll go live from there.
That was December 2017. Just a few months later, in February of 2018, Gloria Satterfield, a longtime housekeeper for the Murdaughs, fell at Moselle
Hello, love.
and suffered injuries from which she ultimately succumbed on February 26, 2018. And Your Honor's heard evidence that not long after that, Alec Murdaugh told the Satterfield family that he was going to take care of them. He was going to make sure that they got taken care of for their mother's death, for her long service to that family. And who did he bring in? His longtime co-conspirator, Cory Fleming. But Cory Fleming only met with them once or twice, if that. Met with them a couple times. He never had them sign a fee agreement, which is common practice, as Your Honor knows, required practice. He never updated the Satterfields on the status of the case. He never advised them about the recoveries. He never advised them of the settlement offers. He never advised them that money was being directed to Forge. He never, of course, told them that he and Mr. Murdaugh, as I'll detail, were dipping into their money for their own personal gain and expenses. And what's most important, Your Honor, is Mr. Fleming never told this family, never told Chad Westendorf, the PR that they put in as a patsy, what he's going to try to claim to Your Honor now, that he generously cut his fee in half and had no idea that Alec was going to take any of the other half of that fee. That's what he's trying to claim now. Cut his fee in half and never once tells the PR that. Never once tells them that. You know what kind of lawyer I am? I'm going to cut my fee in half. $600,000 is enough for me. And why doesn't he tell them that? Because he's got an arrangement with Alec Murdaugh, and all the evidence in this case reflects it. It works out to be just like a fee split you see over and over again. And the reality is, the reason is because they co-litigated the case. Alec Murdaugh functioned as co-counsel with Cory Fleming, co-plaintiff's counsel in a case where Alec was the defendant. It was a shakedown. Plain and simple. These boys, this family, deserve compensation. But they were nothing but a vehicle for Mr. Fleming and Mr. Murdaugh to steal money.
He's on it today. Own it, don't own it.
Again, looking at common sense and what the evidence reflects. But in November of 2018, there's two policies, one for $500K, Lloyd's of London, and they pay on the policy. Well, guess what? At that point in time, Tony Satterfield is the PR of the estate. That's Mr. Fleming's client. Does Mr. Fleming call up Mr. Satterfield and say, Tony, great news. They tendered the policy limits. First check's in, $500K, $500,000. No, he does not do that at all. In fact, he, and we have the email, instructs his staff, hold this check until we can get the PR changed. Hold this until we can get the PR changed. Why in the world did he do that if he thought that that money was legitimately going to go to those boys? It's not. It was meant to put in the patsy so they could cover up what they were about to do. And the evidence is clear, Your Honor. That's State's plea exhibit number 6. In fact, they get the check. Lloyd's of London cuts that check on December 4th, and they make it out to Chad Westendorf. He hasn't even been designated as the PR yet. They haven't even changed it yet. They already get the check made out to Chad Westendorf. And Westendorf was clear, and the evidence is clear, that he was not instructed what to do. In fact, he was always told by Mr. Fleming, I got it. I'll handle it. Do I need to do anything? Do I need to open a bank account? No, I got it. I'll handle the disbursements. That's not Alec. That's Mr. Fleming saying that, according to the evidence gathered in this case. In December of 2018, Mr. Satterfield is convinced by Alec to sign over being PR of the estate so that this scheme can take effect. And an order is filed that retroactively says the date was back in March of 2018, which is a fabrication.
What date was that again?
December 18, 2018 is when the PR change is issued. That's plea exhibit number 7. And the date in plea exhibit 7, if you look at that document, says that it was effective from March 28, 2018. Again, plea exhibit 7. Complete fabrication. Chad Westendorf hadn't been contacted back in March. Tony was the PR. This is all after the fact to hide what they're about to do. And so when he says he thought that check that he got to forge, which he cut shortly after this, for $403,000 was actually going to go to an account for those boys, aside from the fact that that's not how it works, and it makes no sense, and it's made out to a single word forge. It's all an after-the-fact reconstruction to put in their patsy so they don't know that they've gotten a recovery. And Mr. Fleming is at the center of that. Aside from the fact that even if he tries to claim that when he handed those checks to his co-conspirator abusing the judicial system, if I didn't know what my fellow thief was going to do with it, that's not even good enough under the law anyway. When you're conspiring with somebody, you're responsible for the natural and probable consequences of that act regardless. But even that being the case, he knew, and the evidence is clear. I want to be clear. The state has never contended that Mr. Fleming thought that Alec was going to steal every single dime. Because that's not usually how the scheme works, right? As I just stated, you're usually handing some big check, life-changing money to people who've never had that kind of money before, and they're so distracted by that they don't realize you're stealing right from behind them. But for Mr. Fleming to claim that when he delivered those forged checks representing the vast bulk of all this money, that he thought that every dime was going to go to those boys, it defies common sense, it defies the evidence, it defies what he knew how things were supposed to work. Mr. Fleming never once communicates with Tony Satterfield about the change of the PR, never once communicates with Tony Satterfield about a recovery of $500,000. Instead, he deposits the check that they had pre-made out to Chad Westendorf even before the change of PR. And then Mr. Fleming prepares a petition for approval of wrongful death settlement and an order. And that order says that there's going to be $166,000 in attorney's fees, which is the standard percentage. But that's not what happened. It also has in there, on the nose, $11,500 in expenses, which are completely fraudulent. Didn't exist. And what Mr. Fleming's own staff revealed is that in the Satterfield case, every step of the way, normally when they're preparing the disbursement sheets, they're getting all the receipts from the expense Satterfield's depositions, travel, mediator expenses, all that she's getting them all together and she's itemizing them and doing all the math for that disbursement sheet for the client to sign. And instead, no, stop. This is the numbers I want you to put down. That was Mr. Fleming doing that, not Ellen Murray. That's plea exhibit 9, Your Honor. January 7th, 2019, they get Chad Westendorf to sign a disbursement statement. Again, it's got those fraudulent expenses of $11,500 on there. This time it does indicate that the attorney's fees is $50,000. Again, cutting the fee, but never telling anybody, telling Mr. Westendorf, hey, let your clients know what a great attorney I am. I'm cutting my fee in half, for less than half. Out of the goodness of my heart. Never says that. What does that tell you, Your Honor? Why would somebody do that and not let the people who are supposedly benefiting from that know? The only reason you're doing that is because you're creating a delta for your co-conspirator to steal. Mr. Fleming, when that check gets cut, Mr. Westendorf's like, what do I do, man? Tell me what I need to do. And he says, I'll handle the disbursement. Mr. Fleming does. I'm going to pay some medical expenses, which he never does. Absolutely never does. January 17th, 2019, just a week later or so. That first money has come in. It's in Cory Fleming's trust account. And this is the first evidence where we see Mr. Fleming be like, yeah, that's a lot of money. I think I'll just go down and take some of it. And he goes down to a staff member and says, cut me an $8,000 check made out to me from the trust account of money belonging to this family and say it's expenses for the case. They're completely fraudulent. We can look at Mr. Fleming's accounts. He may not remember why he did it, but we can see why he did it. Bank records tell a story, and we can see the balance in his account, how low it was, and we can see that money come in, and immediately goes to pay a mortgage, and other personal expenses. Needed the money, had their money, and just walked down to a staffer's desk and said, cut me a check. Stolen. Ultimately, there's a mediation. Mr. Fleming is there, and Mr. Murdaugh is there, and ultimately they collude during the course of that.
So much time.
Like, Bo, I got to get me something out of this. I got to get me something out of this, Cory. They accept an offer, settlement offer for $3.8 million. Does Mr. Fleming tell this family about such a momentous event? No. Does he try to communicate with them? No. Does he tell them, oh, I got y'all $3.8 million. I can take $1.4 million in fees from that, and I'm going to cut it in half out of the goodness of my heart. Does he do that? No. Why? Because he is creating that delta for his co-conspirator. Because they have the patsy in there so that they can get the scheme done. And they tell Mr. Westendorf again, we got it. Mr. Fleming says to Mr. Westendorf, I'll take care of the disbursements. $3.8 million come in. That's a big day. And Mr. Fleming doesn't wait a moment, because on March 26th, he goes right back down to his staffer and says, hey, cut me a check for $8,500 for expenses in the estate of Gloria Satterfield, which are completely fraudulent. Couldn't wait one day. Let me go ahead and put $8,500 in my pocket. And again, we can look in his account and see how low his balance was, and we can see immediately the vast majority of that money he has to make a payment of taxes. Again, there's no illusion about the motive here. He was broke and he needed the money, so he just stole it from this family because he had it in his trust account. Well, they got $3.8 million. And again, if you have any illusions about Mr. Fleming believing that when he cut those checks to Forge, that $2.9 million check, which is the next check that he cut to the single word Forge, that he really thought that every dime of that money was going to this family, well, the emails prove otherwise. And these are crucial, Your Honor. States Exhibits 13 and 14. Because the adjuster at Nautilus is like, I don't understand it. What? Tell me how to cut this check. Is he doing a structure or not? But does he want a single check? We need to know, because if he's going to do a structure, he has to do it this way. And Mr. Grantland sends it to Mr. Fleming, says, what do you want me to tell him? And Mr. Fleming's like, well, says some things. He's like, well, I got to check with Forge, which is a lie, because he's not dealing with real Forge at all. And they don't have an answer. So, again, Mr. Grantland sends the same question that the adjuster from Nautilus is saying, how are we cutting this check? This is the email. I need some clarification here. If he has a structure, don't we need to wait for information on the structure? Is he wanting us to fund the structure? Or is he funding the structure? If he wants us to fund the structure, it must go through Ringler. If he doesn't want us to fund the structure, does he want the funds to consist of a single check in the amount of $3.8 million payable to Chad Westendorf as PR? And the Nautilus attorney forwards that to Fleming and says, let me know what I need to tell her. And eventually, on April 1st, 2019, Mr. Fleming says, okay, standard check. Chad Westendorf as PR and MKNF as attorneys. There was no structure, and Mr. Fleming did it. Aside from the fact that's not how it works. He couldn't take the money directly. You can't do a structure in the traditional sense that way. These emails prove it. He tells them standard check. And of course, that check is cut to his trust account. In May 9th, 2019, Mr. Fleming tells the Nautilus attorney, you don't have to come to the hearing. And then Your Honor, this is State's Plea Exhibit 18, and this is a crucial thing as well that refutes Mr. Fleming's claim that he was only doing 58 miles per hour. Because again, his staffer starts to prepare a disbursement sheet, and she's searching for legitimate expenses, and she puts on there that there were disbursements to Forge for Lloyd's of London of $403,500, and there's disbursements to Nautilus of $2.9 million in change, and also puts on there the fees. And Mr. Fleming, not Mr. Murdaugh, Mr. Fleming goes down and tells his staffer, no, stop. Don't do it like that. Put these numbers down. Without any support, just tells her, no, I want these numbers. And that's in Plea Exhibit 19. And what's crucial about that, Your Honor, is that any reference to Forge is removed. In the one they actually give to Chad Westendorf, it's removed. And what's also crucial about that disbursement statement, Your Honor, State's Plea Exhibit 19 that they give to Chad Westendorf to sign is that it's got the full fee, collective fee between the two recoveries of $1.4 million on there. It lists that they're taking the full fee. That's what he tells the PR. He doesn't tell the PR, oh, by the way, out of the goodness of my heart, please tell the boys, I'm such a great lawyer. I'm so generous. $600,000 is enough for me. Cut it in half. He doesn't do that. No, he puts the entire fee on that. And why does he do that? He does that to create the delta for his co-conspirator to get his half of the fee split. There's no other reasonable explanation, Your Honor, particularly when you look at the entirety of the course of conduct of these two men together. So Mr. Fleming takes his fee of $600K for Nautilus and $50 for Lloyd's, and then causes that check to be made out to Forge and has it delivered ultimately to Mr. Murdaugh. That's in May of 2019. A number of months go by, and they still have money that they've retained belonging to the Satterfields. Mind you, the Satterfields don't have a dime. The Satterfields don't even know that one solitary cent has been recovered on their behalf. They don't know any of that. And over $4 million has been recovered in their behalf, and no one has told them a thing. Certainly not Mr. Fleming, whose responsibility it was. And he can't hide behind the fact that, oh, well, I was dealing with Chad Westendorf because he specifically didn't tell Chad Westendorf what to do, and he specifically participated in conspiring to put Chad Westendorf in there as PR as a patsy to keep the truth from coming out to these boys and this family. But still got money in the trust account. Mr. Fleming needs some walking around money. So January 2020, goes on down to a staffer and says, hey, cut me a check for $9,700 out of the Satterfield money from the trust account. Make it again payable to me. This time he didn't even, it's gotten so easy, he didn't even bother to try to put on their expenses for the estate or anything like that. There's just no justification. Just cut me a check out of it. $9,700. And he spent that money on personal debt. Again, if we have any illusion about what Mr. Fleming knew when he was colluding with Ellen Murdaugh, or that he really thought that this money was going to the family, despite this entire course of conduct that was specifically designed to keep them from knowing a thing, there's still money in the account. 17 months go by, Your Honor. In October of 2020. And a couple things happen. The first thing is that Mr. Fleming signs a stipulation of dismissal for the case. And do they involve the Nautilus attorney? Does he sign it? No. The only other person that signs it is Alec Murdaugh, the defendant himself. And concurrently with that, at the same time, the next day, October 6, 2020, he causes another check to be cut from his trust account, made out to the single word forge for $118,000 and has that delivered to Ellen. Now, what's interesting, Your Honor, is that when we look at that $118,000, and then actually there was still $113,000 that was remaining in his trust account when all of this stuff came to light, it totals $231,000, which in their sentencing memorandum, they admit, they attribute that to Mr. Fleming. But how in the world can they attribute that 118 in October 2020 when he disperses that to Alec to forge, and they sign that stipulation of dismissal with the defendant himself? How can he say that he knew that that forged check was bad, but not the other forged checks? The whole thing stinks to high heaven. The whole thing is done underhanded. The whole thing is done to prevent the system from knowing what was going on and to prevent this family from knowing what was going on. It was designed that way, and he was part and central to it, crucial to it from the very beginning. Mr. Fleming might try to tell you, or his counsel, that when everything came to light, he was appalled. And eventually, as everything came to light, and actually after requests were made or demands were made, disgorged his fee. Well, Your Honor, you don't get to rob a bank, run down the road, and the police catch you and say, oh, here's the money back. We're cool, right? It's not how it works. And what he didn't do was say, oh, yeah, by the way, I've been stealing checks from these accounts for almost a decade. He didn't come clean with that. It took the state grand jury to catch him red-handed for him to finally recognize that he was caught. And he could no longer claim to be, like so many other people, yet another poor, unfortunate victim of Alec Murdaugh. No, he was the co-conspirator. Your Honor, when we total up the losses attributed directly to Mr. Fleming's conduct in this case, between the Satterfields and the Pinckneys, that total was $3,725,203.85. And everything about this case and how it was done shows you that his Johnny-come-lately mitigating, I'll only admit to what, the very minimum, I'm only was doing 58 miles an hour. Everything about this course of conduct refutes that. Aside from, Your Honor, just good old plain common sense. Common sense about how this was done. Your Honor, I'd like at this time, if it's acceptable to the court, to let some of the victims address the court, and then I'll have a few more comments before I will yield to the defense presentation. And I will also request the opportunity to speak after the defense presentation to address any issues they may raise. But at this time...
Very good. Before you do that, let's all just take a moment to
yes, sir.
Stretch for a moment. Everybody take a moment.
Wow. He's done. First of all, I love, like, let's all take a moment and stretch. Judge Newman said to do it. We're going to do it. Look, she's literally. Creighton does an awesome job at speaking for the victims. That's something that I love about his style. And people, like, some people love him, some people don't like him. But one thing you can't say is that he doesn't, like he doesn't come, ready to stand up for the victims. I love that about him. Yeah, Marla, I would not want Creighton after me for any reason either. Like, I'd be like, no, I'm sorry. What happened? I'll be better.
The reporter said she was coming back last night.
He does. He's passionate.
Yeah.
He's got heart.
We've been on yesterday to come here.
He's awesome. Cory Fleming did not like that when they were talking about.
Sure.
Oh, they zoom in on the shackles. I mean, this is what happens when you steal money from people who trust you. I'm gonna get a drink. Not like a drink. We still got a lot of hours to go today, but a drink.
Okay, we'll come to order.
Thank you, Your Honor. With court's permission, I believe our first victim who would like to address the court is Mr. Tony Sackett.
Okay.
It is beautiful today. I'm gonna get the
Cam
going in a minute.
So first, I just want to say this is actually a life lesson to everyone. You know, a lot of times, we think our actions do not affect other people, but they do, bad and good.
Mr. Satterfield, if you will address your comments to me.
Oh, I'm sorry.
Yes, sir.
Second thing I'd like to say is that my answer still stands. I still forgive Mr. Fleming. And as far as the sentencing goes, that's left up to you, Your Honor. That's why, you're in this situation to give that, not myself. And the main thing, I know I'm going to get asked for what you think. How do you think it went? Me personally, my honest answer, I don't care. I just want God's name to get the glory for it. I just want, His name to be known.
All right. Thank you.
I love him.
Good morning.
First of all, I would like to say that our family, of course, was affected in a tremendous way that hurt us deeply because we not only trusted the system, we thought what was family to us. And yes, Mr. Fleming did wrong and he admitted what he done. And yes, he should be punished for what he's done. But we do forgive. As a Christian family, we believe in forgiving. But it still does not take away the hurt that he caused us. And also, we feel like Gloria did not die in vain because her case actually brought out a lot of other corruption and dishonest deeds that were done to other people. And we feel like that it is being served now. Things are coming to light that should have been brought to light a long time ago. And I want to thank the state for all the work that y'all have done to bring everything to light. And Mr. Ward, you've done a fantastic job this morning, bringing out everything and actually simplifying a lot of stuff. And thank you very much. Judge, thank you so much. We trust in you and your honor that you will make the right decision in your sentencing. And again, we do forgive Mr. Fleming.
Thank you.
Thank Gareth and Ronnie also.
Judge Newman, my name is Eric Land, and I have the honor of speaking on behalf of the Satterfields.
Yes, sir.
I also have the honor of speaking as a lawyer of 35 years on behalf of other lawyers. Lawyers who are overwhelmingly honest and do good by their clients. The license we have is a sacred trust. It's a trust that we have to help our clients. It's not a ticket or a license for us to take from our clients. And, it's natural that we want to dislike criminals. We want to dislike people like Mr. Fleming. but you're gonna hear from a courtroom of people that he's a nice guy. But unfortunately, nice guys sometimes do criminal activity. And so you have to balance today not only the sentencing of the man, but sentencing the crime. Because our profession, a profession that I love, a profession that you love and dedicated your life to, has been stained. And you understand that when things like this happen, when lawyers take money from their clients, especially in this case when it's millions and millions of dollars, that the jokes multiply by 10. I never liked lawyer jokes. I don't like people mocking lawyers. I don't like the nasty things that sometimes that people say. But one criminal activity in this type of case germinates and hurts our profession for a long, long time. Now, I think it's important that you do understand that Mr. Fleming knew exactly what he was doing. He is a plaintiff's lawyer. He has settled plaintiff cases before. And in this particular case, he worked with the party he was making a claim against. It's impossible to get your arms around that. He didn't have client permission to do that. He never had a fee agreement to do what he did with the client. We know, and Your Honor knows, the contingency fee agreements have to be in writing. There was no contingency fee agreement. There was no joint sharing agreement with Mr. Murdaugh, even though he couldn't do it to begin with, to disclose to the client. There were no disclosures at all to the client. He met Tony Satterfield as the PR one time. There never was any communication. I've been suing lawyers for probably 30 of my 35 years. I have never seen every single dollar taken from the settlement. You see sometimes that it's, a portion of it. But in this case, they took every single dollar and never communicated with Tony Satterfield, never communicated with Brian Harriet, his brother. They recovered millions of dollars. They should have been applauded for recovering that on behalf of Gloria Satterfield. You're going to hear that Mr. Fleming said he won't use the word victim like he used for the last 2 years, where he said that he was a victim just like everybody else. But you're going to hear kind of off words. They're close, maybe a first cousin of victim. You're going to say he didn't understand what was going on. Sure he did. If you're going to do a structure, Your Honor knows that you have to have insurance policies that represent that structure. Your Honor knows that when you have two beneficiaries of that structure, there would be two separate policy numbers, one for Tony, one for Brian. Your Honor knows that if you're going to send a check to the structured insurance company, you got to allocate. You can't just send a check for $2.9 million to an insurance company and not have any reference on the check that this amount is for Brian and this amount is for Tony, and it needs to be deposited in this account and applied to that insurance policy number. None of that was done. Mr. Fleming sent the check without a cover letter. No letter to forge to say, hey, this is how it's allocated. It was sent to a P.O. box in Hampton, South Carolina. Every plaintiff lawyer knows that Forge is in Columbia, South Carolina, and Atlanta, Georgia, not in some P.O. box. More importantly, the three checks that Mr. Waters described were signed on the back by Alex Murdaugh himself. It says, DBA, Alex Murdaugh, DBA Forge. Hey, that would give it away, right away, that he was not doing a regular structure. This is a case, Your Honor, that was really two letters that were sent. And, magically, $4.3 million was produced. A tremendous amount of money. Not that Gloria or any other person isn't worth that, but that is a very large settlement. A settlement that would probably be 3 times larger than most other counties in our state. And Mr. Fleming took $11,500 in expenses in a case that there was no filing fees, in a case that there was no depositions, in a case that there was no experts. He had a signed disbursement sheet in May of 2019, signed by a judge, just like you. And when you sign an order, we have to follow it. But he took that order, and he never filed it with the clerk of court. despite getting a letter from the insurance company that said, before you disperse on that check, make sure you get a signed order and file it. But what did he do? He didn't file it. What did he do? He went into the chambers of Judge Carmen Mullen down here, and he told her, look, we've made a decision to change the caption on the case. Instead of it going to be the estate of Gloria Satterfield decedent versus Alex Murdaugh, we've decided to take Mr. Murdaugh's name off the caption. No, I can't do that without your Honor's permission. But that was done without a court order. And then they took off Gloria Satterfield estate and decedent to make it look like she wasn't even dead at all. And what did they do? They came back after they got that signed order, after they told Judge Carmen Mullen, this is how we're going to disperse it. There was no reference that they were going to send $2.9 million of the $3.8 million to Forge. They were going to disperse it to Brian and Tony. What did they do? They just totally disregarded that order and started cutting checks, a check cutting party on May 14th. No court permission. You know, if I'm going to deviate from the order you signed from the disbursement sheet, I better come back before Your Honor and do that. No permission from the court was done. Nothing. No communication with these clients. This young man here, who's a vulnerable adult, who's in his 30s, lost his mother. Alex Murdaugh and Cory Fleming knew that his trailer was being foreclosed on, and he didn't have the money. And they're sitting on $4.3 million of their money while he's getting pushed down on the street and loses his mother's trailer. That was all she had. That was all she had. What happens? He keeps money in his trust account. Judge Mullen signed an order that said, you disperse every single penny in your trust account. As Mr. Woodard said, he kept it for 18 months in a case that was over with. In a case that he went before Judge Mullen and said in May, I need $105,000 of additional expenses that we spent. That's going to be dispersed. Again, in a case that no lawsuit, no depositions, no expert witnesses, and it was $105,000, not $105,172.27. It was just blatant thievery in open eyes of everybody except the two most important people that we work for, the clients. And what happens? Like Mr. Woodard said, on October 12th of 2020, 17 months later, they decide we're going to cut some more checks. And you know what? We better get this case off the docket. So Mr. Fleming and Mr. Murdaugh decide to sign a stipulation of dismissal. Mr. Murdaugh had a lawyer, John Grantland, who represented Nautilus Insurance Company. He wasn't contacted. Mr. Fleming knew that there was a lawyer involved, and they dismissed the case. Yet he sits on another $113,000 for another year, all the way up to the fall of 21, when he finally was caught, when I finally surfaced on September 7th with my partner, Ronnie Richter. Now, I will say this. Of all the defendants that we got money for, and we can announce that we've recovered more than $7.5 billion for the Satterfields from a number of sources. Mr. Fleming was the first to come forward in the fall of 21. He did disgorge himself of the $680,000. His insurance company did pay the full value of his policy. He did finally disperse the remaining $113,000 in his trust account to my clients, and there was additional monies paid by his law firm. But the last thing I want to add, Your Honor, is he fought these charges. He wrote a letter to the Georgia bar. Now, unlike our South Carolina bar proceedings, the Georgia bar proceedings are over. I was the complaining party because whenever I bring a claim against a lawyer for malfeasance or theft, it's my duty to notify the bar, and so I notified South Carolina bar and notified Georgia bar. So I'm part of the process in Georgia. They
they want to hear from the complaining party. So when Mr. Fleming filed his response to the George Barr complaint, I got it. It was a 57-page response that he did under oath. Swore to tell the truth, just like he's going to do when he stands before you today. You know what he told the George Barr? I was a victim of Alex Murdaugh's death. I had no idea what he was doing. I was duped just like everybody else. I didn't understand how to do the structure of Forge. Mr. Waters shared with you that February 2017 letter. It was crystal clear. And he had already done structures, but even if you haven't done structures, it says you can never get the check as the settling plaintiff lawyer. It's got to go from the paying insurance company to the annuity insurance company that's going to issue the structure. He already got the checks. Like Mr. Waters said, Forge doesn't get money. They're a broker. You don't send money to Forge. It goes to an insurance company. But in that 57-page response, he says, I had no idea what was going on. He didn't, you know what he said? I stole from my law partners. I didn't steal from the clients. When I stole those 3 checks of the $9,500, the $8,500, the $9,000, I was stealing from my law partners. By the way, Judge, you read the rules of professional conduct. We don't have license to steal from our law partners either. That's another no-no. So I know you're a just judge. I watched you. I've watched you your entire career. I know how much you care about what our profession. I certainly know how much you care about our state. And this whole Murdaugh, Fleming, Lafayette debacle has stained our state. And I'm going to leave with saying one thing. The hand of one is the hand of all. And Mr. Fleming is pleading guilty to every single charge, which means every single element of every single crime and every single fact that Mr. Waters has announced form the basis of those. So I ask you to do your duty, to look at this as these are state court independent charges, not to look at, well, he's been sentenced in federal court, so that kind of takes care of it. These are claims that our citizens, the state of South Carolina, brought through a grand jury, advanced with our dollars through the South Carolina Attorney General. And I'm confident that at the end, you will give that proportionate just sentence that deals with retribution to punish Mr. Fleming appropriately, but not overly so. Deterrence to tell me and every other lawyer, you cannot steal from your clients. Your duties are to your clients, not to yourself.
He's mad.
Thank you.
He's mad.
Thank you. Your Honor, I think our final victim presentation before I conclude my initial remarks comes from Mr. Bamberg, who again represents Pamela Pinckney. And I think it's important to point out that while there has been a resolution in federal court, that was only on indicted Satterfield conduct because of the statute of limitations there. And I know that Mr. Bamberg will address, of course, that we are here today for the first time for accountability as it relates to Ms. Pinckney alone. But Mr. Bamberg, I'll turn it over to you.
Thank you, Your Honor.
Yes, sir.
Creighton is correct. Attorney Waters is correct.
I love his suit.
On behalf of Ms. Pinckney, she wanted to be here, but she had a procedure on Monday, a medical procedure, and she's been dealing with a lot of pain since. So I'm here on her behalf, and that really speaks to the type of people who were victimized. We had to sit through a federal case through the United States of America's court system and hear about things that were done to the Satterfields. And Ms. Pinckney, her family supports the Satterfields. What happened to Ms. Pinckney, what Mr. Fleming did to Ms. Pinckney was mentioned in the federal case. However, due to statute of limitations, she was not able to seek justice, criminal justice through that. That's what today is for. It's her first opportunity after well over a decade. Your Honor, I want you to understand a little bit about what Ms. Pinckney went through. When we think about white-collar crime, a lot of times people talk about it as though it is victim bliss, that it just involves the almighty dollar, and that's not the case. This was a horrendous accident. Not only did Ms. Pinckney shatter most of the bones in her body, there was a very extensive recovery process for her. But she had to deal with injuries to other people that she cared about. For example, her niece, who in addition to numerous physical injuries, lost the vision of one of her eyes. And her son, Hakeem Pinckney. And Hakeem, Ms. Pinckney poured her soul into that young man. And he lost his hearing at 3 years old. He struggled with that. And she never gave up on him. She poured into him. He ended up graduating from the South Carolina School for the Deaf and Blind. And shortly after graduating, he had all these dreams and ambitions. And during that accident, that fateful day, this young man was rendered quadriplegic. He was unable to move anything below his neck. He was on a ventilator to breathe for him. He relied on an electric machine to breathe for him. And because he couldn't move, he couldn't sign language, and therefore he could not verbally communicate. And she never gave up on him. Hakeem died, and it was very tragic. His ventilator was found unplugged. So, and it's hard not to get teary-eyed when you think about what he went through, but here's a young man who cannot hear, he cannot speak, he cannot move, and now he cannot breathe, and he can't tell anybody. He became a prisoner of his own body. And Ms. Pinckney was aware that that is how her son died. And instead of being a supportive lawyer, instead of showing compassion and care, empathy or sympathy, he could have said to this woman, I am so sorry for what you went through. I want to own up to the fact that I took some of your money. No, he didn't. In fact, they took the money and they flew to the College World Series to watch baseball. Meanwhile, this woman is still recovering. She's still dealing with the loss of her son. And no one cared. And I've said this before, Ms. Pinckney, myself, the Pinckney family, everyone believed that Mr. Fleming regrets everything that he did, not just to them, but to the Satterfield family over a decade later. Nobody doubts that he regrets it. It's hard to not regret your decisions when you're sitting there. I think everybody regrets that except complete sociopaths. We do not believe that he is remorseful for what he did. And there is a difference between I regret getting caught and getting in trouble and true remorse for what I did to you. When we hear these numbers, Your Honor, and we hear numbers like $500,000, we hear numbers like $3 million, we hear about total amount of money stolen, we have to remember that where we come from, and myself, Ms. Pinckney, that I'm talking about geographically, where we live, we're $8,000 check, $9,600 check. Yes, for privileged attorneys and others who either have been very blessed, very successful, or work very hard to get there, it may not sound like a lot of money when you hear about $4 million get taken. Minimum wage in our state, Your Honor, $15,850 if you're making minimum wage. That's how much you earn working for a year. Some of the money that Ms. Pinckney lost, she would have to work over half a year to earn and then pay taxes on it. This is not a small amount of money. This is not a victimless crime. Your Honor, we trust the system. And I echo much of what Eric Bland said, that this was a black eye to attorneys. It was a black eye to the legal profession. It was a black eye to our state. But it was a dagger in the heart of the clients who trusted their lawyers. Mr. Fleming knew he wasn't supposed to do it. We firmly believe, and I've had in-depth conversations with Ms. Pinckney about this, It wasn't until the federal government came, and now there was this window of opportunity to possibly serve a sentence in federal court, that Mr. Fleming was then willing to say, yes, I did X, Y, Z. Up to that, there was no, yes, Ms. Pinckney, I took your money. That wasn't represented to the ODC ethics, as you heard Attorney Lane reference. It was deny, deny, deny. And one of the most difficult things for Ms. Pinckney and every other victim is having to know that you are truly a victim of bad acts from bad actors, and then hear those same bad actors who took bad acts say that they're a victim. It's demeaning, it reopens old wounds, and it's highly offensive. And in the world of white collar crime, Your Honor, if we talk about Wall Street, it's not necessarily people stealing your money and you willingly give it to the investment banker. No one willingly gave Cory Fleming their money. He deceived them. He took it. You know, and I know that there will be folks who will speak very positively about him. And we have no doubts that to a lot of people in his life and over the course of his life, Your Honor, he was an amazing person to them. He did do wonderful things to them. He was very giving to them. But he's not here today sitting in judgment of Your Honor for how good he was to everyone else. He's sitting in judgment for pleading guilty, element for element, charge for charge, to how bad he was to Ms. Pinckney and Satterfield. And we would ask that Your Honor take all of that into consideration. This is their one chance after over a decade to get justice, Your Honor. And we ask that this court impose a sentence that is not only sufficient to, again, punish Cory Fleming. He's got a federal sentence again, but it has nothing to do with Ms. Pinckney. He has not been punished for that. We ask that you sentence firmly to not only punish him for that, but to also deter not just lawyers, but anybody who owes a fiduciary duty and people rely on you. Don't steal from them. We're not expecting people to be perfect, but we are expecting you to be a decent human being. And if you're a lawyer and you take that oath that we all have to take, that you take that oath seriously. And it doesn't matter whether you personally have hard financial times or not. The saddest part, as an attorney who's gotten to know Ms. Pinckney, Your Honor, is knowing that even with the horrible death of her son, even with her own broken bones, her own medical bills, is that Cory Fleming needed money, Your Honor, and asked her. I guarantee you she would have gave it to him. That is the type of person Ms. Pinckney is, and that is who we victimized, Your Honor. Thank you so much for your time.
Thank you.
Your Honor, I just have a few more brief comments, and then I will yield to the defense for their presentation. Again, would request the opportunity to speak and reply after they have presented. Mr. Bamberg touched on this, and I know Your Honor has been presented a lot of letters, and I know that there's support out in the courtroom for people who have known Mr. Fleming. And I'm sorry. I'm sorry to them because they've been victimized by this too, because they have to be here. And they're put in this position. And I'm sorry that they have to go through this because I have a job to do. These people on our team have a job to do. The law enforcement officers here have a job to do. And the reality is that to be a con man, it depends on trust. It depends on reputation. It depends on the inherent credibility that comes with having a law license on your wall. It doesn't work otherwise. It depends on someone who doesn't have a prior record, which Mr. Fleming does. That's how con men work. That inherent trust and reputation is what they tread upon for this scheme. It doesn't work without all these good things that people are going to say that they believed about Mr. Fleming. It's
That's
the
a
only
good
way
point.
a con man can succeed.
That's a really
is that
good point.
People trust him. And they did. And he betrayed them.
That's a really good point.
You might hear a little bit about the process, and you may hear
Thank you, Holly.
essentially that the state, the Attorney General, the State Law Enforcement Division are being unreasonable because we refuse to accept and just check the box that Mr. Fleming was only doing 58. Instead, insisting, because of the hard work that was done by all these folks, to really dig deep and uncover the truth. The truth matters, Your Honor. The truth about what happened to the system matters. The fact that he was doing 90 miles an hour matters. It matters. It's not enough to just say, I did 58, and we say, okay, that's fine, we're done here. What really happened matters. When it affects the integrity of the system, when it was abuse of the system, of the very courtroom in which we are in right now. Your Honor, independent accountability for his abuse of his state law license and state court actions is warranted in this case. Consecutive time is warranted. Consecutive time is warranted for the extent of the reality of what Mr. Fleming did to the Satterfields, exposed in this courtroom, of 90 miles an hour. Independent accountability is warranted for that.
Jackie D gifted a membership.
Above and beyond whatever was before.
Thank you, Jackie D.
I'll give Mr. Fleming credit for pleading guilty, but he doesn't get credit for the delta, for the difference between 58 and 90 miles an hour. And his inability and refusal to admit to that, to only admitting to the most mitigating version of events that he can no longer deny because he's caught red-handed, that only should get so much credit, Your Honor. And there needs to be independent accountability for the truth of what happened to the Satterfields, above and beyond any other proceeding that has nothing to do with what happened here, or what this proceeding is. Independent accountability is warranted for Pamela Pinckney, who, as Mr. Bamberg said, has convictions relating to the conduct victimizing her in this court. And while you may hear that in another proceeding they rolled that into a PSR, that's not the same thing, and we don't even get that. I don't know what's in that thing. It doesn't matter, though. A lawyer should not get one-stop shopping for victimizing multiple clients over the course of a decade. It's not buy one, get one free. There should be independent accountability here today, consecutive accountability for Ms. Pinckney. He should not get buy one, get one free. And independent accountability is again warranted for the state judicial system itself. It must defend itself and have its own independent accountability and not allow someone when the state is unhappy with 58 miles an hour to just make a deal and that be the end of it. I ask Your Honor for consecutive sentencing. I ask Your Honor that even if you run sentencing for the Satterfields concurrent to anything else that happened, that any sentence for the Pinckneys be consecutive. I ask Your Honor not to let Mr. Fleming, who I think we have established has not completely come clean with the reality of his behavior and only admitted to what he's admitting to now because he got caught red-handed.
What is his exposure for in the Pinckney case and the Satterfield case?
Stand by, Your Honor. So the total exposure between the two is 195 years and fines up to over to $8,090,863.90 plus discretionary fines.
Stand by.
Your Honor, if we look at the Satterfield crimes, count 10 is a criminal conspiracy, which is 0 to 5. We have 3 counts of insurance fraud, $50,000 or more, which is 0 to 10, plus fines of $20,000 to $100,000. Counts 13, 17, 21, and 30 are breach of trust with fraudulent intent, $10,000 or more, which are 0 to 10, plus fine in the discretion of the court. Counts 14, 18, and 22, value of money laundering, value $100,000 or more, carry a potential sentence of up to 20 years, Your Honor, and a fine not to exceed $250,000. Counts 23, 25, and 27 are breach of trust with fraudulent intent, value $2,000 to $10,000. That's 0 to 5 plus fine in the discretion. Counts 24, 26, and 28, 3 counts of money laundering, value $300,000 to $20,000, which is 0 to 5, and/or fine not to exceed $250,000 or twice the value of the transactions. And then count 29 is computer crime, value more than $10,000, which is a 0 to 5, and/or fine not more than $50,000. Your Honor, that is the Satterfield case. For the Pinckney case, 2022 GS 4702, again, both of these indicted by the state grand jury back in early 2022. We have counts 5 and 9, which are breach of trust with fraudulent intent, $2,000 to $10,000, which are 0 to 5 plus fine in the discretion, or fine in the discretion. Counts.
It says 0 to.
No. It's Chrome every time.
$0 to 5 or fine in the discretion.
Oh, let me go to the other.
For that one, Your Honor. Count 6. Even if you run certain ones together, that there needs to be independent consecutive accountability from one to the other. And that there needs at a minimum to be a lead sentence for the Satterfields and a consecutive lead sentence for the Pinckneys. So that Mr. Fleming, for decades, almost a decade's worth of conduct, doesn't get buy one, get one free. Thank you, Your Honor.
All right. Ms. Barbier?
Thank you, Your Honor. May it please the court.
Yes, ma'am.
Your Honor is aware that on August 21st, I filed with the court an initial sentencing memorandum. And in that sentencing memorandum, laid out for Your Honor some of the background of the investigation, joint and federal investigation, and then also talked a lot about Mr. Fleming's life, his community involvement, the things that bring him to you today as a whole person to look at. And then, Your Honor, following the guilty plea, which is when we heard a lot of the same information that we heard today from Mr. Waters, on September 12th, we filed a supplemental sentencing memorandum. And in that sentencing memorandum, we addressed a few of the factual issues that we had some discrepancies with. And then yesterday, I received a response from the state. And I want to thank the state because they responded very quickly. And I think that what I gleaned from their memorandum is there's very little that we disagree with in terms of the responses they made to our sentencing memorandum. First, Your Honor, I
Debbie Long,
took
get to the
issue with
membership.
the fact that they said that Mr. Fleming had invited Mr. Satterfield into his office and changed the personal representative execution forms. I pointed out the evidence simply doesn't support that. And Mr. Waters agrees with that. And we're not saying it's material to his guilt, but we wanted to point that out because it was factually inaccurate. Secondly, Your Honor, with respect to the caption that was created on the stipulation of dismissal, the petition and the order, that was not done by Mr. Fleming. Again, that's not material to his guilt, but it's something that, I wanted to point out for the court was not accurate. Regarding the check that was written on the Pinckney settlement proceeds, the $89,000 check, Mr. Waters stated during his plea factual basis that had been made out to Ellick personally. It was not. It was made out to the Murdaugh firm at that time. Again, that's not necessarily material to his guilt, but that was a factual inaccuracy that we wanted to point out. Most importantly, Your Honor, and I appreciate the state's candidness with the court on this issue. They, right out of the gate in their sentencing memorandum said, and I'm quoting them because I don't want to misspeak on their behalf, they said the state does not allege that Fleming necessarily knew the specific particulars of Murdaugh's fake Forge account or that Murdaugh intended to steal all of the money given to him. Indeed, the state has consistently accepted that Fleming might not have expected Murdaugh to steal all of the money. And that's an important fact to Mr. Fleming, Your Honor. That's an important fact that he wants you to know. And that, again, was reiterated today by Mr. Waters in his closing argument or his fact, whatever you want to call it, that he made today. And so we appreciate those two concessions. Those are very important for Mr. Fleming to have on the public record, both for him and for his friends and supporters to understand. And so I appreciate the state's response and the prompt response of that nature. With respect to the Forge issue, Your Honor, I know that Mr. Bland and Mr. Waters have made a lot of comments about what Mr. Fleming definitely knew or should have known or did know and what he did. We pointed out in our sentencing memorandum a couple of things that I think would be good to reiterate at this time. Your Honor's heard, I'm sure, a lot about Forge from the other trial that you had and from the information in that trial that was put forth about Forge Consulting. Your Honor's probably aware that the fake Forge account was created in September of 2015, which is years before the Satterfield case came to be. The account was started at Bank of America and it was titled Alexander Murdaugh DBA Forge. The account clearly had no affiliation with the real Forge Consulting. But Mr. Murdaugh was the only authorized signer on that account. He's the only one that had access to it. He's the only one on the signature card. And unbeknownst to Mr. Fleming and to a lot of other people that Your Honor himself heard from during that murder trial, good people, people that had known Mr. Murdaugh for 40 years. And the crux of the testimony, Your Honor, and I don't have to tell you because you had front seat to that trial. But the crux of that testimony was that Mr. Murdaugh habitually lied to everyone in his personal and professional life. He lied extensively to his law partners, to his accounting department, his CFO, his family, his office manager, his banks, his creditors, his opposing counsel, to judges, and court personnel. And Your Honor, during this time period, I think it should be known, Mr. Murdaugh was the president of the Trial Lawyers Association. He was by many accounts, a respected member of the bar, and a lot of people, including Mr. Fleming, were stunned to find out that he had been stealing millions of dollars, diverting it into this fake Forge account. Ms. Seconder, I recall her testimony was that the firm had these checks being written to Forge for years out of their trust account, and they didn't know he was stealing. There were the bank statements from the fake Forge account were in Mr. Murdaugh's office. No one caught that. No one caught the fact that these checks were coming back with his individual signature on it. Mr. Fleming never saw those types of checks come through his office. You know, I cited to the testimony of Mr. Cope, a partner at the Murdaugh firm, who recounted the story of when he told Mr. Fleming about this fake Forge account and about what had transpired at the firm and about the fact that they had caught Mr. Murdaugh stealing money from the firm. And I cited to you, you know, his testimony, and the crux of his testimony was that Mr. Fleming immediately brought up the Satterfield case. He was calling him about a completely different matter. Mr. Fleming's the one who brought up the Satterfield case and said, oh my God, we had the Forge account in the Satterfield case and it was for millions. And Mr. Cope's clear impression was that Mr. Fleming was shell-shocked. And I say this, Your Honor, and I give you this information not to minimize or downplay or excuse any conduct of Mr. Fleming, okay? Because what we are here today for is a sentencing. As Your Honor knows, Mr. Fleming has pled guilty to each and every count that he's been charged with. That doesn't happen very often. He pled guilty to, you know, all of the conduct in federal court, and he's pled guilty in this court to the conduct. And so he's not here to make excuses for himself or to call himself a victim or to place the blame on anybody's shoulders other than his own. But I have to take issue with the theme of Mr. Waters' closing argument during this process here. He says that Mr. Fleming's guilty plea is the equivalent of pleading guilty to speeding at the rate of 58 miles an hour in a 55-mile zone when he's really going 90. And I have to say, with all due respect, this analogy is a gross mischaracterization of Mr. Fleming's guilty plea and the illegal conduct that he has fully acknowledged.
Amie H51,
He's pled guilty to each and every count in state and federal court, and that's a total of 24 felony counts. And that's hardly a speeding ticket. And he has not run away from his guilt in this case, not in any way whatsoever. He has, as Mr. Waters would have you believe, he's not run away. He has confronted his actions. He has stepped up to the plate. He has fully acknowledged that he was wrong, that he committed illegal acts, and that he is guilty. And he can only give this court and he can only give the government the facts as he knows them. That's it. He can't make things up about himself or other people. He can't say things that aren't true. He has acknowledged his guilt, though. And as Your Honor is aware, that is not the case in most cases. In most cases, first of all, people aren't always prosecuted in both state and federal court, even when there's concurrent jurisdiction. You know, many times one prosecuting entity defers to the other. That's generally the normal course of business. Your Honor was a prosecutor. I was a prosecutor. That happens all the time. And that's not the case here, and I'm not here to complain about that. And we're not here to complain, and we're not just here to subscribe any kind of motive to those decisions. But what I do know is this. I know that the South Carolina Attorney General's office and the United States Attorney's Office share the exact same goals. And the primary goals of those offices are, number one, to protect the public, and number two, to promote respect for the rule of law, and number three, to defer and deter future misconduct, and also, in the end, to ensure that a punishment that is sufficient but not greater than necessary is imposed. And I submit to Your Honor that all of these goals are accomplished in a concurrent sentence. No individual should be forced to serve two separate sentences for the exact same illegal conduct. And I want to address a matter that Mr. Bamberg and Mr. Waters have both raised regarding the Pinckney matter. The Pinckney matter was fully included in the state sentence, and Judge Gergel made that extremely clear. It was included in the loss calculations. They were notified under the Mandatory Victims Act. The loss amounts were included in the loss calculations. The restitution was ordered on the Pinckney case. Ms. Pinckney and Mr. Bamberg were available to speak at the sentencing. They attended all the hearings that I'm aware of, and they've been given treatment just as any other victim in federal court. So that matter has been heard, and it wasn't litigated because Mr. Fleming acknowledged his guilt in those matters. And so this idea that justice hasn't been served in that case, I find, I take issue with that because it has. I mean, you don't order restitution in a case unless there's findings made and unless they are considered victims in the case and unless that conduct was folded into the sentence created by Judge Gergel. And so, Your Honor, what I would submit is that the desire to pursue dual prosecutions it's within the discretion of these prosecuting bodies, but it also, that desire still has to be tempered by the rule of law. And justice, I would submit, is not served for South Carolinians or defendants by obtaining multiple convictions in a high-profile case and requiring a man to serve two separate sentences for the same offenses. And that, Your Honor, is consistent with the rule of law. I would submit, Your Honor, that, and there's been a lot of talk about this involves a state license and a state court system and state judges, and I don't disagree with any of that. Of course it does. I mean, that's why we're here, because Mr. Fleming has admitted guilt in that. But when you look to, who the United States Attorney's Office and the Attorney General's Office, who they serve the public. And it's not two separate publics, it is the public.
I'll give you your song in a minute. And I don't even say
it's to the citizens of South Carolina because they serve the non-citizens too. They serve everybody. And so I don't understand the division that's being tried to create here with respect to, justice can only be done here in this courtroom. Of course, this courtroom plays an integral role in serving justice. But Your Honor, I believe, understands that the role that these prosecutors have and the role that the other prosecutors have are the same. And they generally work as a team, and they generally work to the same ends, and that is to see justice served. If you look to the American Bar Association's standards on who the client of the prosecutor is, there's a section, Kathleen. And it's in a publication they put out called the Criminal Justice Standards for the Prosecution Function. And it says the client of the prosecutor is the public. And it's not any particular government agency, law enforcement officer, or unit, or witness, or victim. When investigating or prosecuting a criminal matter, the prosecutor does not represent law enforcement personnel who've worked on the matter, and such law enforcement personnel, they're not the prosecutor's clients. The client is the public for both prosecuting entities. So, Your Honor, I would submit that in these proceedings, those purposes are being served. And I don't take any issue with the representation that the Attorney General's office has made that they have been a central role in this case and that SLED's been a central role.
Because I'm tweeting.
I wouldn't dare to endeavor to do that, Your Honor. Everybody has an important role in this process, and certainly the Attorney General's office and SLED has too. And from my understanding, from all the press releases that have come out from both bodies, they have embraced the idea that this was a joint investigation and there were joint efforts by everybody involved, all the agencies involved, to bring this case to justice. And Your Honor, I would like to take some time to talk about Mr. Fleming and his life before this, his family, his community, many of whom are here today. You've got a packed courtroom. And I would submit, Your Honor, that doesn't happen every day. As Your Honor might be aware, I think that Mr. Fleming is overwhelmed, and he knows how lucky he is and how grateful he is to have the support of so many people. And contrary to what the comment Mr. Waters made, they're not here because they have to be. They're here because they want to be. They're here because they understand that Mr. Fleming made some terrible decisions. They understand that this has forever changed the course of his life, but they are forgiving and they are supportive. And I think it's a beautiful thing to see, I believe. But Your Honor, I want to take just a brief opportunity to introduce you to Mrs. Fleming. She's here. They've been married for 25 years. She's seated in the courtroom in the front room. His parents are also here. They're Caroline and Frank Koslick and Astor and Catherine Fleming.
You want them to stand so I know who you're talking about?
Sure. If you all would stand, I would appreciate it.
That's why I was smirking. I was just making smart aleck graphics to tweet.
On the far right, we have Eve Fleming. Ms. Fleming's also a member of the bar. She's a public defender here in this area and has worked with juveniles her career. And then we have Mr. Fleming and his wife, Catherine. And then we've got Caroline and Frank Koslick, Mr. Fleming's mom and stepfather. And so, not only have these friends and supporters and this family been here today, they were here. A lot of them came to his guilty plea in Williamsburg County, and a lot of them came to his federal proceedings as well. So it's a very, I can tell you Mr. Fleming is overwhelmed with gratitude for that and doesn't necessarily believe that he's deserving of it, but is extremely grateful. Mr. Fleming also has 2 children. They are not here today. One's in college, and Mr. Fleming felt that it would be better for him to continue his studies and focus on school than he came to the federal plea, and so he's not leaving school to come to this. His daughter just started a job with the Department of Defense. Oh, no, I'm sorry. I apologize. His daughter's not here today. She's overseas. She's just started a new job, just graduated from college. Mr. Fleming's very proud of her. They all are. She was at his federal plea. And so, I can tell you that the friends and supporters that he have, and we've talked about this in our sentencing memorandum, but I think that it sheds a lot of light on his unique personal history and characteristics, because this is his community and they're here for him. He's had some extraordinary good works. And so I want to take a few moments to talk about that, just to give you some additional insight. And I want to make sure, Your Honor, that I preface these comments by saying nothing that I'm going to say or that his supporters are going to say about him and about why we're here today is meant to diminish his acknowledgement of his guilt or his acknowledgement of the wrongfulness of what he did. Mr. Fleming acknowledges the seriousness of his actions. He feels nothing but remorse, and he has expressed that remorse on multiple occasions, but he specifically did it at the sentencing hearing in federal court, and he's going to do it again today, Your Honor. And I'm sorry that there are some that don't believe it's sincere remorse. I think, Your Honor can be the judge of that. I know that when Judge Gergel listened to his remarks and to the remarks of the people that spoke, he did believe that he was remorseful. And it's going to be really hard for me to talk about Cory Fleming's life and do a better job of describing him than the people who have written you letters. And I know Your Honor has received a lot of letters. People are still writing me letters. As of yesterday, I was getting new letters. They keep coming in, Your Honor, and I think that's a testament to how strongly people feel about Mr. Fleming. And a lot of these people have a different story about how Mr. Fleming has made an impact on their lives, how he helped them, how he was there for them when they were in need. They're letters that are written by people from all walks of life. Some live in this Beaufort community, and some are from far away. And some are from our older citizens, and some are from very young adults. And some are from his peer group and his former colleagues. And, these people aren't all people that know each other, but they all have stories about Mr. Fleming. And I would submit to you that there are a couple of common themes that run throughout these letters. The first observation that I had when I read these letters was that, it sort of was in keeping with the theory that I've had since I was a judicial law clerk. And that is that you can tell a lot about someone from how they treat the courthouse staff and the courthouse and the non-lawyers in our system. You've received a lot of letters from some of those people. And they talk about the Cory Fleming that they know. And those people include, a bailiff, and somebody who worked in the clerk's office, people who have worked at the solicitor's office with him, a retired state trooper and a court security officer who said that there are not enough accolades in the English language to describe his personality and character. There are several letters from people who worked as his paralegal. There's a letter from an agent with the South Carolina Department of Probation and Parole who's known Mr. Fleming for 30 years. And she describes him as, quote, a wonderful human being. She says his character, his work ethic, and behavior over the course of our personal and professional relationship has been above reproach, and his dedication to serving the community and his clients has been inspiring to witness. And, Your Honor, in addition to the courthouse, the letters that I have received from the court personnel, I've also gotten a chance to personally observe people who have interacted with Mr. Fleming when I have gone to court with him. And this is before he was in custody, obviously, and even, after he's been in custody. But there have been just a number of people who've approached me and who've approached him to just say, that they were praying for him and that they were thinking of him and had nothing but good things to say about Mr. Fleming. And so what this tells me about Mr. Fleming is that, for decades, he has treated all of the people who play a unique and important role in our court system with the utmost respect, kindness, and professionalism. And the second theme that I see emerging from these letters is that, I think you can tell a lot about a lawyer from the way he treats young lawyers. And, there are a lot of letters that Your Honor has received from people who knew Mr. Fleming when they were a young lawyer. I remember being a young lawyer. It's scary. You don't know what you're doing. It's intimidating. But many of these people talk a great deal about how Mr. Fleming would step in and help. When they were first starting, he saw them in court. He understood they didn't know how to do something. He gave them guidance. He gave them advice. He helped them through a hearing. He was never too busy to assist and offer advice. They say when they needed something, they could stop by his office. And, he was never too busy. He would take the time to introduce them to people while he was at the courthouse or at a bar function. He made them feel welcome. They also talk about Mr. Fleming's selfless acts of kindness and helping people who were in the courtroom who didn't have a lawyer because they couldn't afford one, and he helped them anyway. And, Mr. Fleming wasn't writing down these hours to try to get pro bono, lawyer hours or become, known as a pro bono lawyer. He's doing it just simply to help people that needed help. Some of the letters talk about the fact that if the bar had a fundraiser, Mr. Fleming was the first to volunteer his time, to help. The letters describe Mr. Fleming as a lawyer who would stay involved in his clients' lives. He'd help them get jobs. He lent them a car, mentored their children. The list goes on. One letter notes that he's represented the families and the victims of violent crimes free of charge many times during his career, and that he would go above and beyond to help these people through that process for no compensation, only because he knew, and having had a wife who was a public defender, he knew, what that's like, what it means to be in that system. And I do want to quote one letter, Your Honor, from one member of the bar. He said, "I do believe at worst Cory is a good and decent man who succumbed to a very unfortunate lapse of judgment for which he has already paid very dearly." So, Your Honor, I would submit to you that all of the good things that Mr. Fleming did for the legal profession in South Carolina over 29 years, you must also take that into account when fashioning your sentence. And I know that, Your Honor has been sentencing people a long time. I know that it's probably a very difficult part of your job. And I know that you take genuine care in doing this. But When you sentence someone as a whole person. And when you look at Mr. Fleming's life outside of the practice of the law, there's another theme that runs through it, and that is service to his community, service to others. Some of these letters talk about Mr. Fleming and his life as a neighbor, his life as a landlord, someone they knew from the YMCA, who he was very active in getting built in this county, his church. And you look at what they say about Mr. Fleming. They say that he's the guy that comes over at the crack of dawn on Christmas morning when your pipes are broken. He's the guy that helps you move in on the day your moving truck pulls in and then brings you dinner. They talk about the guy that helped with home improvement projects and never asked for anything in return. He's the guy that made sure you had a ride home from the hospital after you had a stroke. These are all from the letters, Your Honor. He's the guy who cried with you when he discovered that your mom had Alzheimer's and then took the time to take your mom to lunch the next day to make sure he was spending some time with her. There's somebody that some of the letters talk about a man that Mr. Fleming discovered was homeless and how he helped him find a place to live and has helped him get work. The woman who cleaned his house for years talked about how he treated her like family and invited her and her family to share holidays with them. And so, Your Honor, the stories, they go on and on about the help that in the community that Mr. Fleming has served for so many years. One of the things that stands out to me are the single parents that Mr. Fleming has helped. I mean, they talk about the fact that, he did work around their house. He spent time with their children because they didn't have a father. One woman said, who was an 18-year-old single mother when she met the Flemings, said, Cory, quote, changed the trajectory of my life, and he changed the trajectory of my 22-year-old daughter's life. He invited her to a play group, befriended her. He drove her daughter to school for 15 years, lent her a car when she needed it, invited them on fun outings, and made them feel like a part of the community. Another person that you're going to hear from today who was not at the federal sentencing, but who has come a long way to be here today is Miss Blue. She was another single mother who rented a house from the Flemings, and she's going to talk about how she was treated by Mr. Fleming in particular. The fact that when she needed help, when she couldn't make ends meet, he was there for her and didn't require her to pay rent. Which she talked about when her son got in trouble, he was there for her son. So she's here today, and she's going to address the court. Some of the other letters talk about Mr. Fleming being like a parent to many of his children's friends. There's one couple, and their children's friends were in their early 20s, and I thought this letter was so insightful, written by somebody that young. And she said, I wish that you know that Cory is so much more than this gross error of judgment. Cory is the type of person who treats strangers like friends and friends like family. I have witnessed countless examples of kindness and generosity towards others, organizations, and their families. So what I would submit to Your Honor, unlike the picture that Mr. Waters has painted for you, that Mr. Fleming was using his goodness for evil, what these letters reveal and what these people are going to tell you is that over his lifetime, Mr. Fleming has demonstrated the fundamental values that sustain a community. Another constant thing about Mr. Fleming is him as a father, him as a husband, and as a son. And in every single one of the letters, because everybody that knows Mr. Fleming knows that his family is the most important thing in his life, his family and his faith. They all describe him as a devoted family person, loving, caring, present, and someone who sets an example for other peoples in the community about his treatment of his family and his parenting skills. And, Your Honor, this is, I think, as Your Honor knows, all of these cases and in every case, whether it's white collar or whether it's, any kind of criminal case, it's always hard on the family. And, I think that if there's any solace that Mr. Fleming takes in the decision that he's had to make here, which is to own up to his guilt. It is that he's demonstrating for his children what you do when you make a mistake. You know, you step up, you own it, and you admit you were wrong. And that's what he's done. And that's what he hopes his children gets out of this. Because what he has done is try to do everything human possibly to right the wrong here. You know, you've heard from Mr. Bland that he was the first person to step up and return every bit of the legal fee that his firm took in the Satterfield matter. He's been the first person in this matter to plead guilty, period, and to own up to what he's done.
That his firm took?
I'm sorry, that was issued to his firm. The total fee, $672,000, went to Moskun and Fleming, and then it was split. So yes, that was all returned, Your Honor, in that case. But Mr. Fleming acknowledges his guilt, obviously, in the role he played in getting that fee. But Your Honor, he has stepped up, and this has been obviously a very challenging period in his life. The thing that his friends and his supporters and people know about him, though, is that they believe, and I believe, have faith that he will learn and he will grow from this experience, and he will come out of this better and stronger. And that's the point of punishment. Part of that is rehabilitation. And I would submit to you, Your Honor, that that's already started occurring. When Mr. Fleming's law license was suspended, he didn't curl up in a ball and lie in bed. Okay. He didn't, portray that he was bitter or angry at the world. What he did was started working for Habitat for Humanity. He's very skilled in construction, and he immediately began volunteering his time there because he thought it was the one thing that, he was determined to be productive and determined to be useful in his community and to do something that he could put his skills to work and help other people. And you've got a letter from somebody at Habitat for Humanity who said that Mr. Fleming brought kindness, talent, and humor to the work site. And what I would say about that, Your Honor, is that this speaks volumes about Mr. Fleming, because if you're able to bring kindness and talent and humor to others during the worst period of your life, that's something else. I would just submit to you, Your Honor, that these letters, as a whole, collectively, they're remarkable. And I've told Judge Gergel this, and I'll tell you, Mr. Fleming's never read these letters. And I didn't know these stories about Mr. Fleming until I read the letters, because he'd never told me about some of these relationships or some of the people that he'd helped through these things. But he's never read the letters because, it's very difficult for him to think about the fact of how many people he's disappointed in this case. But what we do know, Your Honor, what I know and what his family and friends know is that at the heart of this, he's a good person who made some very bad decisions. And we know that. We know from our experience that good people do make bad decisions. But I would submit to you, Your Honor, that we are all better than the worst thing that we've ever done. And I want to say it for a minute. Mr. Bland mentioned the Georgia bar and the very beginning of this process. And what Your Honor is probably aware of, having been a prosecutor, having been in the system for a long time, Mr. Fleming's not unlike 99.9% of the people that I've seen over 30 years in these situations. And he didn't fully come to terms with what he had done immediately. He admitted to some ethical violations, but he did not admit to his criminal conduct initially. But he made a decision, and it was a decision made this year, to hold himself fully accountable for his actions. And simply because, not because the as Mr. Bamberg put, the feds came and knocking. Mr. Fleming's been aware since the very beginning of this that this was a joint federal and state investigation. So the feds have always been involved. There was never any surprise there. But he decided, Your Honor, that he was going to cooperate and he was going to plead guilty. And he wasn't made any promises. He didn't receive any deals. There's no deal. You know, he pled guilty in federal court and his sentence was calculated by the sentencing guidelines. Like I said, it included both the Satterfield and the Pinckney matters. And Judge Gergel sentenced him pursuant to those guidelines. There was no variance. There was no downward departure. There was no stipulation of a sentence. He took the sentence that was within the guideline range, and he didn't know what that guideline range would be when he pled guilty, and he had no idea what would happen or transpire in state court. But at the end of the day, he made a decision to have faith in this system and to expect, like has been his experience and his wife's experience in the judicial system for a long time, that he would be treated fairly. And that's all he's asked for, Your Honor. That's all he asked for today. I would submit to you that he has accepted responsibility for his conduct. He did not put either the state or the federal government through lengthy litigation or a trial. We didn't come here today to quabble about a trial date. We came here today to fully acknowledge the illegal conduct to which he engaged. I know that I've provided Your Honor with a transcript from his federal plea. I think it's very, very clear in that proceeding, in addition to this proceeding, that he has acknowledged his illegal conduct. And not only that, that he is deeply remorseful for his actions. And he appreciates the fact that his actions have impacted innocent people. And that's the reason he pled guilty. And I will say he is extraordinarily grateful to the Pinckneys and to the Satterfields for their grace. You know, during the federal sentencing hearing, they said they forgave him. They said that again today. That's hugely meaningful to him. And I don't think they'll ever understand how meaningful that is. So we appreciate that, and we appreciate the gracious manner in which they've handled this. So, Your Honor, I would say that Mr. Fleming has suffered, and he has paid a very, very dear price in this proceeding and in the other federal proceeding that would discourage him from ever engaging in similar conduct. And I strongly believe that Mr. Fleming will serve one day as a very important person who can share his story with other lawyers as a cautionary tale, with just other people. And that in and of itself, Your Honor, will promote deterrence. I believe that the tremendous consequences that he has felt in his professional life, he has voluntarily submitted his resignations to the bar of South Carolina and of Georgia. He will never practice law again. And, you know, that is, it was a profession that, although he made some profound mistakes in, it was a profession for a long time that he loved. And so that itself is a tremendous consequence of his misconduct. Also, Your Honor, I can't not let it be said that the notoriety that has surrounded this case and the publicity that has surrounded it has itself, will serve as a significant general deterrence, but it is not something that every defendant has to deal with. You know, it has been quite, as Your Honor well knows, quite significant. Your Honor, I have some people that would like to address the court, if the court would listen to them. And I would like to call them up now if that is acceptable to Your Honor. And then Mr. Fleming also has some remarks that he would like to make to the court.
All right, we're going to break for lunch now for 1 hour and 15 minutes. It puts us about, what's that, 2:45, I guess it would be 2:45.
Oh, I'm muted still. Okay, I see y'all trying to sneak in. I see y'all. Ain't nobody sneaking. Ain't nobody sneaking. While they're doing this, we are going to we can watch our other trial. That'll give us time to hopefully finish that one before we come back and hear that while they're at lunch. But one thing I will like to say is that while okay, Cory is going to have to pay for what he did. That's what we're here for. But when the other people are talking, I want us to give them the grace that we give anybody else, because it's not their fault, and they are coming up to, speak for someone who they know a different side of him, and that is their prerogative, and they are not defending anything that he did. They are giving statement, and if they do, then we can, be like, all right, sit down. But when they come in, I just want us to be our usual loving selves and not put or direct our frustration for what he did to these victims on them. Okay. I just want to make sure that we remember that while they come back. All right. So having said that, Sheila says, yes, Mommy Brandy. I'm not trying to sound like I'm not trying to get on a soapbox or anything, but I just, how we are in here. We like to keep everything kind unless you have passed the point where, you no longer deserve that. And we get to make fun of you like we do Alex Murdaugh. So, all right. Let's see. Jamie C, actually, when we had him on the interview yesterday, we asked him about that. And the reason that he won't do it, he wants to kind of, cut Buster some slack and give him some privacy on it because of how, he hasn't been charged with anything. He's not just a typical, somebody that we see in the public eye that we can, he can, look at in that way. But also, Murdaugh's be suing. So I don't blame him for doing that. So, I am so glad too that we got to hear from Gloria's sister, and from the Satterfields in general. They are just, they've been through so much, and to have to go through so much, and I think it's, to get up there and have to speak it all on a world stage, and to use that time to show that they are giving grace and forgiveness and being better people than the people who stole from them. I think that says a lot about them and who they are. And I love that. And I think that that's inspirational. And speaking of inspirational, speaking of inspirational, while we were sitting here, I made an inspirational quote. That's why y'all were asking why I was smirking. I tried to show it for a second, but I made an inspirational quote. This is my inspirational quote. It's my daily affirmation. Don't let anyone treat you like a fake Forge account. You're a real Forge account. You're legitimate. Don't let anybody treat you like a fake Forge account. I'm going to put that on a t-shirt and I'm going to wear it to CrimeCon when I go in a couple weeks. And I'm going to go find Jim and Poot and Azari. Like, oh my God, can I take a selfie with my shirt? Yeah, I tweeted it as soon as I did it. And then everybody was like, why are you smirking, Brandy? And I was like, because I'm tweeting, just stirring up stuff. Fun times. I do think, but look, like I've said before, I can go into every trial, going into each trial or whatever, like I can go into different trials, like being neutral and, hey, let's hear the evidence, let's hear what they have to say. But, and wait and hold out and, let's not jump to conclusions, except for Thami, because I already knew too much about that because of the other ones. But I told y'all from the beginning that I'm not going to be like that with, Alex Murdaugh. When all of a sudden I had a Twitter, it was while we were already in the midst of it had just started, not, we weren't too far into it yet, but the Murdaugh trial had just started and I didn't know anybody. I didn't even have a Twitter. I mean, I had one that I had made for work like years ago because I needed stuff, but I never actually used it. And my very first tweet was a Murdaugh tweet. And then all of a sudden, I'm like fully on Twitter. So I wasn't like covering trials. I wasn't streaming. I didn't have a YouTube. I didn't even know how to work YouTube. I didn't do any of that. I mean, other than I could get to the trial to watch it and that was it. And even that I had to get like my friend on the phone to walk me through how to do it. So, like to get onto trials or whatever. But I was not like, I am not a professional reporter. I don't owe anybody like any kind of responsibility to pretend like I'm, I think maybe he's innocent because they're alleging jury tampering. No, like I don't care. Like the court reporter thing is totally separate than what he did. These are two separate issues. And I'm not going, like, there's no reason. It makes zero sense for me to like all of a sudden now, that everything's coming back up for me to like, now that I have a, platform here to just pretend like, I'm going to look at this professional. No, I'm not. I'm still going to roll my eyes and I'm still going to sit here and smirk because I'm tweeting out BS to, say what's on my mind. I'm like, I am not, it would be fake of me to all of a sudden pretend to be like, I've been through enough with the Murdaugh stuff to where I've earned my right to dislike him. And I'm going to fully take care of that right. Take advantage of it. Welcome, new member. You've been a member. How you a member again? You've been a member. Welcome back anyway.
What? Did we just become best friends? Yep.
And we had other members who became best friends too, while we were, well, I didn't want to interrupt and I didn't want to talk over it. We had, and we had an anniversary and I got my anniversary song ready. So we had, Kathleen B also became a member.
What? Did we just become best friends? Yep.
It would be fake Forge of me. It would be fake Forge of me if I pretended. Yeah. I would rather have 3 people in here who are okay with me being absolutely myself when it comes to this than to have 3 million people in here and have to water down who I am. So my eyes are going to be rolling, just so y'all know. Anything to do with Alex Murdaugh, my eyes are going to be rolling. And somebody told me the other day that I needed to calm down my sass. I was like, you don't know me, do you? No, it's not. There's no calming this down. No calm. But I warned people ahead of time. also, we have Jimmy Lawson's anniversary. I love these. And we got to play the second part too. It's our special day. It's our special day. I love that. This is like this stream deck and like these things and especially the like I am obsessed. I'm so I just want to listen. Happy anniversary. I don't remember how many months it was. It's past, but happy anniversary, Jimmy Lawson. I didn't want to interrupt and talk over the stuff, so I saved that for later so that we didn't talk over it. Keshet, I've had buttons. I've had buttons, but I just added those 2 new songs today and I was really excited, or 2 new little clips of the song and I was really excited. So fun. So fun. So fun. All right. So we have a little bit of time. So we have, let's see, we have enough time to finish this while we're waiting for them to come back for the sentencing. So we can jump into this. Lindsay Hendricks, the way that you are yourself and express your frustration with someone is why I chose to be here rather than place. I appreciate not bad mouthing, but I appreciate not bad mouthing most, but I appreciate popping off when necessary. Yeah, I can keep my cool for the most part. I mean, you're gonna see some eye rolls. Like my mama used to tell me all the time those were going to get stuck in my head like that. Like I have done it since I was little. It's who I am as a person. And it's just how I roll, or how my eyes roll. But that's not going to change. But like the only time that I really get like super sassy in the way I talk about stuff is, you know, if when I get passionate about something, it's because of like injustice, and that could be like injustice in not just a justice system injustice, but like it could be, you know, being a hypocrite or being a jerk or stealing from people or lying or being fake or, you know, fake forged or, you know, like there's so many things, and those things really frustrate me. So I'll get my sassy pants on when those things happen. And, you know, I tend to, you know, speak my mind a little bit, but I do. Yes. Kathy does. Thank you. When I can't hold back, I do mute myself. Now, if I ever accidentally hit the wrong button and don't mute myself, y'all are going to see a whole new side of Brandy, but I do a pretty good job of being able to either filter it or, you know, if I know that, like during that Travis Rudolph trial when they were victim blaming and saying that, you know, that in certain cases you deserve to be, you know, you basically ask for domestic violence. Lost my shit, lost it out the window. Could not control it, knew I couldn't control it. That was beyond eye roll. So I muted my microphone. So it happens. It happens. That's okay. All right. So we are going to get back into this, and that way we can finish this part for, oh, you know what this means? It's our special day, please. I love it. Love it. All right. I appreciate all of those. And if I missed any of the anniversaries while we were doing all that stuff, I apologize. I tried to make notes of who it was so that I wouldn't forget y'all, but I appreciate y'all being here and hanging out with us. And y'all are the best. And I appreciate all of your support. So, all right. So where we left off here, we had the first responder. What was his name? Patrick Turner. Let me pin it back up here. Patrick Turner was talking. Now, they are showing the first responder video. stuff. So obviously we can't see that. So they just keep showing him staring down like a zombie, like they have been. He doesn't move much. So a lot of it's just that. So that's why if you're just joining us and you missed this part from earlier, that's why we can't see or hear much of what they do during that part. I'll pin it.
So I'm going to give 24 minutes and 46 seconds. Who just arrived into the residence?
The Rescue 82, the ambulance, has just arrived.
I'm pinning it now.
I'm going to give 26 minutes and 2 seconds. We hear, I believe it is you that says she has a blood pressure of like 60. Was that you?
Correct, that was me.
And what does that
Got a
mean?
blood pressure of 60.
So I'm basically just giving them a rundown of our findings right now. And, you know, a blood pressure of 60 is just not sustainable for life. I've let them know that upon my assessment, I said that she's really soft all around here, meaning that she had softness to all of her entire thoracic region where it shouldn't be soft. It should be rigid with bones. She was soft. And along with, you know, with breathing for her and the pulse and blood pressure, just relaying all the information we found to them.
Thank you,
What are
Nancy.
you and the 2 paramedics doing at this point?
So now what we're doing is we're securing her to a backboard so we can move her. We don't want to just lift someone up off the ground just with all of us putting our hands on them because we don't know the full extent to all of her injuries. So for maneuverability, we place that red backboard underneath her so we can all lift her, and then we're going to place her on the gurney, and then we will secure her to the gurney.
Resuming video 26 seconds. 26 minutes and 2 seconds.
I wonder what he's looking at because he really doesn't look up at all. Okay, since we can't see this anyway and we can't hear it, I'm skipping to the parts where they talk about what's happening instead of, wait, 120. Wait, that's not it. 123.
Okay, they're gonna take her to Cedars. Does come to have anything to say?
Paramedic Austin Smith.
From the moment you arrived at the residence to the moment that paramedics took her out of the residence on a gurney,
you,
did her
Katie Pack.
critical state change at any time?
No, it did not change.
Was there any sort of improvement, in your opinion, based upon your treatment or assessment of her from the moment you first observed the victim to the time that she was taken away on the gurney?
No, she was fighting for her life.
Thank you, nothing further.
Well, that's what defense is trying to say, that she
Fireman Turner.
climbed
Good
over.
afternoon.
Thank you very much for your service. When you treated Amie Harwick, the person depicted in the videos, did you ever find that she lost pulse, a palpable pulse?
No, I don't believe she had lost her pulse completely.
If she had lost her pulse, would you have had to administer CPR?
Correct.
And you did not administer CPR.
That is correct.
Now, your unit was the first to arrive. That was an engine vehicle, correct?
Correct.
And you said on direct examination that an ambulance was not dispatched along with your engine. Is that correct?
That is correct.
Do you know why that was?
I have no idea. I believe I don't know what was said to whoever called 911 or what went down with the dispatch. So I don't know why one was not with us initially.
based on your assessment of Amie Harwick when you observed her, was it your opinion she needed a rescue ambulance immediately?
She did.
Now, you were the person who was responsible for removing her outer clothing?
I removed her outer clothing.
Yes. So you cut off whatever that pink garment was that she was wearing?
I did.
And also some boots?
Correct.
And do you recall those boots? They were knee-high boots?
Yes.
And that was in order for you to be able to observe her body in a way that permitted you to do a full assessment of her condition?
Yes.
And did you also remove any jewelry from her?
I don't believe I removed any jewelry.
Okay. And you did not apply the C-collar yourself?
I don't remember if I actually put the C-collar on her neck. I don't know if it was me that actually did it or if it was one of the firefighters.
Okay. And do you recall anybody removing any jewelry from around her neck before applying the C-collar?
No, I don't remember anything about the jewelry.
When she was, so you didn't actually transport her to Cedars?
Me personally, no.
So your involvement with her care ended at the point where the rescue ambulance arrived and carted her to the rescue ambulance for transport to Cedars?
That is correct.
It appears in watching this video that there is a very deliberate and kind of methodical approach to how each of the paramedics and EMTs that responded approached Amie Harwick and began their assessment. Would you agree with that?
Would you repeat that again?
Well, I don't see a sense of urgency in the way everybody's approaching her. So I'm asking if that like a deliberate, intentional approach to take it very slow and assess her before moving her in order not to cause further injury and because it appeared she needed to be evaluated more seriously rather than immediately just dive in and start administering aid.
I mean, we arrive and we still have to we have to gain our bearings on what's happening right now. So it may appear to look like it's a long time for you, but right now there's a bunch of things going through our heads. You know, we have to assess, you know, we have to piece together this puzzle and figure out kind of what happened and then initiate care. She looked unresponsive and dead just by looking at her from the doorway. As we step closer, it's dark outside. As we step closer, we see, okay, wait, there are some forms of life. She is like faintly breathing. And then we can't just move her over. We have to carefully move her. We have to set up the oxygen tank. We have to open up bags of equipment and we have to connect them to the oxygen and prep them. We have to take care of our own body substance isolation. So there's just a number of steps that need to happen before we can just sort of dive in and just start running around.
Okay. And so part of that was PPE you were talking about, personal protective equipment also is necessary when you're approaching a person who's in distress and in need of medical care.
Yeah.
So all of these things were were part of your deliberative effort to assess her and determine what care she was in need of at that time.
Correct.
Thank you. Nothing further.
Just briefly, do you think you were moving with a lack of urgency at the situation?
No, I don't think we moved with a lack of urgency. In fact, it was very urgent, but there's also just a limited amount that we can do.
Do you believe that you were acting appropriately as the situation called for? In other words, treating the victim who was in a critical state at the moment?
Yes, absolutely. Once we determined that she had a pulse and that she did have agonal respirations, we got the oxygen and started breathing for her.
Thank you. Nothing further.
I think based on this. Thank you. You mentioned that.
Thank you.
All right. Thank you very much.
The people call Mr. Dane Lindstrom.
So they ask a bunch of questions that really have nothing to, like, there's nothing that they have that can really add to any of this. I wish that those moments where they're asking things that don't really affect it, I wish that they could just like skip those.
If you could stuck to the witness stand, raise your right hand.
You solemnly state that the testimony you're about to give and the cause now pending before this court to be the truth, the whole truth, and nothing but the truth, so help you God? I do. Yeah, please have a seat. Please state and spell both your first and last name.
Dane Lindstrom, DaneLindstrom.
Thank you. What do you do for a living?
I'm a firefighter paramedic at the Los Angeles Fire Department.
And was that your assignment back on February 15th of 2020?
Yes.
What are your duties as a paramedic?
We respond to EMS emergencies to treat citizens and travelers to the city of LA.
And what's your background training experience that qualifies you to be a paramedic?
I have a license. I'm certified as an EMT and licensed through the state and nation as a paramedic, as an EMT paramedic.
Now, on February 15th of 2020 at around 1:54 in the morning, were you at the location of 2086 Mound Street in the city and county of Los Angeles?
I believe so, yes.
Okay. Now, why were you there on that date and time?
We were called to respond to a fall.
Now, when you received that call, did you immediately report to the scene?
Yes, we did. We were upgraded by an engine, but we were told it was up in the Hollywood Hills, so we had to back our ambulance in. So there was a little bit of delay getting to the scene. But yes, we went from the station to the scene.
And what do you mean by you were upgraded from an engine? What does that mean?
So the initial dispatch was an engine only, and I was on the ambulance that day. So an engine arrives there first on scene, and they make an assessment of what they need, whether it's an EMT ambulance or a paramedic ambulance. They felt the need for paramedics to arrive on scene, and so they radioed our dispatch to Avalon, and that was us.
And did you report to the scene alone or with somebody else?
With a partner.
And who was your partner at the time?
Austin Smith.
Now, can you describe what you observed when you arrived on scene?
Let's say cancel this.
Sure. Partner doing at the time. And when you transport that person by ambulance, where did you transport that person to?
To reconfirm, I need to check my report, but I'm pretty sure Cedars-Sinai Medical Center.
Okay. And when you
want to check your report?
Can it be thrown up in front of me just so I don't say something out?
I mean, it's
Cedars-Sinai, but if we're going to go deeper into questions.
Okay. Now, was your observation of the victim at the time you transported her, was she critical?
Yes.
Now, did you conduct an assessment of that person while in the ambulance?
Yes.
Now, you said there was somebody else with you. What was your partner doing at the time?
Exactly. So both of us would have been working on the patient if she was a critical patient.
And the reason why both of you were working on her is because she was critical?
Yes.
Now, can you talk about the assessment or your assessment of her condition while in the ambulance during transport?
Critical, but I mean, do you mean something more specific?
Yes.
Okay, are you able to differentiate critical and something else?
Sure. So it was a fall victim. So we would do what's called a trauma assessment. So I mean, we're going to do a head-to-toe assessment to see any breaks, bleeding. The big things are to take care of the ABCs: airway, breathing, and circulation. If she's not breathing, then we're going to check what's broken, what's injured, and go for a full head-to-toe to give a report to the hospital to kind of transfer care and what we can treat in the field.
Would you say your assessment in the back of an ambulance is more thorough than that of an assessment that would be done at an actual crime scene? Objection, Your Honor.
Do you know how to answer that? Can you answer that?
So we are going to assess and reassess. So when we find somebody on scene, we're going to get an initial assessment. But always once we get them back in the back of the ambulance, we're going to give a reassessment to see if we missed anything, if it's dark, if we didn't roll the patient, if they woke up, if something changed.
Did she wake up at any point?
No.
Was she unconscious the entirety of the transport from the location to Cedars-Sinai?
Yes.
And based on your head-to-toe assessment, were there any injuries that you observed on the decedent? I'm sorry, not the decedent, the victim?
Yes. Can I refer my report to with them?
No, I think that they've already been described.
Okay.
Yeah, so.
And so based on her injuries, did you observe that she had broken bones, for instance?
Objection, Your Honor. I think that beyond the ability to assess probably suspicion that.
I'm not sure that it is. I'll find out. Here, are you able to tell whether someone's bone is broken, particular bone, or what have you, just by feeling the body or what have you?
We can suspect broken bones if there's nothing popping out of the skin, but yes, we're looking for crepitus, which is grinding or popping. So we're pushing hard on bones to see if they're going to rebound or crunch or switch, I guess you could say, for lack of a better word.
All right.
And did you,
she had
scrunch on bones, I guess?
She had several regions of her body that were unstable, so that should not have been. I mean, we're squishy when they should not have been.
Is that a legal term?
No, I'm sorry. Yeah, they were unstable when they should have been stable. Would be the best.
And was this could you name a region of the body in which she was squishy, as you would call it?
Yeah, I believe her. I mean, once again, with the report, her pelvis and her ribcage were unstable.
Gotcha. Okay. Now, you said you assessed her for her airways. I believe you said breath and something else.
Airway, breathing, and circulation. Yes.
At any point, did her airways change, the condition of her airways, from the moment you picked her up to the moment you dropped her off?
So upon our arrival on scene, the engine was already breathing for her. So we were assisting respirations with a back valve mask. So we continued to assist her respirations the entire time.
Now, is there any other injuries that you were able to
Again, I can contemplate what your question's going to be based on the sidebar conversation we had. Of course, in the post, it's on objection under 352.
Okay. That's fine, Your Honor. Did her condition remain critical at the time of drop off at Cedar Sinai?
Yes.
Did you remain at Cedar Sinai?
We had to linger. For me personally, I like to look in on trauma patients to see what they do, and also I had a report to fill out. I was too busy attending the patient, so I had to do all my paperwork afterwards.
But her condition did not change whatsoever.
Upon the time we found her to when we dropped her off, no.
Thank you. Nothing further.
Question, Kennedy? All right.
Hi. It's going to be so short, I'm not going to even walk over there.
Okay.
So when you were caring for this critical patient, were you the one who actually put the seat collar on?
I don't believe so, no. I think that would have been on before we got there.
Okay. And did you remove any personal items from this individual's body? Amie Harwick was her name. Did you?
So we would have cut her clothes off. That would have been, if we're considering those personal items. We're not going to take jewelry or anything unless it gets in the way of our treatments, but we would have removed her clothes.
Okay. And would necklaces be considered something that would want to be removed prior to administering a seat collar?
Probably yes. If it gets in the way, but you can also fit a seat collar over the necklace as well.
Okay.
I love that color blue she's wearing.
And patient also had palpable pulses the entire time she was in your care.
I believe so, yes.
And if she had lost pulses, would you have administered CPR?
Yes.
Thank you.
Anything?
No, Your Honor.
All right, thank you. You missed it, Tim. Appreciate it. May Cory next witness?
I think
Roll call, Ms. Natasha Paulson.
All right.
I think we're caught up enough now to where I can make it normal speed if you want me to. If it's going too fast for you, I think we're caught up enough to where we can still finish this before lunch. So these are not real big, like aha moment witnesses that we're hearing.
You solemnly state that the testimony you're about to give and cause.
It's the first responders talking about the condition that she was in.
Please state and spell both your first and last name.
Natasha Paulson, Natasha Paulson.
She's pretty too.
Hi.
Hi.
Do you know somebody by the name of Gareth Pursehouse?
By name. Yes.
And what do you mean by name?
I mean that we haven't met in person, but we've conversed through text messages and we've spoken on the phone.
And if you could do me a favor, could you move just a little closer to the mic so that we can hear
How's
you?
that?
Better. Okay. Thank you. So could you repeat your answer so that we can hear you?
Oh, sorry. We've communicated through actually a dating app Hinge through text messages, and we had one conversation on the phone.
Let's talk about the dating app Hinge.
Okay.
Describe how it is that you met somebody by the name of Gareth Pursehouse on this app.
So the way that Hinge works is either party can contact whoever they're seeking. It's not like Bumble to where only the woman can reach out first. With Hinge, you have the ability to leave comments on photos or any of the texts that the other person has placed in their profile. And that's sort of the way to open up the conversation. And then if you're interested, you can respond back. And that's how we got started. I believe he reached out first.
Now, on this Hinge dating app, are you able to see photographs of the person that you're speaking to?
Yes.
And
I've never
did you
even heard of
see
Hinge.
Any photographs associated with the Hinge profile belonging to someone by the name of Gareth Pursehouse?
Yes, I did.
Here at this time, the people are holding what appears to be a profile picture. In the name of Gareth, be that
476 more
50.
to 10K. 476. Yeah, I know. It's always been like kind of a joke that
This photograph depicted in people's 56.
See?
And how do you recognize that?
This was his Facebook profile picture and his Hinge profile picture.
And do you see the person that's depicted in this photograph in court today?
Yes, I do.
Could you please identify that person by tell us where that person is seated and what that person is wearing?
He is the second person from the right in the front row here, wearing a navy blazer and what looks like a white polo with dark hair and glasses.
Now, I know you said that you met on Hinge. Did you initially start communicating through the application itself?
Yes, initially.
And did that communication turn into other forms of communication?
Yes, it did.
What forms of communication?
We exchanged phone numbers and started texting, and we had one phone call.
So I'm going to show, you said that you communicated on the actual app itself.
Yes.
Laura, at this time, I'm holding another page saying Gareth on the top with what appears to be an exchange of messages. Did that equals 57?
Yes.
I see what you did there, Simon.
Show you what's been marked as People's 57. Do you recognize that?
Yes, I do.
And how do you recognize that?
That is a photograph of myself on the Hinge app, and that is Gareth's response to me below.
Where it says Morticia Adams with a happy face, Aldi Gomez?
Yes.
When did you start communicating on Hinge?
Oh, I believe we matched on Tuesday the 11th, and I believe, well, I know for a fact that we started texting and we had our phone call on Tuesday the 11th of 2020.
So would you say you started communicating throughout other means aside from the application immediately after meeting on Hinge?
Yes.
And that was through text messages?
Text messaging and then one phone call.
Do you have to exchange phone numbers? In order to do that?
You do. It's for Hinge, I'm not sure if there's
Shunka Bacon gifted 5 memberships. Thank you so much, Shunka
a
Bacon.
call function through it, but we did not use that. We used our cell phones.
So you actually had to actively exchange phone numbers to do that?
Correct.
At this time, Your Honor, I'm holding another photograph of a series of text messages that marked as People's 58.
Yes.
I'm showing you what's been marked as People's
I missed her name. The pretty redhead on the stand.
50. Do you
I'll go back and
recognize
look.
that?
Natasha.
Yes, I do.
And how do you recognize that?
This was our first text exchange, and after the gotcha, I believe is when we had our first phone call.
Now I'm showing you these text messages here on the left that appear to be lighter in color. Are those text messages that you received from the defendant?
Yes, they are.
And as to the ones on the right side with a darker background, are those text messages that you sent?
Yes, they are.
And you said these are text messages that you exchanged on Tuesday, February 11th?
Correct.
Now at the top here, there's a phone number. Is that the phone number that was given to you by the defendant to communicate?
Yes, it is.
Now, was this phone number always labeled in your phone as such?
No, at one point I did change it to his name, but when I took these text messages to send in, I changed it back to the phone number.
Now, you said at some point you also exchanged a phone call on the same day that you initially exchanged text messages. Is that correct? And that was around after the time the text message you sent said, gotcha.
Correct.
Now, I also want to talk to you about further communication you had with the defendant. Did that continue past February 11th?
Yes, it did.
Why is it doing that?
And that was also through text message?
Yes, it was.
I want to talk to you about Valentine's Day of 2020, February 14th.
Okay.
Did you exchange text messages with the defendant on that day?
Yes, we did.
Here at this time, the people are holding 2 pages of a series of text messages that have been marked as People's
59.
Yes.
All right.
I'm showing you what's been marked as people's 59. Do you recognize this?
Yes, I do.
And how do you recognize this?
This
He
was
does
the part of the text message exchange that we had on Valentine's Day.
Showing you the first text message exchange here, Happy Valentine's Day. Was that received by you
Yes, it was.
from the defendant?
Correct.
And at what time?
It was at 12:02 p.m.
Now there is a text message here in blue. Hello there, apologies. It's been nonstop trying to get today's collection app in the shop so it can be purchased. How are you? Is that a text message sent by you to the defendant?
Correct.
And that was at what time?
5:55 p.m.
There's another text message. Oh, that's totally fine. Busy woman. I'm good, just also trying to get everything under the sun done. Happy face. Is this a text message you received from the defendant?
Yes, it is.
And where it says, I just finished, Lordy, is that a text message to the defendant?
Yes, it is.
Turning to the second page, do you recognize these text messages?
Yes, I do.
Are these a continuation of the messages that we were just reading?
Yes, they are.
There's a text message that reads, yippee. Is that from the defendant to you?
Yes, it is.
Now there's another message here. Watching dudes pick out last minute flowers at the market is amusing. If you catch their eye, they give you a help look and some sort of laughing emoji. Is that a text message you sent to the defendant?
Yes, it is.
And at what time was that?
10:48 p.m.
Now, did you get a response from the defendant?
Not immediately, but yes, I did.
And when did you receive that response?
February 15 at 1:57 a.m.
And that response is, ha ha, that's funny.
Correct.
Is that the last communication that you received from the defendant?
That I received, yes.
That's crazy. That was
Thank you,
not long
Your
after he left.
Good afternoon, Ms. Paulson.
Good afternoon.
You reached out to the detectives on the 17th of February of 2020, right?
Correct.
And so your communication with them was initiated by you.
Yes, it was.
You suffered a head injury, right?
That is correct.
And you lost a lot of your memories from 2020.
Yes, I did.
Sorry that happened to you. When your memory loss, was it actually amnesia? Is that how it was?
Correct, retrograde amnesia.
When did that, to what point did that affect your memories?
So the span of my amnesia begins near mid to late March of 2020.
After reaching out to the detectives on the 17th of February 2020, you had a phone call with a Detective Masterson on April 25th, 2020.
That is incorrect. I spoke with Detective Luis Carranza.
It was with Detective Carranza. Okay. And it was on the 25th of April.
Why does it keep doing that?
April 2020, right?
I actually do not remember the day that he and I spoke, but I do remember that we spoke.
Okay. That conversation was not recorded.
Not to my knowledge.
You had a meeting on the 29th of August of this year with Miss Mariano and with Detective Carranza.
That is correct.
And then that was in person, right?
Correct.
And that was also not recorded.
Not to my knowledge.
Aliens.
The timestamp.
Aliens. See?
That your testimony on direct about what time.
I have fiber internet too. My internet is so fast, so it shouldn't be doing this. Oh, it's probably on
The
Chrome.
messages were sent and received. You're relying on what the phone says, right?
I'm sorry, could you clarify your question?
Like earlier with your direct testimony with Miss Mariano, you were asked, what time a message was sent, what time a message was received. Your understanding of when a message was sent or received is based on what the timestamp is on your phone.
Yes, correct.
It wasn't like, you were sitting there, saw the message, looked at your watch.
No.
Okay. Thank you. That's great.
Any regrets?
So Ms. Paulson, I just want to be clear, any sort of amnesia you may have suffered as a result of an accident takes place after these events, is that correct?
Over a month after. I mean, the actual amnesia itself does not start until over a month after.
And when did that accident occur?
When did the accident occur?
Yes.
It was January 27th, 2021.
So after you had met the defendant on Hinge, is that correct?
Correct.
After you had a conversation with Detective Carranza regarding your interaction with the defendant on April 23rd, 2020.
Correct.
And so your memory loss that you've suffered dates from March 2020, after this incident, to what time frame?
I would say approximately maybe February-ish. The thing with amnesia and when it tapers off, it's not, the way that it's measured is not so concrete as when it as the onset, and the severity is measured by how much you've lost. So I can pinpoint at least one of my.
I'm going to swap and see if, because home does that a lot to me. So we'll see if.
Of 2020. And then it continues through to about February or March of 2021.
So after all of these events?
Yes, correct.
Thank you.
Anything?
No, you're.
All right, you may step down. Thank you.
She does. I have hair envy.
Next witness? Yes.
She's beautiful hair.
Guy Holland to the stand.
She is.
All right, Mr. Holland, if you could raise your right hand.
Do you solemnly state that the testimony you're about to give and the cause now pending before this court should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Is that a statement?
She, that text that she sent at 10:45, he texted her back like, just, oh, haha, that's so funny.
First and last name?
First name is Guy, spelled G-U-Y. Last name is Holloman, H-O-L-L-O-M-A-N.
After he left her house.
Please tell the jury what it is that you do for a living. Sure. I'm employed by the City of Los Angeles, Los Angeles Police Department Forensic Science Division as a supervising criminalist.
And can you briefly describe your education, training, and experience to be the supervisor of that particular unit?
Sure. I hold a bachelor's degree in molecular and cell biology from UC Berkeley. And I've had the required training for all of the assigned units that I've served in over the years, DNA, field investigation, as well as narcotics analysis.
How many years have you been a criminalist?
I've been with the department almost 23 years. First years as a lab tech, so almost 22 years.
And how many years as a supervisor?
This October will be 6 years.
Okay. Do you supervise, back in 2020, did you supervise criminalist Philip Nahn?
Yeah, I did.
And was he part of your unit?
Yes, sir.
And drawing your attention to the date of February 26, 2020, back then the detectives from West Bureau Homicide, specifically Detective Scott Masterson, contact you about a syringe with liquid that they wanted your unit to analyze?
He did.
And was that a syringe that's here, shown on People's Exhibit number 55, photograph B?
That is correct.
And was Philip Nunn assigned to analyze the liquid within that syringe?
He was.
Okay. And did you receive the results of the analysis?
I did.
And how about his graphs and his library searches to try to determine what was inside that liquid?
Yes.
Did you review all those documents?
Yes.
And did you find out that it tested negative for any controlled substances?
Correct.
But there appear to be other possible chemicals there.
That's correct.
Well, I have another question without getting specifics about what other substances. Go ahead. The answer stands.
You have to have a certain amount of money to be on dating apps.
Double N.
Oh, is that like sugar babies?
You reviewed
Not that one, but
these documents also as part of Mr. Nunn's analysis?
Yes, sir, I have.
Okay, and looking here at page 7, one of the possible chemicals could have been nicotine.
That is correct.
It could have also been pyridine.
Pyridine.
Pyridine, correct?
That is correct.
And did you, after you received the result that there were no controlled substances in the liquid of that syringe, what did you tell the detectives, if anything?
Well, I told the detectives that the laboratory had the capabilities of detecting controlled substances, and that for anything else contained in that evidentiary item, that he could request at another lab test for any non-controlled substances that might be in that syringe.
Like a nicotine.
Correct.
And why couldn't your lab test for nicotine?
Well, our lab is set up to detect controlled substances, and nicotine is not a controlled substance. We don't have what's called the nicotine reference standard to compare the unknown sample to. So that's why we could not confirm the presence of nicotine in that particular sample.
Nor could you confirm the other chemicals that were shown in the syringe.
That is correct.
And so did you recommend that the detectives take the liquid from that syringe and have it tested by another lab?
Yes.
And which lab did you recommend?
I mentioned the Federal Bureau of Investigation, that their laboratory might have the capabilities of confirming nicotine or non-controlled substances within the syringe.
Why did you recommend the FBI?
I knew that they possibly would test for a larger battery of chemicals that our lab was not capable of confirming.
first time he's paid
I
attention.
have nothing further on.
Thank you.
That's kind of crazy, huh?
Good afternoon, Mr. Collins.
Good afternoon, sir.
There we go. Can I just sit up here?
Here we go.
So your lab can, as in this case, can be asked to test to try to see what is in an unknown substance.
That's correct.
Just going to remove this.
It's interesting.
And
Interesting part to be.
there are specific policies and procedures that are in place for that exact situation.
Absolutely.
Yeah. And that's what happened in this case, right?
Check some vague as to what happened in this case.
A test was done for an unknown substance.
Correct.
Gas chromatography mass spectrometry, GCMS, it's an extremely reliable method for identifying compounds.
Yes.
it's something it's a really well established analytical tool for criminalists.
That is correct.
It's something that all criminalists in your lab are expected to be able to perform.
No, not necessarily. If there's training required to be able to operate the instrument properly, to maintain it properly, and to analyze the data that comes from that. So there's a training component there. Obviously, once you're trained and found competent in the use of the instrument, then you're at that point expected to be able to use it during analysis.
And GCMS has been in use in your labs in your entire professional career.
Yeah, as far as I can remember, yes.
So I'd like to talk about
I'm gonna do 1.25 for this
procedure that it appears that you actually approved it yourself. This is TM-NAU-400 GC/MS. Are you familiar with that?
I am.
And specifically on page 4, there is a sample preparation guideline for unknown substances.
Page 4 of what?
Of this procedure. This is not an exhibit, Your Honor. Or this procedure that you approved. One of the ways that you begin testing unknown
Vegas did this procedure. Vegas the time the procedure he approved when.
Well, I take, you know what he's talking about?
I'm not sure yet.
Okay,
Sort of.
go ahead.
Okay, you're familiar with this procedure that I read the name of it earlier. TM space NAU-400.
I'm familiar with it. Yes. Sir.
Yes. And this procedure is a procedure that is in place to make sure that testing is done correctly in the lab. Right?
Absolutely.
And it was in place in March of 2020.
Correct.
There is a specific section in this procedure that relates to how to, or what requirements are in place to indicate.
Right.
And what that means, indicate, is that the GCMS test would indicate the presence of a substance, right?
Correct.
So under this procedure, what happens is the sample must be compared to a spectrum of the reference material of a GCMS library or published spectrum, right?
That's correct.
And just to kind of make it less technical, what we're talking about is when a sample is tested by the GCMS instrument, it produces, the instrument produces the results of the test, right?
Correct.
And then what this is talking about is taking those results of the test and then comparing them against libraries of chemical compounds.
Yes.
Okay. And so your lab, one of the requirements is that the overall appearance of the sample spectrum must be substantially similar to the reference material spectrum, right?
Correct.
And there must be no substantial unexplained extraneous ions.
That is also correct.
So in the technical notes that the criminalist is writing as a part of the GCMS analysis, these notes are required to have, number one, the name of the library being used for comparison, right?
Correct.
And it says multiple libraries can be used. The criminalist can search through multiple libraries.
Correct.
Number two, the technical notes need to include.
Let me interrupt you. Ladies and gentlemen, let's go ahead and take a 15-minute break, if you will, please.
Before we took our break, Mr. Holloman, I was asking you about the requirements to indicate. Do you recall that?
I do.
So,
just so we're clear, we're not talking about confirming, but indicating. Yes.
Correct.
Got it.
Indicating. So the first requirement that we were talking about was for the criminalist to include in his or her technical notes the name of the library being used.
Yes.
Okay. And the next requirement is the percentage match assigned by the library.
Yes.
And it says that number should be at or above 80.
That's correct.
The last requirement for the technical notes is the spectral data provided by the library. That should be included in the notes.
Yes.
And you reviewed criminalist non's notes in this case.
I think it all be
and
like
he
that.
followed the procedure.
He did.
Okay. Now, if a criminalist in your lab follows the procedures that are in place in your lab, and a sample mass spectrum, and there's an indication based on the sample mass spectrum that there is a chemical present, there is a very high likelihood that that GCMS indication is accurate.
Objection, foundation.
I don't know. Is this something you can answer, sir?
It is, and the answer to that is not necessarily.
Okay.
Now, indication is different than identification.
That's correct.
There's a separate procedure for and requirements for identification.
Yes.
And with identification, your lab has reference, I want to make sure I get the right word, reference materials that are in-house, that are present in the lab.
That's correct.
I'm going to object as relevance 352 and beyond the scope.
Sustained. Let's move on.
I just want to make sure that it's clear what the difference is between identification and indication.
Well, okay, make that clear and then move on if you would.
So,
it's judge.
Well, let him explain it. Ask him what's the difference. If yeah, easier let him explain.
This will not take more than a couple minutes, Your Honor.
Okay, and then leave that area if you would. Go ahead.
So for identification, you have a reference sample that is present in the lab.
Correct.
And there's a lot of requirements for how you obtain that reference sample, how you maintain it, test it, a bunch of stuff, right?
Yes, sir.
Okay. And so when you have when you have a GCMS result, and you want to test it against that reference sample, you can do that in your lab.
You can.
You run the reference sample through the machine.
Vegas to which reference?
Okay, again, you said all you wanted to clarify was what was it? The indication versus what was it?
Versus identification. That's what I'm doing.
Well, no, I mean, let's just get to it. Let's not go through all these steps. Tell them what the difference is. I'll ask the question. What's the difference there? Can you explain the two differences? I don't want you to get into each step. What's the difference if you can?
Yes, sir. Gentleman was on the right track. So
Okay.
an identification or a confirmation involves the use of a reference sample or a known when compared to the unknown sample. If they match, then you can identify the unknown. In the case of an indication, there's no reference sample when it's just compared to the library of chemicals that's already in the database. That's not enough to constitute an identification. So to identify a chemical or a substance, the criminalist has to run a reference sample and compare it to the spectra or data obtained from the unknown.
Is that why your lab did not identify, did not conclude the nicotine portion of it?
That's correct, Your Honor.
Okay, great, thank you.
And your lab's inability to run that, to complete an identification doesn't take away from the reliability of the GCMS test.
Objection, argumentative.
No, I'll the answer. Sam, what was your answer?
Absolutely not.
Okay, okay.
All right.
Judge is not a
just
fan.
Very briefly, I'd like to talk about the lab where this test occurred. Your lab is the name of it is the Hertzberg Davis Forensic Science Center, right?
That's the name of the facility that we operate out of, yes.
Okay.
Or the main facility. We have a satellite facility called the Piper
right.
Technical Facility.
Yeah, sorry, I didn't mean to speak over you. The facility, the Hertzberg Davis Forensic Science Center, that's at Cal State LA, right?
Correct.
And the criminalist laboratory is comprised of 7 specialized units.
All right, let's see. That.
Break, Mr. Holloman, I was asking you about the requirements to indicate. Do you recall that?
I do.
So,
just so we're clear, we're not talking about confirming, but indicating. Yes.
Correct.
Got it.
Indicating. So the first requirement that we were talking about was
It's a lot of nothing.
For the criminalist to include in his or her technical notes the name of the library being used.
Yes.
Okay. And the next requirement is the percentage match assigned by the library.
Yes.
And it says that number should be at or above 80.
That's correct.
The last requirements for the technical notes is the spectral data provided by the library. That should be included in the notes.
Yes.
Okay. And you reviewed criminalist non's notes in this case.
I have.
And he followed the procedure.
He did.
Okay. Now, if a criminalist in your lab follows the procedures that are in place in your lab, and a sample mass spectrum, and there's an indication based on the sample mass spectrum that there is a chemical present, there is a very high likelihood that GCMS indication is accurate.
Objection, foundation.
I don't know. Is this something you can answer, sir?
It is, and the answer to that is not necessarily.
Okay.
Now, indication is different than identification.
That's correct.
There's a separate procedure for and requirements for identification.
Yes.
And with identification, your lab has reference, I want to make sure I get the right word, reference materials that are in-house, that are present in the lab.
That's correct.
I'm going to object as relevance 352 and beyond the scope.
Sustained. Let's move on.
I just want to make sure that it's clear what the difference is between identification and indication.
Well, okay, make that clear and then move on if you would.
So
Well, let him explain it. Ask him what's the difference. If, yeah, it'd be easier to let him explain.
this will not take more than a couple minutes, Your Honor.
Okay, and then leave that area if you would. Go ahead.
So for identification, you
They just
have
did
a
this.
reference sample that is present in the lab.
Correct.
And there's a lot of requirements for how you obtain that reference sample, how you maintain it, test it, a bunch of stuff, right?
Yes, sir.
Okay.
They just did
And-
this.
And so when you have when you have a GCMS result, you want to test it against that reference sample, you can do that in your lab.
You can.
Right?
You run the reference sample through the machine.
Vegas to which reference?
Okay, again, you said all you wanted to clarify was, what was it, the indication versus what was it?
Versus identification. That's what I'm doing.
Well, no, I mean, let's just get to it. Let's not go through all these steps. Tell them what the difference is. I'll ask the question. What's the difference here? Can you
They
explain the
showed
difference?
this.
I don't want you to get into each step. What's the difference here if you can?
Yes, sir.
They just showed that.
And the criminalist laboratory is comprised of 7 specialized units.
All right, let's see.
And you received training on that, right?
I have.
And you observe you observe people that you were criminalists that you were supervising sometimes when they testify.
Yes, that's part of the training.
And your testimony by an expert or a criminalist like yourself has to occur under certain parameters, right?
I'd say yes, but I'd ask you to be a little more specific if you can.
Well, for example, the ANAB, ANSI publishes best practices for testimony regarding forensic scientific results.
Objection relevance.
Allow that as foundational, and I will reserve my ruling until I hear the rest of the questions. Go ahead. You can ask. Is that a yes or no?
That is correct. One of those things is making sure that the person testifying stays within the scope of their expertise.
And this body, ANSI and ANAB, they publish best practices like that and other standards to make sure that laboratories and testimony are considered technically competent.
Objection as to other laboratories.
All right,
Foundation.
rephrase your question.
So this body, can you just explain what is ANSI and what is ANAB?
They're an accrediting body that will conduct assessments of different laboratories to make sure that they are meeting certain technical and calibration guidelines, that they're meeting certain standards.
And meeting those standards is one way for the lab to convey to criminal courts like this that testing procedures follow high standards.
Vegas to which lab I'm talking about?
You're talking about your lab, his lab?
Yes, because our lab is accredited by that body.
Right. It has the ISO /IEC 17025 and has for a long time.
Yes.
And that's the standard. It's an international standard that most labs in major countries abide by.
Objection foundation, most labs in most countries.
Sustained.
Relevant.
352, Councilman.
So you testified that you recommended sending this sample to another lab.
That's right.
To another lab that would have the reference for nicotine.
Yes. At the time, I was not sure that the FBI could do the testing, but I thought that would be a good place to try. And so I suggested that to the detective.
And you were making a suggestion for additional testing because there was this indicator that there was these substances present.
Not only that, I remember having a conversation that there was some facts derived during the investigation that substance might be contained within the syringe. So I knew that even before testing it.
Mm. Now, the indication, not the identification, the indication showed nicotine and cotinine, right?
Among others, yes.
Cotinine is what nicotine breaks down into, the metabolite.
I'm not sure.
Had you had a reference sample in your lab of nicotine, you could have run the test yourself, right?
Question calling for speculation and relevance.
I'll allow it, as essential to these criminalist training experience. If you had that sample, could you have run that yourself, or is your lab capable of having done so if you had that sample?
We could have run the nicotine drug standard, but I'm not sure if the data itself is of sufficient quality to make a confirmation. I'm not sure about that.
In other words, okay.
He's like, okay, let me just
Since
try
you
it.
did not have that reference sample present in your lab, that's why you had it sent elsewhere.
Correct.
Nothing further.
That was it. That was it.
After counsel's questions, has your opinion changed that the analysis conducted by your lab by Philip Nunn only detected the possibility of nicotine and these other chemicals?
My opinion has not changed.
Thank you.
Okay, based on that question.
When we were talking earlier about the requirements for an indication, one of them is that there is a percentage match assigned by the library that has to be at or above 80, right? If it's below 80,
Objection asked and answered.
Don't finish this question.
if it's below 80, then it wouldn't meet the requirements that are in place by your lab. Most likely wouldn't meet.
That's correct, but that doesn't necessarily mean that that indication is not valid. That percentage, because we're not confirming, it's really just a guideline, a line that we drew in the sand as we had to apply some rules to the quality of the spectra produced. But we still couldn't identify it either way. And the lab only performs an indication in special circumstances.
So
In this particular case, there were so many different substances that were indicated, it wouldn't have been scientifically useful to do an indication in this case, which is why it wasn't done.
However, the percentage match was there for the library. The percent match assigned by the library was there.
Objection asked and answered.
And nothing further.
Anything?
No.
All right, sir. Thank you, sir. Appreciate it. You can sit down. Thank you.
People call Sarah Bruxton Dickington.
They're about to come back. We got like
Please state and spell what's your first and last name.
less than 10 minutes on this.
S-A-R-A-H, Buxton de Quintana, Buxtondequintana.
I'm gonna have to go back for that one.
Ms. Dickington, can you please tell the jury what it is that you do for a living?
I'm a supervising criminalist at the Los Angeles County Medical Examiner's Office.
And can you briefly describe your education, training, and experience to perform the duties of that position?
Yes, I have a bachelor's of science in biochemistry. I have a master's of science in forensic DNA and serology, and I have worked at that office since 2004 in the laboratory and then later as supervising others.
How many years have you worked as a supervisor?
Worked as a supervisor since 2018.
And on March 6, 2020, were you a supervisor for that division?
Yes, I was.
And was an analysis conducted on a blood sample for an Amie Harwick under coroner case number 2020-01406?
Yes, there was toxicology testing performed.
And who requested this toxicology analysis?
The toxicology was requested by our deputy medical examiner, Dr. Luzzi.
So the deputy medical examiner will be the one to request what type of toxicological analysis will be conducted.
That's correct.
And what was requested by the deputy medical examiner in this case?
He requested a screen that we refer to as an H screen, and the H stands for homicide.
So the homicide screen, what does that entail?
It includes ethanol or alcohol, as well as common controlled substances, drugs of abuse, cannabinoids, marijuana, cocaine, methamphetamine, opiates, PCP, and fentanyl.
So it's alcohol, cocaine and metabolites, fentanyl, marijuana, methamphetamine, opiates like codeine and morphine, opiates like hydrocodone, hydromorphone, and phencyclidine.
Yes, that's correct.
That's fentanyl?
Phencyclidine is PCP.
PCP, I'm sorry. And what were the results? What part of, where does the sample obtained to conduct this analysis?
I'm sorry, I didn't understand the question.
Where's the sample obtained?
The sample was a sample of chest blood collected by the medical examiner.
And how was it analyzed?
The two separate analyses in this case started off the screening process. One was the ethanol analysis, and the other was the immunoassay screening for the drugs of abuse.
And what was the result of the alcohol screen? Was there any alcohol in the blood of Amie Harwick?
No, there was not. The results were negative.
How about cocaine?
No, there was no cocaine.
How about fentanyl?
No fentanyl.
How about the initial test for marijuana?
The initial test for marijuana was presumptive, but the confirmation testing that was triggered, it did not confirm, and so there was no marijuana.
And how about for methamphetamine?
There was no methamphetamine.
How about opiates like codeine or morphine?
There were no opiates such as codeine or morphine or hydrocodone or hydromorphone.
How about for PCP?
And there was no PCP.
And were you requested to test for nicotine?
No, we were not.
Were you requested to test for any poisons?
No.
And the request you indicated would come from the deputy medical examiner based on his examination.
That's correct.
And it was a report generated with these results on March 6, 2020.
Yes, there was.
And did that report become part of the autopsy report?
Yes, it did.
I have nothing further on it.
Amie. Yeah.
Good afternoon.
Good afternoon.
Is it significant in evaluating toxicology if there was a death in the hospital as opposed to the field?
Depends on the length of hospitalization, the time of the stay.
What about surgical intervention?
It could be significant if there was blood transfusions or products.
And why would blood transfusion or products be significant in making a toxicology analysis based on blood drawn after a transfusion or any type of medical intervention?
Objection, relevant to the foundation.
No, I'll allow it. You can answer.
So first of all, the transfusion could be due to blood loss and therefore loss of substances that may be present. And then transfusion could dilute and or introduce other substances if they were a significant percentage of the blood that was remaining in the now decedent.
And is there a way to try to test around medical intervention by going to the hospital that admitted an individual and asking them for blood samples that were drawn at the time that the person was received at the hospital?
Objection, foundation.
Just stay.
You
don't have to answer.
I'm sorry.
Do you know if there is a procedure by the Los Angeles County Department of Medical Examiner Coroner for requests made to hospitals when a decedent actually dies in the hospital for blood drawn prior to surgical intervention or transfusions?
No, I'm not aware.
Thank you. Nothing further.
Anything? No question. You may step down. Thank you. All right, ladies and gentlemen, we're going to break at this time. That was 7 witnesses today, so that's good. We'll see you all tomorrow at 9:30. Please don't get sick like I did, and keep wearing your masks if you do. Thank you. We'll see you tomorrow.
So, the
1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 1, 2, 1, 2. 1, 2, 3, 4, 5.
all of that testing is just over how they tested that syringe and saw that there's nicotine in it. So like all the questions that he gets, I can understand the judge kind of a little bit getting mad, even though the judge is, you know, normally the one who's not supposed to get mad. But he gets up there and he asks so many drawn out questions and none of them have any kind of relevance to anything at all. At all. But good timing. We've worked this out pretty good today. I think that that's exactly what they're trying to do. Because he's supposed to retire in like pretty soon. He said on his interview, I can't remember when he said, but I think that's what they're trying to do. They're hoping. They're hoping for a judge that doesn't know everything about Alec. Marie Moss, 1 sidebar, 6 witnesses, and 25 objections. Gosh. So many objections in that trial. What's funny, though, is that defense attorney, he will ask a question and then he'll object to to the witness answering instead of saying, you know, that's not responsive. Can you please, you know, whatever. He's like, objection, non-responsive. Like, bro, that's your witness up there. This is your turn to question that witness. It's the most bizarre thing I've ever. Most bizarre thing. So strange. He works for the public defender's office. And he does, you know, he tries. He tries. Public defenders, they have a really tough job. It is a lot of repeating, which can get really frustrating. Look, I am multitasking here, Beth Henderson. I got all the stuff going. We're covering the Murdaugh stuff. We got that caught up. We've still got today's trial for the fourth murder trial thing. Tomorrow's another busy day too. But that's why I wanted to do this like, oh, my back. That's why I wanted to do this stuff like at faster speed so we could get it all in without having to spend extra hours doing it. I don't have any extra hours right now. $25 objections. Yes. This lawyer's voice reminds me of Wags on Billionaires. I saw a little bit of that show, but I haven't watched a ton of it. Why, hello there. We are about to watch the sentencing of Cory Fleming. And he's supposed to speak. Have we seen a trial recently where they're looking for lesser charges rather than not guilty? I can't think of any. I can't think of any either. Oh, well, Shabusiness. But that's not really lesser charges. That was just NGI.
So much. I used to work up in this courthouse. Yeah. It's a great letter. Thank you.
Beth Henderson.
What? Did we just become best friends? Yep.
Welcome to the cult. You live here now. This is your life. Report every day for jury duty. Every day. Tell a friend. We're glad to have you.
It's tough. He's somebody I really care about.
Yes. I've known him a long time.
Yeah.
I've known him for law school.
You hear that? And he had one, the guy who killed his lover's husband, the one that drove cross country. I think they're talking about Cory. Hello. Hello. Welcome. Welcome. Come on in. Take a seat. I'm all about a hot mic moment.
All right, come to order. Court is in session.
Here we go. Here we go.
Thank you. You may be seated.
Ms. Barbier?
Your Honor, may it please the court, your courthouse staff was nice enough to move the microphone to this side of the courtroom. And so I'll have the people who would like to address the court come to that microphone if that is acceptable to the court.
Sure.
Okay. The first person that, I'm sorry, Mr. Fleming needs to be brought to the court.
Yeah, we need him.
They forgot him. They forgot Cory. They forgot to bring Cory in. Just standing out there waiting, shackled up waiting.
Thank you, Your Honor. As I was saying, the first speaker that I'd like to call up to the microphone is Mike McCloskey.
Mike McCloskey. What movie is that? It's the movie. Monsters, Inc.
Good afternoon, Judge. My name is Mike McCloskey. I'm privileged to practice law in this community for 57 years. I'm also privileged to call myself a trial lawyer. I've known Cory Fleming since he first started practicing law. However, I've known his family literally since the first day I moved to Beaufort, and that was March the 3rd of 1967. I was at the hearing when Judge Gergel sentenced Cory Fleming. It was a remarkable proceeding. And the thing that made it remarkable was Cory Fleming. I remember Ms. Pinckney telling Cory that she still loved him and that she forgave him. And I never will forget his response. I don't know how many criminal cases I've handled. I don't know how many times people who had either gone to trial and who were waiting sentence. I just don't know. But I've never heard anyone, after being forgiven, respond by thanking her and then following closely thereafter. And I understand you have a transcript of that proceeding, and I invite you to see if I'm correct in my recitation. Immediately thereafter, Cory Fleming said words I've never heard from anyone in his position. I don't deserve to be forgiven. I do not deserve to be forgiven. I've never seen a man empty himself to that extent. He was thoroughly disgusted. He admitted his behavior was a betrayal of trust that was placed in him. He admitted that he had disgraced his family. He admitted that he had dishonored his friends, his profession, his family. That's the Cory I saw a little over a month, no, a little less than a month ago. That proceeding was on the 15th of last month. A little less than last month. Well, why would that be important? I've heard a lot of negative stuff about Cory Fleming. And there's no one here, his family, his friends, anybody that's here to support Cory, that supports his conduct that brought him in front of you today. They didn't support it in front of Judge Gergel on the 15th of August. However, they realize that there is great wisdom in a little piece of scripture found in the 51st Psalm, which is David's great lament after Nathan brought to his attention his great sin. A broken and contrite heart, O Lord, you will not despise. We cannot embrace Cory's conduct, but I'll tell you what all of us do embrace. We embrace Cory in his broken and contrite state. And to what purpose would we do that? Why would we do something like that? Because we see a goodness in Cory that has been covered up, but is coming to fruition now. There's been a lot of discussion about sentencing and the bad acts, rightly so, that Cory has committed. But I'm reminded that human nature and human behavior can change. Well, what is the most powerful vehicle to change human behavior and nature? It's adversity. It's struggle. We don't have our kids grow up healthy by giving them cream and ice cream all the time, cake and ice cream all the time. We subject them to adversity. Now, this adversity is brought on by Cory himself. I wonder how many of us can claim that our conduct has been so pure, so innocent, that we haven't had the chance to grow up through adversity. No, we can't excuse, justify, or defend the events that brings Cory in front of you today. But we're not going to leave him. We're going to actively participate in his restoration in this community, his recovery, his healing. And through that, I hope that the court will find some assurance that through this period of adversity in Cory's life, he will grow, change forever for the better. I thank you for the opportunity of appearing before you in behalf of my friend, Cory Fleming.
I hope that he does grow and
Your
change.
Honor, next, Shannon Wilkes would like to address the court.
Good afternoon, Judge. I met Cory and Eve in 1998 when I moved to Beaufort. I needed a job, and I was a young paralegal at the time, and I began to work for Cory as his paralegal, and I did so for 2.5 years. Cory was a relatively new attorney, and like I said, I was a new paralegal, but through working together, and Cory still reminds me of this today, we learned a lot from each other. We had a positive and open working relationship where he treated me like a colleague and not just his paralegal or someone who worked for him. I worked with him. Cory always treated me and his clients with respect, compassion, and kindness. I have witnessed many times firsthand the love and devotion that Cory has for his wife, Eve, his children, his parents, his extended family, and his friends. One evening during a dark and desperate time in my life, and Cory probably doesn't even remember that he did this for me, I knocked on the front door of Cory and Eve's home. When Cory opened that door, he saw me not just as his paralegal, but a friend in need. Neither one hesitated to let me in that door and give me a shoulder to cry on. I'm here today as a supporter of Cory. Being a supporter of Cory does not mean that I don't understand that he made bad choices, because I do understand. And being a supporter of Cory does not make me a victim of anything. I am proud to stand here today, and I'm proud to see that Cory has taken responsibility of his bad choices. And these are choices that he cannot change, but he can choose how to face the effects of the choices he's made now and in the future. And I believe Cory is already doing that by taking responsibility and truly being remorseful, because he is remorseful. He and I have talked on numerous occasions and have discussed our mutual Christian faith. We've shared scripture, we've shared prayer, and lessons learned from this scripture. And I know through this faith, Cory will live a full life, a life full of purpose. And he has a willingness to help others find their own purpose. Thank you, Judge, for letting me speak. And I ask that you take the words that I've said into consideration in Cory's sentencing today.
Your Honor, next we have Rich Chiavella.
Good afternoon, Your Honor. My name is Rich Chiavello. Thank you for the opportunity to give me this chance to speak on behalf of my friend Cory Fleming. I met Cory 22 years ago when we both became new parents. A couple of years later, we both welcomed our second child, our children. Over the years, my family and I became very close friends with Cory, his parents, his wife, his children. We spent many holidays, birthdays, and weekends together. He's the last person that I ever thought I'd be standing here talking to you about today. I've only known Cory to be a loving son, husband, father, and friend. I believe Cory to be a good man who made a bad choice.
Choices.
I also believe that when he returns to his family and friends, he will dedicate his life to earn the respect, trust, and admiration of all who come to know him. Your Honor, I ask that you show Cory as much leniency and mercy as the court will allow. Thank you.
Your Honor, there are several people that were here earlier who had to go. They didn't know it was going to last this long and had commitments and a very critical doctor appointment. And they left me their statements, and I'd like to read them if I could.
Are they the same ones that you emailed to me or had me to read before?
There are, Your Honor, there's one statement from a person who's also written a letter, Kevin Green, and he says much of the same things. So if Your Honor wants to simply rely on the letter.
No, you submitted them all to me to read, and I've read them, and so I don't need you to read them again if you've already done
It's
that.
not the same letter.
Oh, another from the same person?
It's the same person.
Okay.
Okay. And, but I just wanted the court to know that there were a few other people. In addition, Your Honor, I have Miss Denise Davis.
Your Honor, I'm grateful for the opportunity to speak on behalf of my friend Cory Fleming. I've had the privilege of knowing Cory since 2009, and I'm eager to share my insights about his character and the positive impact he has had with my family and our community. I first met Cory at the YMCA, where our shared passion for competitive running and physical fitness brought us together. Over the years, we participated in numerous local running events, forging a strong bond based on our shared interests and values. I've had the opportunity to witness firsthand Cory's dedication to the YMCA. For the past 8 years, I have overseen the YMCA's River Swim, a signature fundraiser for our Learn to Swim program. Cory, alongside his daughter, participated in the challenging 3.2-mile swim. And when I approached him for sponsorship and support of the worthy cause, he didn't hesitate. In addition to our YMCA swim, I could always count on Cory to sponsor and actively participate in a running event I chaired for the Parents Association of my son's school. He generously extended beyond financial contributions. He consistently went out of his way to help others. I can personally attest to this. I'm a single mother to 3 sons. There have been times, excuse me, when I relied on Cory's expertise to fix various household issues. He never hesitated to lend a hand. One vivid example is when my outdoor shower pipe froze and started spraying water everywhere on Christmas morning. Despite the holiday festivities, Cory was there to help at a moment's notice and without hesitation. Moreover, Cory's unwavering commitment to his family is truly commendable. I've had the privilege of not only being friends with Cory, but also developing a close bond with his family. During my own challenging times, Cory and his family extended their kindness to me without hesitation. Their support and empathy served as a beacon of light through my moments of difficulty. Cory has been a guiding figure in the lives of my sons. He's been a mentor, providing them with support, advice, and empathetic ear when they needed someone to confide in. His genuine care and interest in their well-being have made him a beloved figure in our home, and we often refer to him as Uncle Cory, despite not being related by blood. Cory's character is one of generosity, acts of kindness, and a strong sense of responsibility towards his family, friends, and community. He has consistently demonstrated his commitment to making a positive impact and his contributions have left a lasting mark on the lives of many, especially my family. I respectfully request that you consider my testimony when determining Cory's sentence. I firmly believe that his actions and genuine goodwill he has shown throughout the years are a testament to his character. I kindly ask you for your leniency, mercy, and grace in this matter. I believe Cory's positive qualities should be weighed during the sentencing process. Thank you, Judge Newman, for allowing me to speak on behalf of my friends.
Next, Your Honor, is Lisa O'Brien.
Good afternoon, Judge. I am Lisa O'Brien, and I'm a Beaufort resident, born and raised here. I met Cory and his wife and children at the Y. I taught spin there for about 16 years, and he and his family actively participated in my classes. In 2011, our oldest son was brutally attacked and beaten and robbed in his home in the middle of the night here in Port Royal. I didn't ask for help, but Cory knew my anguish. He saw it on my face, and he approached me outside after class and told me that he and his wife would do anything to help us through this process. Even though the prosecutor would take control, he would be there for us. He spent countless hours talking to us over the phone and in person and just helping us to understand what we were going to face. I've stood in one of these courtrooms at least 5 times as the mother of a victim. Each time Cory has put himself out to be there for our family without anything asked or without any bragging or patting himself on the back for being a good person. In one of my conversations with Cory at the Y, he told me that one of the hardest things he had to do was to stand in the courtroom while people that didn't have an attorney didn't know what to say, when he could easily go up there and help them. And every day it was hard for him. And there's one more thing I want to mention. When all of this happened, we moved upstate a couple of years ago. And when all of this happened, I came down and I wanted to go into one of the classes and see my old friends. And I asked Cory if he was going to be there, and he showed up. And I told him, I said, you know, I'm not going to ask you anything about these things. I don't want you to feel pressured to ever be around us. And he stopped me in my tracks and he said, no, I have learned from this already things about myself I didn't even realize I needed to know. The remorse was clear, and his actions to stop me and tell me that he had guilt are something I can't even explain. I didn't ask him, and he just told me. I think what I want to say most is I'm here on my own accord. I drove 3.5 hours to come. I don't feel obligated. I don't feel like I have to be here. And certainly I'm not forced to be here. I would stand up for Cory in a minute, and Eve and his family, because one thing in somebody's life that happens a couple of times does not define them. He is more, the whole picture of who he is more than this. And this is terrible, but this does not define him. And I just ask for you to consider that.
He's got the snot nose like Alex.
There were 5 assailants, and they were apprehended the night of the crime. They were caught by Detective Rue, and it took about 2 years to prosecute. They did all plead guilty.
How much time, what was their sentence?
It ranged from 15 years to 20 years for all 5.
15 years to 20 years each.
Yes, sir. Well, each person was sentenced with a concurrent. So they were charged with 3 things: burglary in the first degree, armed robbery, and possession of a weapon during a violent crime. The burglary first degree was 20 years for one individual, and the armed robbery 20, and 5 for the weapon. And that process matched each person down the line.
How old were they?
They ranged in ages from 23 was the oldest person. The youngest one was about a month from turning 17.
And what year was that?
2011.
Are they still in prison?
Yes, sir. The first one will be released next year.
All right. Thank you.
You're welcome.
Your Honor, next we have Laura Blue.
Good afternoon, Your Honor. My name is Laura Blue. From 13 years being in the Beaufort area, a citizen of Beaufort, South Carolina. I've known Cory as being my landlord. It's just so much I could say about this man. I have 2 children. We were homeless, living in a hotel. It was during Christmas time. We were transitioning from the hotel to the residence in which he was allowing me to rent. And when I went into the home, so much I can say about this man. He immediately shared with me that I didn't have to do the first month rent and make sure I get my kids some toys for Christmas. My son was 7, my daughter was 9. We've been in the home 13 years. My son graduated from Beaufort High School. He's now in the United States Navy. I have a 22-year-old daughter. She is currently the business manager at St. Helena in Port Royal. I have a 4-year-old grandchild that actually came into the home while we were there. I would say from landlord to family, that's how we look at him. Both of my children looks at him very highly as an uncle. He's very respected by both of them. In spite of what's going on, we talked. I've relocated to Missouri, so I flew in to speak on who he is to us as a family. My daughter spoke at the federal.
This makes me really sad for her.
And I will say this, Judge. During this time, while I was in Missouri, Cory and I text, talk, try to encourage him plenty nights through texting and sending scriptures to let him know that in the Bible, God forgive us of all our sins. He asked me when I came down and visit my family here, if it was possible to just come by his home. He needed to share something with me. In spite of the media, in spite of people around me, he called me, him and his wife, went to the home. He talked with me, he shared things. He didn't go in depth or anything. He just let me know. He did something, he was very sorry about it. He just couldn't get over the hump of understanding that he has to forgive himself. I will tell you today, Judge, on behalf of my family, we truly, truly, by no means, look at him more than just my landlord. Again, he's my family. I rest assured his family has supported me tremendously. They didn't ask me to come. They didn't beg me to. I asked them, can I please come? can I please every day, what can we do? Because again, like I say, this man took my family in, put a roof over my head with 2 children. And he made sure not one day, if I was late, he overcharged me. Not one day he made an eviction notice or anything. And I've been late many of times. Yet he let us stay in the home. He was ready to renovate the home right before my son was graduating. And I was working for Department of Social Service inside Child Protective Service as an investigator, not making much money. And I told him, I said, Mr. Fleming, if we leave, where could we possibly go for the next 3 months until my son graduated? He said, you know what, you guys stay here. And when he graduates, then we'll go ahead and start the renovation of the home. So I just ask that you just take into consideration what I said about this man. Thank you, Your Honor.
Your Honor, I'm not going to read the statements because we do have letters from Kevin Green, Jay Taylor, and Tom Miller, all who were here earlier but had to go. But at this time, I'd like my client to address the court.
Okay.
Here we go. I feel really bad for the people who spoke for him. I do. To care about somebody and then find that out is going to be difficult.
Your Honor, excuse me. Thank you for the opportunity to address this court. For many years, I stood in this very courtroom representing people. Many of those people had broken the law. I was very aware that one bad decision or a series of bad decisions can have life-changing and irreversible consequences. Despite knowing this firsthand, I made some terrible decisions and I broke the law. Today, I offer this court no excuses.
Good. Good for him.
There are no excuses.
Good for him.
I place the blame for my actions on my shoulders, nobody else's.
Good for him.
I never imagined standing here and being in this circumstance. I have a profound and deep disappointment in myself. It is a very difficult and constant feeling that I will carry with me for the rest of my life. Today, I'm grateful for the ability to thank the Satterfields and the Pinckneys for expressing their forgiveness to me when I was sentenced in federal court and for letting me know that they're praying for me. It means the world to me. It is helping me through a very difficult time. Although I've already made these remarks in federal court, I want this court to know my regrets, my failings, and my heart. And I don't think I can say how sorry I am too much to any of these people. So I'll say these words again to the Satterfield family. Your mother was a very good woman. In the aftermath of losing her so tragically, suddenly, you deserved a lawyer that had only your best interest at heart. You deserve someone to be honest with you. You deserve someone who talked with you. You deserve someone who dealt with you fairly. And you deserve someone who would not betray your trust. I did not do those things. I failed you.
Good for him.
Michelle Pinckney, I not only betrayed you as a client, I betrayed you as a friend. You suffered a tremendous loss that no parent should ever endure. You and your entire family were good to me. I have no words for how empty I feel when I think of how you must feel about me. You deserved much better. I failed you and I failed your family. To both the Satterfields and the Pinckneys, for these failures, I am immensely sorry. I know that an apology is inadequate, but please know that I am genuinely incredibly sorry for my treatment of you. Next, I want to apologize to my former colleagues in the South Carolina Bar, South Carolina Supreme Court, the Office of Disciplinary Counsel. My actions have cast a negative perception on the legal profession. I understand that the public's confidence in our judicial system has eroded as a result of this case. I am deeply sorry that my actions have negatively impacted a profession that I loved and people that I care deeply for. I have permanently resigned from the South Carolina Bar because I no longer deserve the privilege of practicing amongst you. I want to apologize to my former law partners and staff. I know that my actions have caused a tremendous amount of stress, burden, and heartache on each one of you. I'm truly sorry for the pain I've caused. I'm sorry to my friends and members of the Beaufort community that I have let down. I love Beaufort. I've always considered myself lucky to live amongst this community. And I'm extremely grateful for those who've stood up for me and offered kind words that were very much needed. To my wife, my children, and my parents, I will spend the rest of my life regretting the shame and the turmoil that I've inflicted on our family. Each of you have been a tremendous source of support to me during the past 2 years. I don't feel that I deserve it, but I promise you that I will strive every day to earn back your respect and be worthy of your love. Thank you for standing by me during this very dark time. I love you so much. Your Honor, I know that I deserve to be punished for my conduct. I take full responsibility for my actions. I can assure this court that I will live the rest of my days trying to follow the lessons that I've learned, to remember what is actually important in life, time spent with my family and my friends. To know that doing things for others is how to gain fulfillment out of life. It does not come through material possessions. A lot of people have spoken to me, my friends and community, about what I've lost in this ordeal, but I'm looking at all that I've gained. I've had to take a very hard look in the mirror. I didn't like everything that I saw. I've grown from this both spiritually and emotionally. I've taken stock in my life and realized how lucky I am. I'm incredibly grateful for my wife, my children, my family, my friends, for their support and love. I believe there were times in my life when I took these people for granted, but I'm looking at life through a new lens. When I decided to plead guilty in federal court, I didn't have any assurances of what my sentence would be there or here. I made a conscious decision to have trust in the legal system, one that I betrayed. I betrayed this system, and I am perhaps undeserving of that. I understand how difficult your role in this process is, and I sincerely thank you for the opportunity to address your court and for considering the information presented on my behalf.
Your Honor, in conclusion, I just like to make a very, very brief remarks. I all reports the time that you spent with us today, allowing us to speak and allowing the people that want to come and talk on Cory's behalf to be heard.
As I said, I know Your Honor has a very difficult job in this process, and I have always observed firsthand the dignity that you treat defendants with. I would respectfully submit to you, Your Honor, that in this case, a concurrent 46-month sentence is sufficient punishment and will protect the public. It will serve as a deterrent. I believe there's already been a significant deterrent effect, but I think the sentence here will serve that purpose as well. Mr. Fleming has accepted responsibility for his bad decisions and his illegal conduct. In the process of calculating his federal sentence, there's an enhancement called abuse of position of trust. And this was calculated in to Mr. Fleming's sentencing guidelines, and he was held accountable for the abuse of position of trust. So that's what he did. He abused his position of trust and abused his law license, and he's taken full accountability for that. You have heard about his worst days, and I hope you will also know that those bad decisions do not define his life. One of the things the court always considers in these matters is whether or not somebody has a criminal history. Mr. Fleming had no criminal history prior to this case. He has made, I would submit, significant efforts already at rehabilitation, and he's going to continue to do that as he serves his sentences. He has expressed extreme remorse. He only seeks a chance, Your Honor, to serve his time and then rebuild his life. And while to be able to be released from prison and still have time to contribute to society. Your Honor, in conclusion, I would submit that a 46-month concurrent sentence will encompass all of the illegal conduct to which he has acknowledged, including the Pinckney case, which I discussed was already considered. The Pinckneys were victims in the federal case. Their loss amount was calculated, their restitution was ordered, and they were treated under the Mandatory Victims Act. But a 46-month concurrent sentence will reflect the seriousness of this offense. It will promote respect for the law, and it will provide just punishment. And I thank you again, Your Honor, for all of your consideration and for you taking the time to hear us today.
Thank you, Your Honor. I know this has been a long proceeding, and I'm not going to talk for a long time. Abuse of a position of trust. Your Honor was asking one of the people that spoke on behalf of Mr. Fleming about those terrible crimes that happened to that person and the ages of those people. And we don't know now what their lives were like, their backgrounds were like, the opportunities they had, the privileges they had. And there was very significant accountability for that, for those young men, and rightfully so. But there has to be significant accountability here too. One thing you didn't hear a lot about, Your Honor, was the facts of what Mr. Fleming, even to this point, actually claimed. What we know is that when he first got called by Lee Coe, he said, oh, the Satterfields, but he didn't disclose, oh, I was colluding with Alec, oh, I'd stolen checks, oh, I'd been stealing from Miss Pinckney prior to that. He didn't disclose any of that. In fact, for the longest time, he claimed he was a victim. And then when the state grand jury called him red-handed, he then changed and started to say, out of the generosity of who I am, I cut my fee in half. And so if I did steal, they still were better off than they would have been if I'd taken my full fee. Ms. Barbier read from our memo, and she left out one clause about what the state's position is. And that clause is that what Fleming didn't realize, because he knew that the scheme as usual depended on some significant portion of the funds going to the family so that that sleight of hand works. They're too focused on this right here to know that this is going on behind them. And what Mr. Fleming, when finally pushed against the wall, his final version that went to federal court with, essentially this, Your Honor, that every single one of those forged checks that he cut from his trust account, the $403,000 one, the $2.9 million one, and the $118,000 one, that he believed that Alec, that those boys, that the Satterfield family was going to get every dime of that. And the only thing he was willing to concede once he had finally been pushed against the wall time after time and revelation after revelation was that he had withheld that $105,000 in fake prosecution expenses for Alec. And the interesting thing about that is that for you to accept that to be true, what his version is that Alec never even came and got that. Because as we know, there was $113,000 still in his trust account when everything came to light. So what he is trying to admit is that, yes, I colluded with Alec Murdaugh, but I didn't think that he had gotten one thin dime of that money. And when the state, and she made some discussions about one agency deferring to another, and she mentioned press releases. And of course, as always, when the state grand jury first indicted Mr. Murdaugh and others, that's going back in November of 2021. You know, in a press release, we're going to thank supporting agencies, but she's had those transcripts. She's read the extensive testimony that we presented from the witnesses in the state grand jury in November of 21, and December of 21, and January of 22, and February of 22, and March of 22, April of 22, and on and on. She's read the information about her client that was gathered by state grand jury subpoenas during that time. And when Mr. Fleming sat down and told that story, that I believed that every dime was going to those Satterfield family, that when I was at my dirtiest, my motives were the most pure. That because I had cut my fee in half, even if I'd stolen money, they were still going to be better off than they would have been. And the state said, that makes no sense. And it makes no sense for all that I've detailed for you here today. That course of conduct that shows that he knew what was going on, he was instrumental in it. And so when he talks about accepting responsibility, he's not accepting true responsibility. And that is why there needs to be accountability in state court. That is why that when the state said, hold on, Mr. Fleming, that doesn't fit with the facts. That doesn't fit with common sense. That doesn't fit with all we know about how this went down. Mr. Fleming, and we said, give us some more information, give us some more time. Mr. Fleming instead went down the street and made a deal to just bypass accountability in this courtroom, which this is where the affront occurred. Ms. Barbier went in great detail, and Mr. Fleming said it too, about how he pled guilty in federal court with no deals. No deals. And he talks about how the Pinckneys were considered in the pre-sentencing report, which of course the state doesn't have. We don't know what was in that. But what he leaves out when they make this great presentation to you, how they pled with no deals, and therefore that's enough. Just let the feds handle it. We just thumbed our nose at the state, thumbed our nose at our obligations in the agreement we signed, and went down the street. What he leaves out is that he was allowed to plead to a single lesser offense, one charge, 0 to 5 years. If you had done one charge of what it should have been, that's a 20-year offense. And even Judge Gergel in the plea transcript on page 75,
it's true,
when they were trying to say, well, there's no deals, we didn't do a substantial or a downward departure, says, well, in some ways, you've already given him a 5K, which is a downward departure motion, by allowing him to plead to the less serious offense. One charge for 0 to 5 years is not enough, Your Honor. It's not enough for the reasons that I expressed to you. It's not enough because of the difference between what was admitted to in federal court and what we have exposed here today. It's not enough because of the difference that Today is where there's the first real accountability, a real conviction for Pamela Pinckney. And it's not enough because the state judicial system needs its say for those who abuse it. I said before, a lawyer should not have a decade of conduct and get one-stop shop. For that reason, we submit there should be a lead sentence for the Satterfields and a consecutive lead sentence for the Pinkeys. Thank you, Your Honor.
Thank you.
All right, here we go.
Well, I guess we've been here listening to argument and presentations concerning this, goodness, about 4 hours or more. And prior to that time, I was submitted voluminous materials to review. The one thing that I did not review is Judge Gergel's transcript. As much as I admire him and his capabilities as a federal judge and the great work that he does, I don't defer to the federal court system for in making my decisions. I practiced law for 24 years and have been a judge for 23 years. During my time as a prosecutor, I've prosecuted police chiefs, probation officers, professors, and as a judge, I've sentenced church secretaries, preachers, professors, law enforcement folks. But until I came down to this 14th Circuit in March, I never sentenced a lawyer. And that lawyer was sentenced to consecutive life sentences. Now I have a lawyer, co-defendant, colleague of his, facing 195 years in prison. In addition to dealing with and sentencing all those folks, I've certainly dealt with my share of grand larceny cases, people who might steal an automobile, facing 10 years in prison, a shoplifter who, after the third offense, is facing 10 years in prison. And I've had my share of sentencing people like the assailants who were convicted of the crimes that was mentioned, and dished out a lot of time to many of them. So this is my second time in these 47 years having to deal with an issue of sentencing a lawyer. And I cannot imagine a more devastating, anything more precedent. This is unprecedented. This is unimaginable. This is, I think, the greatest crime for a lawyer in the history of the state of South Carolina. Certainly in the number of years being faced and the impact of the crimes on the citizens of the state. I cannot imagine anyone going to a lawyer in South Carolina at this moment in time and having complete trust in what that lawyer says to them. And of course, part of my years of practice, I've had clients come to me with, and they come and said that they didn't know how much money they got on their case, that they went to the lawyer's office and the check was turned over and they just was asked to sign the check. So they came to me to find out how much money they got in their case.
Wow.
But this is totally unprecedented. I cannot, there's no way there was a case in this state where the amount of thievery exceeded what's occurred in this case. Now the presentations on behalf of Mr. Fleming were certainly inspiring. Reminded me of the revival that we had at our church last week. Reminded me of funeral services that I've had to attend, particularly within the last year. And I've heard a lot of testimonies, so much so that they can go on and on in churches, at a funeral. And so we ask people to limit their comments to 2 minutes because everyone has so many good things to say. And most folks reminded me of what was said in federal court, sort of a disregard to the dual sovereignty of the state court. I didn't read Judge Gergel's transcript. He's in a different system, a different sovereignty. I've never deferred to a federal court to guide my sentence as a state court judge. Now, for all of the great things that said about Mr. Fleming, and I made the funeral reference because it's as if he's no longer with us, as if we're at a funeral, and that he will not have an opportunity to redeem himself. He will not have an opportunity to do good deeds. And someone mentioned that the things that he was able to share his tale with others, well, he'll have an opportunity to share his tale and his story and the consequences of his choices with people that he will meet that will be in dire need of his counsel and advice. Now, since coming here for Murdaugh and doing that trial in March, and I was back here 2 weeks ago for another trial in Colleton County. A mother who had been teacher of the year in the school system there left her 13-year-old totally handicapped and disabled child in a car beginning at 11 a.m. when it was 91 degrees outside, and left that child in the car until about 5 or 6 p.m.
Christina.
And she was constantly in and around the car with her boyfriend.
We love Christina.
Climatologists testify that the temperature in that car got up to 139 degrees. And you're talking about remorse, and the testimonies and presentations over this mother and her mistake. She was on methamphetamine with her boyfriend. as remorseful. I cannot imagine anyone giving me a presentation of a mother who loved her child and who went wayward and more concerned about using drugs and pleasing her boyfriend than caring for her child. And she got 37 years in prison, convicted of murder. Well, it was 2 weeks ago here in the same 14th Circuit. And the folks who came to talk with him and said, you know, she loved her child. She would nothing she wouldn't do for her child. She had her child in the Special Olympics, but she abandoned the child. And so when I'm listening to Mr. Bamberg talk about Mr. Pinckney, Hakeem Pinckney, I'm thinking of that same type of vulnerability that child had. He was a child at the time, wasn't he?
He was late teen, I believe, Your Honor.
And so he placed his trust in a respected member of the bar, a very respected member of this community. And I could tell that by all of the folks here. You know, sometimes say that there isn't very much between any of us. We all have good and we all have bad. And certainly everyone was here to tell me about all the good in Mr. Fleming, but we're dealing with the consequences of the bad, and that is as bad as it gets in this case for a lawyer who has a prior record. He has no prior convictions, but when you carry on a scheme of over a decade, that's a record. Record that did not result in charges or convictions, but a record of his life. And as bad as it was with Mr. Pinckney, then we moved to the Satterfields. Again, vulnerable people. So I imagine, and I know that many of the friends and family and colleagues were totally shocked, not at what the good Cory Fleming has done over a period of time, but this Cory Fleming in these cases. And quite frankly, when the people come to me and wanted to lay the burden on me, said, Judge, please be lenient. That's not my responsibility. You know, I believe in justice and mercy, but leniency is not part of Micah, the scripture. Facing 195 years in prison. Anything else before I impose my sentence?
I'm going to say, Your Honor.
All right, Mr. Fleming, if you'd come around for sentencing.
Here we go.
My heart bleeds for you because I have no doubt of the quality of human being that you are, as reflected by all of the positive comments. But you must suffer the consequences of your actions in these cases that you're standing before me for. And tempering justice with mercy. It's my responsibility to impose a sentence. And there are so many. If I were to spend time here now imposing a sentence on each of these indictments individually, we'd be here for a few hours probably. So suffice it to say, with regard to the Satterfields, and need my clerk here to take notes for me. On count 10, where the exposure is 0 to 5, the sentence is 5 years. I wrote insurance. Is that insurance fraud?
Yes, sir.
That is count number or indictment number.
Count 11, Your Honor.
Count 11. On the exposure is 0 to 10. The sentence is 10 years. On the breach of trust with the 10-year possibility or exposure, the sentence is 10 years. On the money laundering, where the exposure is 0 to 20 years, the sentence is 10 years. On the 5-year breach of trust, sentence is 5 years. On the 5-year money laundering, I believe it is, it's 5 years. And on the computer crime, sentence is 5 years. And each of those will run concurrent with each other.
Concurrent.
As to the breach of trust involving the Pinckneys, counts 5 and 9, is it?
Yes, sir.
Where the exposure is 5 years, the sentence is 5 years. The 30-day breach of trust, count 6, the sentence is time served. On the conspiracy charge, sentence is 5 years. On the breach of trust, where the exposure is 10 years, the sentence is 10 years. And that sentence will run consecutive to the sentence that you're currently serving. All the sentences otherwise will run concurrent with each other. I'm going to defer any restitution hearings. I believe it's just too convoluted for me to get a true handle on what the state is seeking and what should be ordered. And I tend to think that it's, well, I don't want to prejudge whether it's necessary or not, but I'm going to defer any ruling regarding any restitution. I'm not sure whether the state is actually seeking it, whether there's an actual loss, if there is, whether the parties can agree. We can have a separate hearing solely dealing with restitution if necessary. As sentence of the court, best wishes, Mr. Fleming.
Thank you, sir. Thank you.
So I need to take time to work with all this. Were you following everything? You want to put the years on them? Yeah. Anything further here today, Mr. Waters?
No, sir. That would conclude the state grand jury matters for today, Your Honor.
All right, court will be adjourned.
Okay, so the first group, let me mute this. It doesn't sound like we're gonna have any hot mic moments.
Thank you.
Maybe a hot mic moment. No hot mic moment. All right, so the first group of indictments, there was a 5-year, 10-year, 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 5-year. All right. Sorry, I got distracted. First group of indictments, 5-year, 10-year, 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 5-year, 5-year, and 5-year. So those first 7 were all to be served concurrently. Then he had the second, like the Pinckney charges, there was a 5-year, and then one of the count was time served. And then the conspiracy was 5 years. And then the breach of trust, 10 years. That's consecutive to the current sentence. So he's got 10 years and then 10 years. No, I did not even notice the yellow tie. All right, hold on. Let me pull up my notes. I made notes and now I'm trying to remember, let me pull up my stuff because I'm trying to say it on memory. Well, let me get out of this. Let me get out of this. Let me get out of this. Let's see. Oh, nope. Hold on. The first, my phone is blowing up. First, now I can't read my typing. First, hold on. Let me pull it back up because I was typing it as we went, and then I just lost everything I had just done. I just lost everything I had done. Oh, that sucks. Okay, well, that's a whole lot of work gone that I didn't save. That sucks.
After the third offense, they're facing 10 years in prison. And as a judge, sentenced church secretaries, preachers, professors, law enforcement folks.
Wait, how do you Control Z will bring everything back? Oh, hallelujah. Oh, hallelujah. Y'all are my heroes. Y'all are my heroes. Oh, okay. I had notes from my podcast and from the trial that we watched before this one and from all this other stuff. And it did not, I went to a new screen and then I went back to the old screen and it was all gone. And you can see how red my face is because I thought I just lost all of that. Okay. All right. Y'all saved me. Okay. Let's see. So here we go. Yeah,
My heart bleeds for you because
I clicked save now.
No doubt of the quality of here for a few hours probably.
All right, here we go.
So suffice it to say, with regard to the Satterfields.
No, I'm not reading chat. If you have any idea how much it takes to run all this, I try.
Take notes for me. On count 10, where the
I have a lot of them.
exposure is 0 to 5, the sentence is 5 years.
All right, so count 10, the sentence is 5 years.
I wrote insurance. Is that insurance fraud?
Yes, sir.
That is count number or indictment number.
Y'all, I didn't even have a YouTube until
11,
January. So
and the exposure is 0 to 10. The sentence is 10 years.
okay, the second one, the sentence is 10 years. Now what happened? What just happened? Everything moved. I'm about to give up on
Exposure is 0 to 10. The sentence is 10 years. My clerk here will take notes for me.
it. Started over, and I don't know why. I'm just having all kinds of problems.
10.
This is started over. It was 5 years for this one.
Where the exposure is 0 to 5, the sentence is 5 years.
Okay, for the first one, 5 years.
I wrote insurance. Is that insurance?
Not touching
fraud?
anything else.
Yes, sir.
That is count number or indictment number.
Count 11, Your Honor.
Count 11. And the exposure is 0 to 10. The sentence is 10 years. On the breach of trust with the 10-year possibility or exposure, the sentence is 10 years. On the money laundering, where the exposure is 0 to 20 years, the sentence is 10 years. On the 5-year breach of trust, the sentence is 5 years. On the 5-year money laundering, I believe it is 5 years. And on the computer crime, sentence is 5 years. And each of those will run concurrent with each other.
Each concurrent with each other. Okay, so I said that right.
As to the breach of trust involving the Pinckneys, counts 5 and 9, is it?
Yes, sir.
Where the exposure is 5 years, the sentence is 5 years. The 30-day breach of trust, count 6, the sentence is time served. On the conspiracy charge, sentence is 5 years. On the breach of trust, where the exposure is 10 years, the sentence is 10 years. And that sentence will run consecutive to the sentence that you're currently serving.
Okay,
All the
consecutive.
sentences otherwise will run concurrent with each other. I'm going to defer any restitution hearings. I believe it's just too convoluted for me to get a true handle on what the state is seeking and what should be ordered. And I tend to think that it's, well, I don't want to prejudge whether it's necessary or not, but I'm going to defer any ruling regarding any restitution. I'm not sure whether the state is actually seeking it, whether there's an actual loss. If there is, whether the parties can agree. We can have a separate hearing solely dealing with restitution if necessary. As Senator of the court, best wishes, Mr. Fleming.
Thank you, sir.
All right. So, so what did I get wrong? Because the first group of them are each to run concurrent with each other. And then he's got the second group that 10-year is the longest on that. Consecutive. So why am I wrong? What am I missing? He's got a 4-year, well, minus 2 months. He's got basically a 4-year sentence. This is supposed to be for after the this is after the federal charges. I didn't come here to math. Okay. Y'all are confusing me. Hold on. Y'all are confusing me because look at Lucy. Look at this. Look at this. Lucy didn't come here to math either. She came here to like just snack and live her best life. I need to fix up her little area. Look at her. She is so funny. So what am I getting wrong? Because y'all are confusing me now. He said everything consecutive to I understood it as y'all are giving me a headache. Ain't none of us come here to math and look at everybody math and different. See, it's so this is how I understood it. And so and some of y'all are saying I'm wrong. So I might be, I don't, but the way that he worded it to me sounded like all of those first sentences, like that first group of indictments that he went over, he said that those were all going to be, he specifically said concurrent with each other. And then the highest of that was 10. So you can like just disregard all of the extras, but the highest was 10. So if they're concurrent, then 10 is 10. And then the second stuff he talked about, the 10 was the highest. And he said that one would be consecutive. So how is that? So how is that not 20 years? Somebody get a lawyer on the phone. Terry, thank you. 5-year for Pickney, 5-year for Pickneys, and 10-year for Pickneys, all consecutive. So 20. Okay, so if it is hold on, we're going to do a poll. Don't anybody look it up. Nobody leave this room right now, or you're all cheaters. Start a poll. How did you interpret that sentencing? $20. What was the other answer? 14 years. We have a 17 years. And this is hilarious. We're going to do a poll. Don't nobody go look it up, you cheaters. Do it exactly how you interpreted what he said. This is exactly how I thought, and then I'm getting told I'm wrong. So there's so many answers. Oh, it's so funny. Team 24. I have switched to Team 24. A 10. Where did 10 come from? I didn't give an I don't know button, but I gave a I didn't come here to math button. This is so funny. You know, it's funny, Brooklyn. I even thought about that. He said that women shouldn't be allowed to vote, and now I'll get comments that we shouldn't be allowed to math either. That's so funny. News is reporting 20. Most of y'all are saying 20. This is so funny. So I'm reading what y'all are writing, and so I understand why some of you have different answers, but it's not what I heard at all. So it's just funny to see everybody interpreting that so differently. Just say, Lucy, ate your homework. What did I hear? I heard him say, because he specifically said that first group that he read out were going to be concurrent with each other. And then the second group that he read out, he said that would be consecutive to the current sentence. He asked, wait, where'd that go? He asked the clerk if she was keeping track. Kansas Sunshine DJ. Thank you for the super chat. Thank you for the super chat. Now his clerk is confused. That's so funny. All right, let me look it up. I want to see what other people are saying. See, this person's saying that he got 70 years. This person says 10. This person says his current sentence plus 10. Everybody's trying to see how many different sentences there are right now that are. Common Core math not allowed. Yeah, everybody's even talking about, I wish they would be more clear about the sentencing because everybody's arguing over it. That's so funny. All right. Allie B, Tizzy, can I send you a link that clears this up? Sure. Sure. I don't think anything can clear it up, but sure. Go ahead. Go ahead. Thank you. Thank you. Thank y'all both. Thank you so much. $1 for each year. Thank you, Terry. Oh, I didn't do the cha-ching on that one. Thank you so much. Yeah, send me link or whatever, but that's funny. That's because the way I understood that is that he is, because Judge Newman is sentencing. These are the state sentences. So the way I understood it is a 20-year state sentence. That's the way I understood it. Because the other was federal. It's totally different. All right, let's see. Here's the link. All right. So this is from Posted Courier. Beaufort ex-attorney Cory Fleming gets 20-year sentence for helping Alex Murdaugh steal. Newman handed down 2 back-to-back 10-year sentences. And then his time in federal lockup is expected to count toward his 20-year term. So 20 years. 20 years Celsius or Fahrenheit? Oh, that's so funny. I can pull court documents when it comes, you know, when it gets filed if y'all want me to, but to me, it's the way I heard it was 20. What does the poll say? Let's see what the poll says. Okay, so the majority said 56% of you said 20 years. Here, let me end it. 56% said 20 years. 26% say I didn't come here to math. 15% of you said 14 years. And 2% said 17 years. 20 years Eastern stability or Central time. Yeah, that's it. That's how that worked. All right. Let me get this set up. All right, I'm getting us. I've created a separate stream for the paint dry trial. So I'm about to portal us on over there. Let me make sure it's set up. And I'm going to take a 5-minute in between so y'all can, it'll portal you over to chat so you can chat, but I'm going to take Lucy out real quick. And then we're going to watch paint dry. Not fresh paint, wet paint. Wet paint is allowed. Don't call it fresh. Mods will time you out. And then we'll have a mistrial. This is so funny. I love this chat. Y'all make my life so much happier and fuller and funnier. All right. Wendy says, y'all, my therapist is literally calling me. I'll need her. Yes. Yes. Oh, yes.
It's been 84 years.
Problem solved. It was 84 years. Duh. Duh. Oh my gosh. So funny. When did we put that one in there? Where did 84 years come from? Oh, Melly trial. Melly trial. Oh gosh, all those. Oh, Melly trial. Oh, Melly trial. All right. So I am going to end this stream. I am going to send you over to the next stream, and Tommy. I'm going to send y'all over to the next stream. Keep your hands and feet and ponytails inside. I am portaling you over to watch paint dry. Today is day 2 of paint dry, so we're going to get some of that in. I had no idea the Murdaugh hearing was going to take this long. I thought this was going to be a pretty quick thing, but we did get to watch our 2 hours that we had of the other sex therapist thing, and then and we got to watch all this. So crazy day so far. So we're about to go watch paint dry for a little bit, and then and try to get caught up on that, or at least as caught up as we can. You cannot say fresh paint, Jamie C. Mods will time you out. No fresh paint. It is not fresh paint. It is, you can say wet paint. You can say paint that has not filmed yet, but you cannot under any circumstances say fresh. I'll see y'all over there.